Good morning, good morning, good morning. It's day 6 and the final day, question mark, of the Sarah Boone trial. We should be getting to closing arguments today. This morning is going to start with the jury instruction conference. They're not going to finish it because we're going to have to do more jury instructions because the big fight in jury instructions is going to be over that self-defense instruction we heard them talking about yesterday. But the state only has text messages left to admit. I don't think we're going to end up getting any rebuttal from the defense. It would be unusual if we did. So here's what I think will happen today, and then we'll see at the end of the day if we were close. They're going to do the charging conference in the morning. They started quite late because Sarah Boone was not present in court. So even though the attorneys are there, there's nothing they can do until Sarah Boone's in court on the record. So they were there but could not start, waiting for Sarah Boone. Then we're going to get into the jury instructions conference. Then it seems like we'll get into the rest of the state's case, which is just text messages. The state will rest their rebuttal. Then the jury's going to have to go out while they finish arguing jury instructions. I imagine then they will take lunch and then we will get to closing arguments. But if they Zoom this morning, we might not get to lunch. They might just start closing. Remember, for closing arguments, the state bears the burden. So the state goes first, then the defense, then the state has a rebuttal. We'll see what those closing arguments will bring. This jury's going to get the case today. How long they have to deliberate, how long it takes them to deliberate will become the question of the afternoon, won't it? So I think we should just go to court. I'm ready at this point. I'm like, okay, it's Friday. They started last week on Friday. Are we almost done? So I'm going to just roll the intro.
Bring the jury.
We're going to bring the jury. Are you guys ready? I'm ready. We're ready. Let's just go to court. That's what we want to do.
Hey there, I'm Emily D. Baker, the internet's go-to legal analyst, breaking down the legal side of the pop culture and entertainment stories we can't stop talking about. I'm a big fan of the cursey words. I've been a licensed attorney for over 17 years, but this is not legal advice. This is where the law nerds unite to talk about facts, not... Let's get into it.
All right, we're going to have to bring the jury. But first,
give me a moment.
Charging conference.
Then it was.
This is right at the beginning.
Hang on. Let me make sure.
36F separate red lines, 36G separate red lines, 8.9 culpable negligence red lines separates.
I'm going to put them at 1.25 unless we have a problem with it, because they are all pretty clear. And if we get to any substantial arguments, then I will slow them down.
Then it was what was sent at 11:31 yesterday.
That 34-page document I have.
Okay.
Regicant, I hope I got that somewhat close, said, I need your legal explanation on some of this. Don't worry, we'll get there. Oh, all the kids are there today. That's, by kids, I mean law students. All of the trial ad students, or the mock trial team, seem to be there. Jury instructions are the most important part of the case, to me, because what you tell the jury the law is impacts how they determine the case. So they need to know what the law is, and it needs to be clear. We have seen, or at least it is my opinion, that in the Karen Reed case, the jury instructions were super confusing. I'm going to zoom past them fighting over how the email attachments got sent.
Possible that you don't have your track changes are off, and maybe that's why.
They're trying to figure out, they have different red lines of the instructions. The defense has a proposed version, the state has a proposed version, and then the judge will go through and make sure that the changes are all in one jury instruction sheet. So right now they're trying to figure out how the defense sent theirs and why one of them is like 30 something pages and one of them is 40 something pages or whatever. So we need clear instructions.
Word under review.
All right. So then the clerk's printing them out. I watched a little of this before I hopped in the shower so that we could zoom through the downtime. Because you know how much we love to zoom. I always did jury instructions, but again, this was a minute ago, did jury instructions on paper because it was easier for my brain to track jury instructions on paper and to make notes on them. I think if I had had an iPad, I could write on.
Both parties have.
Or like my Remarkable, I would have done it that way.
Document, which includes the defense's red line with regard
I
to
can't do
proposed
it
jury instructions.
visually
We'll
on
start page 1 of
screen.
34. Instruction 3.1, introduction to final instructions. Any objection to the form of this instruction, State?
No, Your Honor.
Defense?
No, Your Honor.
So
Moving to
these are
page
standard
2 of 34,
instructions.
Instruction 3.2, statement of the charge. State?
No objection.
Defense?
No objection.
Moving to page 3 of 34, 7.1, introduction to homicide. 3 paragraphs. Any objection?
No objection from the State.
The number and the name
Moving to
identifies the
next
jury
portion,
instruction.
Justifiable homicide in the singular paragraph. Any objection, State?
No objection.
Defense?
No objection.
Moving to excusable homicide and the 4 paragraphs, including paragraphs numbered 1, 2, and 3. State?
No objection. I have no objection to anything I submitted to the court.
Okay, thank you. Defense?
Obviously.
Moving to page 434, 7.4, second-degree murder instruction. Defense, any objection?
So the second degree murder instruction is the definition of the charge. We'll see if this is also where they put the lesser included crimes. Lesser includeds are not charged crimes. So Sarah Boone is charged with second degree murder. But within second degree murder, there can be other things, and those other things can also be an option to the jury. So if you're like, okay, well, second degree murder, we don't agree with, but we might agree with manslaughter, that's what we're going, I think, here, if they put them with the charge, which is what they normally do.
Objection to the form of the instruction.
No objection.
And also the removal of the lesser included chart on page 5 of 34, correct?
Correct.
Moving to page 6 of 34, instruction 3.4, when there are lesser included crimes or attempts.
So there will be lesser somewhere.
My only question is,
No
if I
attempt.
understand from the defense, they're looking
Attempt plays into, well, when someone survives. There no attempts here. That's your attempted murder charges. So that's going to be removed from the jury
to
instructions.
see culpable negligence is a lesser included.
Yes, Your Honor.
Would that not need to be included here?
Yes, Your Honor.
Okay, so is the only addition to this, the balance of the 3.4 instruction would be correct with the exception of the last sentence, which would read, the lesser crimes, plural, indicated in the definition of second degree murder is manslaughter and followed by culpable negligence.
Yes,
So as Dr. B walked in with coffee, they're getting to two lesser
State.
includeds?
State objects. There's no evidence to support a misdemeanor culpable negligence.
Misdemeanor? Okay, we're going to slow this back down. A misdemeanor culpable negligence. Oh, we are on normal. Okay, so the defense is arguing for the manslaughter and a misdemeanor culpable negligence to be given as a lesser included, and the state is like, no.
Plural, indicated in the definition of second degree murder.
For those of you that are in our international audience, hi, I know it's the middle of the night for a lot of you. Misdemeanor charges are less than the felony charges and can only be sentenced to a maximum of 1 year in jail. So a misdemeanor crime generally doesn't, if they carry jail time, they carry minimal amounts of jail time, 30 days, 90 days. And then they cover some probationary terms. Misdemeanors are significantly less than felonies. When you're looking at felonies, she's charged with a second degree murder, which means the floor on that charge is 22 and a half years. The maximum on that charge is life. The manslaughter, the maximum is 15 years. A misdemeanor, the maximum would be 1 year, and then fines and fees and probation.
Murder is manslaughter and followed by culpable negligence.
And yes, she has been in custody for 4 years. So if she was convicted of a misdemeanor, there was no additional time they could give her. And no, there would be no repercussion she could take for being in custody for 4 years, even though she was only convicted of a misdemeanor. Just to answer all those questions at once.
Yes, so it should go to R. Yes.
State?
State objects. There's no evidence to support a misdemeanor culpable negligence lesser included offense for a category 2 lesser to be included in the jury instructions. Both must be supported by the charging instrument as well as the evidence in the case. There is no evidence in this case that he only suffered culpable negligence. The crime for culpable negligence with death is manslaughter. culpable negligence isn't even a category 1 lesser of manslaughter, it's a category 2 lesser, which includes, by inference, there must be some evidence that her culpable negligence did not result in death.
What's your response to that?
Misdemeanor. The thing is, the jury won't know it's a misdemeanor. The jury won't hear that at all. They'll just have, the jury won't know about the sentencing. The jury won't know if it's a felony or a misdemeanor. The jury will just know the elements of the crime. So they won't know that the way all of us went.
Judge, the
What?
instruction that we're asking for is 8.9. It reads to prove the crime of culpable negligence. The state must prove the following two elements beyond a reasonable doubt. 1, Sarah Boone exposed Jorge Torres Jr. to personal injury.
Yup.
And 2, she did so through culpable negligence. As to the fact that
If those are the two elements, I can see how they're lesser included. She did cause injury to Jorge Torres, and that injury, culpable negligence, is part of the instruction for manslaughter. I mean, I can see why they're arguing it. If those are the instructions, I can see why they are asking for that. That fits with the manslaughter definition as well.
there is evidence of culpable negligence as to the case, in the fact that Ms. Boone, while Mr. Torres is still in the suitcase, goes upstairs.
It's the whole
As
case.
to it being charged, it's a category 2 lesser included that's available to the defense. Defense can get category 2 lesser included offenses as long as there's evidence to support the category 2. And there is evidence in this case to support the category 2 lesser included. That's
And-
why we're asking.
Any other further argument, Mr. J?
No, Your Honor, thank you.
Okay, all right. At this point in time, the court is inclined to include the culpable negligence as a
Okay.
lesser included. We'll get to the instruction momentarily. Any other revisions to the 3.4 instruction, defense?
No, Your Honor.
Moving now to 7.7 manslaughter, there are some objections. The defense is now objecting to paragraph 2C, the death of Jorge Torres was caused by the culpable negligence of Sarah Boone.
Right, culpable negligence.
So how
in
can
the
you ask
manslaughter.
for a culpable negligence instruction and then object to 2C in the manslaughter instruction? Logically having trouble understanding that.
Yeah, that doesn't make any sense, Your Honor. You're 100% right. So what just happened is that the judge said, defense, you can't take the culpable negligence language out of the manslaughter instruction when you just argued for a misdemeanor culpable negligence. What are you doing? Please explain why you're doing that. So we're now getting into the language of the instruction for manslaughter.
Because this is my argument, because I'm not arguing that there isn't evidence of it, because I just said there's evidence of culpable negligence.
Uh-huh.
The difference is, and I think the burden is different from the state, because it's not alleged in their information.
Does not the instructions
Neither's a misdemeanor. No, neither of those are alleged in the charging document, and they don't have to be. It has to conform to the charging document, meaning it actually has to be a lesser included, and to proof in the case. That's it.
say give 2A, 2B, and or 2C depending upon allegations and proof?
And proof.
Yes, the allegations would be the information.
And proof is the evidence at trial.
Any response, Mr. J?
Judge, it's a category 1 lesser. All the theories are included in that. The language does not need to be included in the charging instrument. And quite frankly, it's not inconsistent with the language in the charging instrument. She's accused of having a depraved mind when killing him, and what the evidence has also shown is that she was heavily intoxicated when she made this decision. That supports a conclusion for a prior fact to reach that this was out of culpable negligence. And if they reject our argument that it was done knowingly and out of patriotism, spite, etc.
Then the misdemeanor, or then the
Any other
manslaughter
arguments,
is
sir?
appropriate.
No other argument.
I don't think the misdemeanor is appropriate. The manslaughter is appropriate.
At this point in time, the court is going to overrule the defense's objection as to the objection to 2C in the manslaughter instruction, including the final two paragraphs of what the definition of culpable negligence is on the bottom of page 7 of 34. It seems like it's stipulated between the parties that 2B, Sarah Boone intentionally procured an act that caused the death of George Boone, should be Jorge Torres, is not applicable. Is that correct, State? Is that correct, defense? Okay, thank you. And also, since 2B is not applicable, the to procure definition will not be provided. Any other questions regarding the 7.7 instruction?
No, sir.
No, Your Honor.
No objection to what they suggest is the definition of culpable negligence as the court's indicated.
With regard to the
Second lesser?
second lesser? Yeah, thank you.
No objection to that proposed instruction.
All right, very good. Thank you very much. What is the
Defense
instruction
typos,
number for the...
they are working off of the defense's red line. So when the court points out typos, those are working off of the defense's red line.
culpable negligence instruction?
Just so we know who's making the typos.
I think it's 8.9, isn't it?
8.9.
Okay, thank you very much. Moving now to page 10 of 34, 3.6D, voluntary intoxication.
Not a defense. I like that they explain it.
Does this now need to address culpable negligence? Or is that only...
No, yeah, we would request to add it, the culpable negligence, since it's going to be given. So it should read second degree murder, comma, manslaughter, comma, or culpable negligence.
You're talking in the last sentence, correct? Voluntary intoxication is not a defense to second-degree murder, manslaughter, or culpable negligence.
Yes.
Thank you. Any
So-
objection,
No,
defense?
I agree with that.
That tells the jury, hey, it doesn't matter that you're intoxicated. It's not a defense to
Do
these
we want to
things.
take an attempt to address the 3.6F?
I would suggest we do that later and see if we can just get.
Those are going to be the self-defense instructions. Those are going to be
At
hard
this time,
to go
just going to
through.
make a note that we're going to bypass the 3.6F instruction and 3.6G instruction.
Thank you
That'll
all for
take us
also
all the
saying
way to page
Dr. P is the real hero this
23
morning.
of
He brought
34.
breakfast.
Instruction 3.7, plea of not guilty, reasonable doubt, and burden of proof. Any objection to the form of this instruction, defense?
This is me when I talk to somebody who processes slower than I do. I am the judge sitting there going,
No objection.
Moving now to page 24 of 34. Weighing the evidence, 3.9 instruction.
Should we go to 3.7, plead not guilty?
Did I skip it?
Yes, sir, page 23 of 34.
I'm sorry, I thought that's what we just covered, Mr. J. I apologize.
Oh, I didn't, I was just making sure.
Mr. J's like, wait, what?
That it's either the court made or the defense made, so I was scrolling, but no objection to 3.7.
Okay, thank you.
this is why I like doing it on paper because
Moving
you
now
don't
to
miss
page
things when
24 of
scrolling.
34, 3.9, weighing the evidence. Looks like give as applicable paragraphs 6, 7, 9, and 10 have been struck. Is that acceptable? State.
Yes, Your Honor, I agree that 8, the inconsistent statement instruction, should get bumped up to 6.
Agreed.
And the remainder should not be read.
With those revisions, is that instruction 3.9 acceptable to the defense?
Yes, Your Honor.
Yes, the jury does get the jury instructions back
Moving now
in
to
the
page
jury room.
25 of
Sometimes they get one copy, sometimes they get individual copies. I've never seen a court. Sometimes they don't send them back, but the jury can ask. I prefer when the judge hands them all paper instructions to read along, but I think courts should ask, would anyone like to read along as they're being read the instructions? Some courts don't because they want you to listen to the instructions and not be like flipping through and reading ahead, but it just depends. I would need to read along if somebody was reading me, 30 pages of text. So yes, they get the instructions. And I've seen juries like work through instructions on the paper and they leave them in the jury room and you can see kind of the notes they take and how they break them down. And that is helpful, I think, for them to do. The jury instructions can be dense and they are all on like a computer program. So when you're going through the jury instructions, there is a whole program to do all of this. So when the edits have to be made by the clerk, they just go into the program and kind of click through it. But that Dr. B would be like, hey, are you heading home? I'm like, I'm not done with jury instructions yet. And there's like, it's on the work computer's desktop. So I'm here.
34, the latter portion of the 3.9 instruction. Any objection to the language contained on this page state?
No, sir.
Defense?
I love his reading
No, Your
glasses
Honor.
so much. This judge
Moving now.
just makes me happy.
3.9A instruction was struck by virtue of Ms. Boone testifying in this matter, so that need not be addressed. The 3.9B defendant's statement instruction also included.
The instruction he just struck was the instruction he read to Ms. Boone that said, if you don't testify, then they get this instruction that they can't speculate, they can't hold it against you, etc. She testified, so that comes out.
The requested language by the state. Is there any objection to the form of this instruction at this time? Defense?
No, Your Honor.
Okay, Ms. Boone, earlier this week, and I can't recall if it was yesterday or the day before, the state had filed a motion seeking to add additional language to this instruction. And I had read that language to you at that time. Do you want me to read it again to you this morning?
Yes, please.
Okay, so I'm going to read you the entire 3.9B instruction. 3.9B defendant statements reads, a statement claimed to have been made by the
She should also have this on the table to read along with from her defense attorneys.
defendant outside of court has been placed before you. Such a statement should always be considered with caution and be weighed with great care to make certain it was freely and voluntarily made. Therefore, you must determine from the evidence that the defendant's alleged statement was knowingly, voluntarily, and freely made. In making this determination, you should consider the total circumstances, including, but not limited to, 1, whether, when the defendant made the statement, she had been threatened in order to get her to make it, and 2, whether anyone had promised her anything in order to get him to make it. That should be revised to the feminine. Any objection?
No, Your Honor.
Defense?
No, Your Honor.
That is the form instruction created by the Florida Supreme Court, ma'am. What has been added is the next paragraph, which reads, law enforcement
And we
is
read
not
this
legally required to
on
ask
stream.
a suspect whether he or she wants to talk to law enforcement after Miranda warnings are read to a suspect. This is, however, one of the factors you may consider whether the defendant's statements were voluntarily made. Similar to other conversations we've had this past week, ma'am, I don't want to know about specifics of any conversations that you had with you and your attorneys, just simply whether or not those conversations have been had. Did you and your lawyers discuss the proposed language that I just read to you?
Yes.
Do you have any questions with regard to that proposed language?
No.
Are you in agreement with this additional language being added to this defense?
Yes.
All right,
I've never
or to
seen a
this
judge
instruction,
check
rather.
in with a
Thank you.
defendant as much as he checks in with this
The
defendant.
last sentence read, if you conclude the defendant's out-of-court statement,
He's
was
just,
not
like, heading
freely
off
and
her
voluntarily
arguments.
made, you should disregard it. Any other clarifications to that instruction statement?
No, Your Honor. Thank you.
Defense?
Judge, in looking at it, it says in the final part, consider whether the defendant's statements, can we replace and put?
There are a bunch
Sarah Boone's statement?
of motions I haven't grabbed on the
Where are
website
we
for this.
specifically, sir?
In the state special that I have no objection to, it says, this is however one of the factors you may consider whether the defendant's statements, if we could have Sarah Boone's statements, were voluntarily made.
The language used all throughout the instruction is the defendant.
Yeah, I tend to agree with the state on that.
Okay.
Rule 3.10, or I'm sorry, instruction 3.10, rules for deliberation, page 28 of 34. Looks like the parties agree that paragraph 7 is not applicable.
Yes, sir.
I agree.
All right, that would change paragraph 8 to 7. Any other revisions to 3.10?
Not in this.
Defense?
None from the defense.
Moving to 3.11, cautionary instruction. Defense?
No objection.
The court then interlineated on page 30 the 2.7 closing argument form instruction. Any objection to that instruction?
When he says
State?
form, that's just standard,
Defense.
no edits.
No, Your Honor.
Moving now to 3.12 verdict instruction, page 31 of 34. State?
No objection.
Defense?
These are your instructions, defense.
Moving now to 32 of 34, instruction 3.13, submitting case to jury. The only other question I have for the parties is with regard to, I believe it was Exhibit A, the suitcase. Are we going to send that back, or is that going to be viewable upon writing similar to the baseball bat?
No reason that it can't be sent back.
Okay, agreed?
Agreed.
So the
Okay,
jury
all right.
will have the suitcase in the jury room.
Is this instruction acceptable to the state?
Yes, Your Honor.
Defense?
Yes, Your Honor.
Very good. And then moving to, that concludes the, except for the 3.6F and 3.6G instruction, that includes the verdict or the instructions. I'll have Anita clean that up and send it to the parties so that
pull
we
some
have a
of those
cleaner red line to
instructions if I
work with.
can.
The only other question that I think we can address this morning is the verdict form. I received the defense's verdict form. And it looks like manslaughter is no longer being sought in the verdict form.
Sir,
Manslaughter was struck out and it was just culpable negligence.
Under the defense's part, yes.
Right. Okay.
what?
So how do we want to address the verdict
The
form then?
fuckery.
Because if we're giving instructions on manslaughter, certainly needs to be included in the verdict form.
I understand, Judge, but
Here's why I say it's fuckery. The entirety of the instructions we've just gone through, the entirety of the instructions that they just went through, that we've just gone through, involves manslaughter as a lesser included. So now when we get to the verdict forms, the defense just took it out. They're like, nah. But they never said in this entire charging conference that they're asking to remove the lesser included of manslaughter. They never said it. Not once, never objected, never said don't include it in the jury instructions. And then it's not on the verdict form. The judge's face is just how I feel. The judge feels like this. This is how the judge feels at the moment. He's like, how are you just removing manslaughter from the form when it's in all the jury instructions? You can't just not put it on the verdict form. And the defense is like, what?
the defense isn't requesting manslaughter, but if it's instructed, it has to be in the verdict.
Yeah.
So the verdict form would read, we, the jury, find the defendant guilty of murder in the second degree as charged in the information. We, the jury, find the defendant guilty of the lesser included offense of manslaughter. We, the jury, find the defendant guilty of the lesser included offense of culpable negligence. We, the jury, find the defendant not guilty. Is that acceptable to the state?
Yes, Your Honor.
Is that acceptable to the defense?
Yes, Your
All right. Similarly, I'll have Ms. Barrios make those revisions and submit them to the parties as soon as possible. Anything else, state, we need to address before? Bruce, do we have everybody as of this time? Everybody's here?
So
Thank you, sir.
they have a lot to
Other
get
than
through with the
3.6 instructions and the state's request
self-defense
for
instructions.
other instructions, which I think we'll have to table for now.
Yes, sir.
Are we prepared?
The state has requests for special jury instructions regarding initial aggressor, regarding battered spouse, regarding causation, regarding withdrawal from physical contact. So there are at least 4 special requests with regard to the self-defense instruction that the state has filed. So we'll be going through some of those.
Prepared to go ahead and bring in our jury at this time?
Only thing I wanted to bring to the court and the defendant's attention was apparently yesterday at lunch there was some sort of domestic violence event out in the quad. A coworker indicated that without believing it was any particular jurors in this case, that he did see people with juror badges in and about the area. So I don't know if that warrants inquiry by anybody.
Defense?
I think it should be mentioned.
I agree.
Okay.
I agree.
Just to see,
Sure.
we spent all this time, we've got a bunch of alternates.
He agrees with you. Stop.
Let's utilize them, but I do have an issue.
Yes. What do we got?
He agrees with
I
you.
think
Stop.
The state attorney, the last piece of evidence is they extracted from Sarah Boone's phone a bunch of pages of text messages. And I believe their intent is to introduce all those text messages, which are quite a few, but I think they want to read specifically out a few to the jury. My only concern is I don't know which ones they're going to read out, and under the rule of completeness, if there's a thread where it needs to be put in context, we would ask that all of that be read. So I don't know exactly what they're planning.
Mr. J, any response?
It's going back with them, just like I told them during some of the body-worn cameras. Only some of it's published. It's all going to be there for them to use. I do not intend on reading all 108 pages.
Oh, well, that's good to know.
I intend on trying to delineate what contextually is one conversation from the other. I think it's just fair to say this is all going back with you. You're going to have a scrub laptop. You're going to review it all.
Okay. Mr. Owens, you can make any objections you deem necessary at the time, and we'll address it. Because it's just hard for me to say what should or should not be. I understand the state's position, but if it's something that's you believe in the rule of completeness should be provided at that time, regardless of it going back, we'll address it.
It's going to be about 40 minutes worth of reading text messages. Are we going to have some people come in to read the messages?
I'll volunteer to voice act the messages. No, they generally don't. The attorneys will read them, but you can have other attorneys come in and read them. And I've done that for colleagues. People are like, I need a transcript reader. I'm like, me, I'll come. And oftentimes you would have somebody come and sit in the jury box and read the transcript of whatever the testimony was that was being read in. And you would just sit in the witness box and read through them and have people come in and read. Sometimes you would have two parties come in and read. It just depends. But I don't think they're going to be dramatically reading them into the record. You also should not theatrically read them. You just kind of read them neutrally.
Again, I'm not sure how long it's going to take. I do not practice reading what I'm going to be reading in the mirror. Number two, no, I don't understand why a witness would be called. It's in evidence. The lawyers do not publish them.
Okay. Anything further, Mr. Owens? Okay, all right.
If I was Mr. Owens, I might actually ask for another attorney to read them, just so it doesn't somehow have more or less weight. I don't know what they do in Florida, but in LA, we often had somebody come in and somebody who wasn't the attorney on the case, somebody who was unknown to the jury. So it didn't have a more or less impact on the jury. It didn't seem more credible because the attorney they had been in court with was reading it somehow. It was just to make sure it was neutral as can be.
Take like 5 minutes to use the bathroom.
Sure, we can do that. Okay, so I don't want to highlight that it was a domestic violence event. So are the parties, is it acceptable to the parties to inquire of if anyone heard or participated, got any information, or observed anything of the event that transpired yesterday afternoon in the courtyard? Is that acceptable?
Yeah, you definitely shouldn't suggest what it was.
Agreed. Okay, got a thumbs up from Mr. Owens. All right, we'll take a 10-minute recess. We'll just plan on bringing back here at 9:30. We'll bring the jury in at that time. Thank you all very much.
All right. They're going to go to break. I'm going to mute this as we zoom. I saw a couple really good questions in the chat. Dahlia said, Emily, I'm not sure if I understood. If the jury votes for manslaughter, it will be sentenced as a misdemeanor. I'm glad you asked. No. The court is giving 3 options on the crimes. So, first, second-degree murder, felony, minimum of 22 and a half years, maximum of life. Second option is manslaughter. That is a felony up to 15 years. The third option is what they call culpable negligence, which I would have to go look at the law of it to figure out what the equivalent would be in jurisdictions I practiced in, but it is a culpable negligence misdemeanor. Like you did something negligently and somebody got hurt while you did the thing. That would be a misdemeanor. So there are 3 options for them. I see a lot of questions about what they were talking about, what happened in the courtyard yesterday. The DA said as they were wrapping up that yesterday in the courtyard, there was an event, like a domestic violence awareness event, and that one of the other DAs in the office brought it to his attention and said, look, we don't know who was there, but people with jury badges were walking around in that area. So because it is something that was going on near the courthouse in relation to what this case is about. They're just going to inquire from the jury, did you see anything or do anything or were impacted in any way? Did that change anything in any way? It's just like if they were doing a misdemeanor, like vehicular crash and there was a car crash in front of the courthouse as the jurors were leaving, it would be like, did you see anything that changes your mind about this case? It's over ask, over explain. So that's what it is, just to make sure. And then Owens was like, look, if somebody is impacted, like they were so moved by something they saw yesterday when they were going to their car, I'm sure when they were done with court yesterday, all those jurors wanted to do was get to their car, go home and take a bath. But if they saw anything during the lunch break or whatever, then the court and the parties should know about it. So let's see. Keiko said, do you think it'll be a short deliberation? I do. I want to hear the jury instructions first because sometimes instructions can be confusing and that can take time. But I also wonder if they'll want to go back through the videos themselves. I don't know. I think that you either believe her version of events or you don't. I don't think there's any controversy in the fact that Jorge Torres is dead, that he died because he was in the suitcase. And it's just, do you believe that she was in fear or not? It seems to me to be a fairly simple question, and they're only deliberating with 6, which means this can go much faster than other deliberations because it's 6, not 12. So they are standing for the jury to come in. They're going to do the last of the state's evidence, and then we'll go from there. And for those asking in the chat, yes, it has to be unanimous. But 6 people agreeing on something is way easier than 12 people agreeing on something. So there's that. I mean, yesterday was wild. I was not expecting those videos at all. So it was surprising. RW said, why only 6? That's what the law in Florida says. So, because Florida, other states do that too. I've learned quite a lot about varieties and jurisdictions through doing this. Other states do that too, and it depends on the level of the felony. So a first degree murder, there would be 12, but everything else, 6. So is 6 instead of 12 pretty common? I've seen more jurisdictions that do 12 for everything felony. It seems to me to be less common. I don't have a poll of jurisdictions. It seems to me to be less common to do 6 in criminal. In civil, it's very common to have all kinds of wonky numbers and you don't have to all agree. Civil
State,
hurts
do you
my
recognize
brain.
our jury?
Yes, Your Honor.
Defense, do you recognize our jury?
Yes.
All right, members of the jury, you can be seated.
Sarah's like, they're asking me to. I recognize them too. Ma'am,
Members of the jury, good morning.
we watch. Oh, that tie. Is this your tie for closing? Counsel, if you stay by the microphone, we'll forgive the tie. I am having a harder time personally looking at Sarah Boone's face today after all those videos. She's like, yes, I recognize them. I'm like, shut your face up. I want your face to be quiet or sit down. Like I'm so done after yesterday. I'm just so done after yesterday. So many good ties. And then Mr. J, sir, it's something. But I'm having difficulty today.
Welcome back to 12 Alpha of the Orange County Courthouse. Just again, if you could raise those hands, confirm you complied with the court's instructions. All right, all hands have been raised. Thank you very much. Members of the jury, before the state continues with their evidence presentation today, I just have a couple of questions to go over with you. Yesterday, there was an event in the courtyard of the Orange County Courthouse. Did anyone happen to observe that event? If you did, please raise your hands at this time.
What do you mean by observe?
We'll get to it.
Okay.
Did anyone happen to hear anything during that event?
Did you see it?
All right, and record reflects no hands have been raised. Did anyone see anything during that event? All right, juror number 2, first row. Thank you, ma'am. Did anyone participate in that event?
If they didn't hear anything, they probably
Reflect no hands have been raised. Did anyone receive any writings or review any material from that event? Record reflect no one has raised their hands. Can the
It
parties
might be
approach
his
for a
lucky
moment?
tie. I mean, he's been a DA for a minute. It might be his lucky tie. And look, I don't have any style. I wear band t-shirts from Target. It is just not my favorite. Also, I think my perception on that might be skewed because the white balance in the courtroom is so yellow that the yellow shirt with the yellow tie is hard. So, but it doesn't mean Mr. J's closing won't be.
We've got a couple follow-up questions.
Look, I like his tie a lot better, but also purple. I'm completely biased. This is more my
The
preference
jury,
with the
I'm
blue
going to
suit,
send everyone
the
out
purple
except
shirt,
for juror number 2.
purple shirt, purple tie. Dig it.
The first row. We've got a couple follow-up questions for you individually, ma'am. Same instruction I've given you all previously. Please don't conduct any independent investigation or research as to the person, places, things, or...
I would like to note I feel so bad for this juror right now because they're probably sitting there going, fuck, did I do something wrong? If it were me, and I think if it were a lot of you, that you would sit there and being like, shit, did I do something wrong? Because it's all the jurors leave except for the one. They just want to ask that juror if anything that they saw during that domestic violence awareness event in the courtyard could impact them. They just want to know if it impacted them. But that one juror has to be like, the anxiety. However, this judge is so nice that maybe it's just like, oh, I get to chat with the judge.
charge involved, and don't have any discussions amongst yourselves or anyone else, and we'll bring
So
you
they're
back in as
letting out
promptly
the
as
jurors
possible. Thank you.
except for one. But the jurors were honest. They're like, did you see anything? Did you not see anything? So, and for those of you that are new to the case, hi, welcome. The judge has students from his trial advocacy team with him, or from the trial advocacy team at his
seated, thank you.
the law school where he teaches. Sorry, moot court, not trial
Juror
ad.
in seat 2 on the
I
first
use them
row, from
synonymously.
right to left. You had advised, based on the court's question, that you had observed something, and you said what does observed means. And instead of getting that out in front of every other juror, we just want to have that individual conversation.
The juror's like, shit, I was just trying to clarify, Your Honor. I didn't mean to be on the hot seat.
With you now. So tell me what it is that you saw or heard or anything yesterday in the courtyard yesterday.
When we were walking back from lunch, and we saw that they were gathered, and I asked the deputy if he knew what was going on, and he said it was somebody Bain talking about domestic violence.
Okay. And you said we were walking. Who's we?
Other
I'm not
jurors.
sure. I don't want to say her name.
Okay. All right. Is that a juror that was on our panel here?
Yes.
Okay. All right. Do you recall where they may have been seated?
No, in the back over there.
Paige,
Okay.
there are extra jurors. There are
Do you
8
recall
extra jurors.
what color her hair was?
Yes.
What,
Would you like me to tell you?
please.
Dark brown or black?
Is it the shorter juror? Okay. Thank you very much. State, any further questions?
And after you were told what was going on, then what happened?
I walked back in.
All right. Did you hear any of the speakers?
I couldn't hear anything. No.
Anything further from the defense?
Again, this would be me. Hey, there's a bunch of people out here. Bailiff, do you know what's going on? Oh, yeah, it's this kind of thing. Somebody's speaking about this thing. Okay. I had to do this once. I hated it.
Can the parties approach for a moment?
I had to do this more than once, actually, but I had to do this once that related directly to me, and I hated it. All right, they're approaching. Some of you know that story, some of you don't. Maybe when we get to a break, we'll tell that story again. But
So the panel, you can just hang out where you're at, okay?
they're going to bring the rest of the panel in. I wish the judge had said, we just have a question. You didn't do anything wrong. So I love the judges' clerks look like they are matching
for
each
you.
other.
You
Like
do not
they've
need
got
to
like
stand.
a
We stand for
uniform
you.
situation that I'm loving going on. Hello, future lawyers. Y'all are going to have a good day. Best day to show up. Well, yesterday would have been a good day too, but closing arguments, best.
Y'all can be seated. Thank you. Again, members of the jury, if I could see those hands, you complied with the instructions during that really short break. Record reflect all hands have been raised. Thank you very much. Mr. J, you may proceed, sir.
Permission to publish from States 21, which was previously marked as P for identification.
You may proceed, sir.
Again, this is a DVD exhibit with 2 folders in the main directory. One entry is in a
My kid's personal Uber driver said it has to be a uniform, right? They are exact. I don't think so. However, what I will say is that when doing like a mock trial or something like that in law school, I can very much see everybody looking at each other going, hey, what are you guys wearing? We'll just do this. It's easy. And everybody kind of just wearing the similar things because you're in law school and you're not really quite sure what to do. Also, they look great. So yes, the benchies are on point today and look lovely. And again, those are the moot court mock, I'm going to say the wrong thing ever, mock trial students. So they learn to do this. And they do this in mock trial competitions, which is more like, I don't know, theater law.
A folder called attachments. Another is a PDF labeled extraction. And for the record, it is 108 pages.
Wait, are you going to read them from this form?
We'll go back to the jury, and there will be a laptop provided to them.
Well, they've got calendar date. They've got everything in this extraction. You're going through.
For purposes of publication, I'm going to go by page number and date unless something requires more specificity. And for to and from, I'm going to just use the name, the contact if one exists, or the phone number if one doesn't. On page 1, creation time for notes.
And no, none of the
7:49,
jurors were
asking
excused. It was just an
Jorge
inquiry.
Or George not to be despicable to me, making more drink after he guzzled his and I shared mine.
I'm going to make myself smaller so we can all read this a little bit better.
On page 2, date March 8th, 2018. You are now in a relationship with Jorge or George on Facebook. And metadata.
They're Facebook official. Hold on. They went Facebook official on, what day is that? March 8th, 2018 is when they went Facebook official. And that extraction is coming from Facebook messages, instant messages on her phone. All right.
Entry 100014, etc. for Jorge Torres to Sarah Boone, owner.
I didn't realize he was going to read
Page
this
3,
straight from the extraction. Interesting.
May 21st, 2019, from 407-716-8684 to Melissa. And he can still live here, correct? Or until I decide to finally get him out if he doesn't clean up his act after tomorrow?
I would want to go back if I was the juror, and I might do this on my notes. I would want to go back and see where in time that 5/21/19 text messages fall with the body cam we saw when she's telling the police, get him out, get him out. I would be very curious where that falls in time. 21/20/19. That must have been when she removed him off the lease.
On page 9, May 30th, 2019, from a contact labeled as Mom, Jorge or George, to 407-716-8684, which I will just refer to as owner in future references. Where is my clippers in the gray box?
Dumpster like
From
you, so
owner
is your
to
two
Mom,
shirts.
Jorge,
No more Rick and
all
Morty.
capitals, dumpster, separate message, like you, separate message, so is your two shirts, separate message, no more Rick and Morty, a response from contact Mom Jorge to owner, okay. From owner to Mom Jorge, Lucas cried when he saw the adventure fund was gone, thank you, no wonder you're out, fuck off. From owner, he's the one that broke it because you took it. From owner, wanted to go on an adventure. On to page 10. From owner, be proud, feel good. You made my, quote unquote, our son cry.
5/30, 2019 seems like the time period that the victim had moved or was back with his parents because she had kicked him off the lease. And so I'm not surprised that the phone that's being used to text back and forth between George and Sarah is George's mom's phone.
Cheese stick, Lucas, your kids, get the fuck out of my life and my sons. No one, no one, no one, spinster, good, for nothing, dumpster diver, that's what you are, and the rest of you. Later on this same page,
These are
owner to mom Jorge, get all of you, mean, selfish, fuck all you.
She really
Your
does just
firstborn is a joke.
wield her son when she's upset, doesn't she?
Going on to page 11, same date of May 30th, 2019. From owner to mom Jorge, get the fuck out of my life. Lucas 2, bad influence. From Jorge to owner, I am, as you can see, go drink your life away. From owner to mom Jorge, your kids are too. Yuck. Shucks, I only have one. Beaters, your three together. Yuck.
Some kind of
Going
a
on to
picture.
Page 12, from owner to mom Jorge, still dated 5/30/2019. Gross, and all the time, gross. Mom Jorge to owner, I love that guy, I love that guy. You're the one who kicked me out. Owner to Jorge, mom,
Finally.
finally. Get your shot together and check me out in 2 to 3 months. Hope you're
Fucking
there.
autocorrect.
Unless I find someone better.
Shit.
Shit.
Well,
together.
Shit refers to
From mom
shit
Jorge
together.
to owner, are you serious? Are you serious? Owner to mom Jorge, that's what happens? No. Mom Jorge to owner, I'm helping out dad right now. Call you in a few.
To everyone who said ducking
Owner to
autocorrect
Mom
in the
Jorge.
chat, 10 out of 10 and a gold star.
Can you help me put out, fuck, off, Jorge, mom to owner? How?
Fuck off.
No problem.
How?
From 267-216-5170 to owner. Damn, you can only talk when you're drunk and talking shit. Owner to the previously
Well?
mentioned 267 number. Stop calling, texting my phone. He's not here anymore. And it's damn. 267 number to owner. NP, you didn't have to be a bitch about it.
So whoever that number is texting back Sarah, no problem,
Owner
but you don't have to be a
to
bitch about it.
267.
She's
Going
looking
on to
for
page
him
13.
somewhere, right?
Still May 30th, 2019.
It's probably one of his family members,
Yo,
yeah.
I like you all. He's a dick.
It seems like she's looking for him. I would guess he was blowing up the mom's phone and then started blowing up the family phone. So for all of you that are like, I'm confused, is this mom or George? I believe it is George using his mom's phone. These are the contacts from Sarah Boone's phone. Sarah Boone might have saved that number in her phone as George mom, because that's George mom's number. But George, when he would leave Sarah Boone's house, and on May 30th, it seems like that's what was happening. When he would leave Sarah Boone's house, he would stay at his mom's house, and he didn't always have his phone. So I think he was using his mother's phone, and that is them talking back and forth. So, and then there's another number in there, because we're going through 3 different numbers. So there's another text thread also happening where she's looking for George somewhere else. So I don't know if that is a brother or one of his kids or a sister or whoever, but there's there's another text thread going on. So it seems that Sarah is blowing up everybody's phone because George is not there. And she's like, I'm glad I kicked him out. Is he there? Anyone who's been around this knows exactly what this is.
And the sheriff just left. Sorry I couldn't text back. I'll always respect you all. You know that. He's not here anymore. And yes, I am a bitch.
Oh,
So are
he's
you.
not here anymore is Sarah talking to one of his family members. All right, Sarah telling somebody that he's not here. It's hard to read these when they're not like screenshotted like a Bravo celebrity would do from the phone, because these are the text extract, the phone extraction. So these are going in chronological order, not in conversational order. So they're going to jump around. Jump.
He's a dick and the sheriff just left. Sorry I couldn't text back. I'll always respect you all. You know that. He's not here anymore. And yes, I am a bitch. So are you.
Okay.
267 to owner. Look, I'm not here to be taking shots at you. I never called you a bitch. I said you were acting like one. I'm not going to be here going back and forth on some childish shit. Have a good night.
Boundaries.
Owner to the 267 number. Friends forever, thank you. Would love to chat sometime. Call his parents, I guess.
What he's not reading in, the jury will
Further down on
have.
page 13.
The
Now
jury will have all 108 pages.
on to May 31st, 2019, from owner to mom Jorge. Tell Jorge to call me. I want my things he took. I have his birth certificate and propane certificate. Until then, if he wants those back. And I have your quote-unquote art box. Mom Jorge to owner, stop being petty. I did not take anything that wasn't mine, I swear.
Which indicates George is using that
Owner
phone to text.
Mom Jorge, you're a liar. I never can believe you from all the other lies. You stop being petty and take shit like you always do. Another one bites the dust, Jorge. Hope you're miserable like you've made everyone else. Mom Jorge to owner, I'm not lying. Owner to Mom Jorge, Lucas said he won't miss you either. When I get mine back, you'll get yours.
She weaponizes her
Jorge
kid
to
all
owner,
the time
I
in
didn't take
these
it.
and in the videos.
I'm coming over in a few to get my stuff, and I'm coming with Jean and Melissa. Going on to page 14. Owner to Mom Jorge, go for it. Bring mine W. Mom Jorge to owner, I don't have anything of yours. That's why I'm coming with them so they can vary that. Owner to Mom Jorge, I don't care. They're not going to babysit you because you're an asshole and got kicked out after being taken off the lease. Mom Jorge to owner, they seen what I had in my hands. Owner to Mom Jorge, still don't care or believe you. I'm going to get Lucas anyway, so don't waste their time or mine.
I wonder if this is after the call out. This is on 531. I wonder if this is after the call out when she was standing out there saying he has my keys and he's wearing like boxers and the police are like, we checked his pockets. He doesn't have your keys. Like your keys are in the house. And she's asking the cops to like go find her keys. And they're like, they're in there somewhere. Like, go in your house. And she's convinced that he has her keys and they're like, we've checked all of his pockets. So I'm wondering if when he is saying they saw what I had in my hands, they're talking about him being taken out into custody. And because that's the same day they're arguing about him being taken off of the lease and him not being able to cash his check because they don't have the documents. It seems like these conversations are happening similar in time because they are the same. They are the same. So Marta, I know his name is spelled Jorge, but everyone in this case, including Sarah Boone, has pronounced it George, and his brother did on the stand as well. So I'm going with how the family pronounced it. I would also read it as Jorge based on the spelling, but I'm going with what they're doing in trial. So that's where I am at with that. So
Mom Jorge to owner, exactly. Owner to Mom Jorge.
And he
You are a
changed
visitor and
midway
a terrible
through.
resident. Boyfriend too. Just go away unless you bring my stuff. Mom Jorge to owner. I don't have your shit, Sarah. I need my birth certificate.
Goldie, thank you. I didn't
Owner
catch
to
that.
Mom Jorge. I don't give a shit either. I worked for that birth certificate, voter's registration, and your ID card. Just because your name is on them doesn't make them yours.
I need a minute to process that she is texting him about his birth certificate, saying, I worked for that birth certificate, voter's registration, and your ID card. Just because your name is on it doesn't make them yours, even paid for them. He might have needed a duplicate birth certificate if he didn't have one. She may have helped him fill out the forms and go get it. But ma'am, those are his government documents. What are you doing? This is why the DA asked about it so much and asked about control of documents, because he could not cash his checks and his paychecks without his documents. And that was that first rollout we saw yesterday.
Even paid for them. I needed
That's
you to be
wild.
a man and take care of me, not beat me, call me names, and make me feel like I'm not a person. Not giving back until I have mine.
Ma'am.
Mom Jorge to owner, whatever, Sarah. Owner to Mom Jorge. Next step is restraining order. Know that. You can come over here 100 times. Doesn't mean I have to open the door. Good one, Jorge. Go away. Mom Jorge to owner, whatever. Owner to Mom Jorge. It's been a great day without you. Will be from now on. Mom Jorge to owner.
Stop blowing up the phone then. Stop blowing up the phone then.
Owner, you need to do. Owner to Mom Jorge. Enjoy living with your parents at 41 with no girlfriend and lonely. It was the inevitable, just like it has been before.
And then she paid her rent online.
Owner to Jorge. Mom, did you take
no, that
Lucas'
was mail too. So pay rent online, figure out bill amounts for Brian.
sunglasses? Mom Jorge to owner. OMFG. No, I did not. Turning to June 2nd.
No, let's not turn back, because then we're here for this. Hopefully you don't mind me pausing even the things the DA is not reading, because then we're getting other texts where she is like on 6/2. So this is from 5:31 to 6/2. George, call me. Is George with you? Can you have him call me? I'm home. SY is up. He's sleeping. So now we're on 6/2 going through those, and she's looks like emailing her ex asking if George is there.
Page 15, 1:10:57 a.m. from owner to Mom Jorge. Jorge, question mark, call me. If Jorge is with you, can you have him call me, please? Text to Mo.
I think after we saw her yesterday saying to him, I'll scream bloody murder, we know what that's going to be. I don't know why they didn't redact the phone
1:18,
numbers.
16 seconds on June 2nd. Owner to Mom Jorge. I beat you to the punch. Want to do the dartboard with me? Come.
This is from June 2nd.
Owner to Mo. I know you won't answer, Mo. Tell him to come finish the dartboard with me, please.
Tell him to come over.
Owner to Mo.
Telling her brother to tell her to come
I
over.
miss him.
Right.
Owner to Mom Jorge. Ask Jorge to call me, please, when he gets a minute. June 2nd, 7:43:40 a.m.
And now it's where is he? Where is he? Where is he? Where is he?
Have Jorge call me, please, when he gets a chance, if he's with you. 7:45 a.m. Owner to Mo.
I need a chart of the days of those 911 rollouts.
Going on to page 16, June 2nd, 2019, 10:50 a.m., 55 seconds. Owner to Mo. Hello. Can you please have Jorge call me? Willing to give back. Don't know if he's there or at parents. Really want to see him.
That was me. I'll give him I was trying to pause. I'll give him the stuff I took if he just comes and sees me. Like if he just comes to see me, I'll give him the stuff that I took from him. Let's see. Sorry, y'all, that was me. I'm trying to look at the
Owner to
dates of the
Mom Jorge
rollouts. Oh, June 2nd.
10:52, 16 a.m. Not
Nope,
pursuing
it's
after
June
12
15th.
o'clock. Ever again. (12:19 p.m. 23 seconds). Owner to Mom Jorge. Please call. Come over. I'll come get you. Come over, please. I need a super hug. Hugs? Please. Need. You. 6:23 p.m. Owner to Anna.
All right, June 15th is the second rollout that we have. That's the first one in 2019 that they showed yesterday.
He doesn't live here anymore. Call parents or Mo in response to an incoming phone call that was made at 6:10 p.m. 54 seconds from
She's
Anna to Owner.
Blowing up everyone's phone looking for him.
Entries 9803, 9804 in the PDF timeline, June 2nd, 2019. Image 0092.heic, capture time 6:33:01 p.m. Image 0093 HEIC, captured 6:33:26 p.m.
What's the image?
Publishing from
Oh, great.
attachments.
Or not great. Shit, what is she sending him? I'm nervous.
Image _0092, metadata showing 6/2/2019, 6:33 p.m.
Oh, his records. I was worried it was going to be boobs for a minute, honestly, or more. I'm really glad it's not, but it's sad that she's like holding his stuff hostage to make sure he's coming over,
Image
which is much more
IMG
manipulative and controlling.
_0093, metadata, date taken 6/2/2019, 6:33 p.m.
This relates to the case much. Oh, fucking hell. Well, there's that.
(6:34 p.m. 51).
Just in case the videos from yesterday didn't put a point on who's trying to control who, this will put the final point on who's controlling who in all of this.
Seconds, June 2nd, 2019. Outgoing from Owner to Mom Jorge. All up to you now, big boy. And for the record, those images were sent to Mom Jorge at 6:34 p.m. 33 seconds. Look what you made me do. Or maybe you're...
Well, she's not quoting Taylor Swift on the look what you made me do. With that, we hadn't seen her say, look at what you made me do in any of this yet. But there that is, which again is so similar across DV cases that it's wild to me that you see it in case after case after case after case. You made me do this to you. Wild.
Your mom will for you. Response from Mom Jorge to Owner. Wow, that's really childish. Owner to Mom Jorge, but effective. Mom Jorge to Owner. Yeah, I see what you are doing. Did Lucas leave? Owner to Mom Jorge. I'm watching shadows. Be gone for good. Minus birth certificate. Mom Jorge to Owner. Okay, cool. Enjoy.
Perfect in the chat said, I
Owner
wonder
to
how
Mom
confident
Jorge.
Sarah's feeling now. I think Sarah thinks she's justified in all of this. That's why she took all those videos of her being horrific and abusive to George, because she sees it as she's right. So, yeah.
Am nice. You're not.
I am nice. Oh, the gas.
And nice was from Mom Jorge to owner. Going on to page 17, this is still June 2nd, 2019. Mom Jorge to owner, yes, I am. You are not, though. Owner to Mom Jorge, to who? Your mom? Brothers? Not me. Mom Jorge to owner, to everyone. Owner to Mom Jorge, but me. Mom Jorge to owner, I love you. Owner to Mom Jorge, I'm going out at 8.
Well, if there was any question about
Get
why his
dressed.
family didn't like her.
I've given you since noon. Peace out, Boy Scout.
And he's like, I'll bring booze.
Mom Jorge to owner, I'm coming over with a handle. I was helping Pop all day cut grass. Owner to Mom Jorge, yay you, getting in the shower then out. Bye-bye.
That's not bye-bye, that's
Mom Jorge to owner.
bye-bye.
Excuse me, can we approach the bench?
Yes.
That is bye-bye. Bye-bye. And that's also, I'm going out. Good Lord, chat. All right, let's zoom through this bench
To
conference.
owner. I'm already showered and dressed. Mom Jorge to owner. Hello? Text from Anna to owner. You're rude as hell, but okay. Owner to Anna. Your dad is a POS, but okay.
These are the same day.
At
We're
least
still on
you
June
know, and we'll
2nd.
stop calling owner to Anna. Futile. Anna to owner. CTFU as you are a piece of shit, but that's God's business, not mine. Have a good day, Coke whore. Since you like to switch it up, I'll do the same. Don't text me back either, fake ass.
I don't know who Anna is. But Anna's had enough of Sarah Boone. These are now June
Page
9th.
20 of 108, June 9th, 2019, from owner to Philip. He's off the lease. The process has begun. Page 22, June 11th, 2019. Metadata only shows to Mom Jorge. You tell your son he's not welcome here, taken off the lease and bound, worthless. Don't show his ugly, fucked up face around here again. Police will be called. Ask him if it was worth it and ride my bike he has. Stay Hispanic, that's what you all are. And he can watch all the porn he wants from the phone Mom gave him.
The response, by the way, that he skipped over is we're from Puerto Rico. Like, what the fuck, Sarah? Well, do you think the jury likes her more now? Less? For those of you in the chat asking about Sarah's son with his father.
Page 26, June 14th, 2019, 11:38:56 p.m. To Mom Jorge. Wow, congrats, blackouts and whoring. We wanted to see him. Hot house, 7 people. Mission to work on my bike. Repeat. Candy Crush. Fuck himself. Shit job. Repeat.
Why is Candy Crush catching strays? I mean, it's not Midas merch, but why is Candy Crush catching strays? Sarah, the chat wants to charge you with more. The chat's like, there's not enough charges.
Same page, June 15th, 2019, 7:37 p.m., 48 seconds. To Melissa, just an FYI, if my place gets effed up, I'm letting you know. He's in jail. Thanks for the
6:15 is the second call out we have on recorded video. I went back and looked at the dates. So this, when she's saying he's in jail, this would be after that video that we saw.
Prompts. I'm at my ex's house. Please don't let this reflect on me as a tenant. You said to call cops. I did. He's gone. We're both proud now. I consider you my friend. Melissa, why was he in your apartment?
Well, it's a whole lot of texting. Yep, we're going to back up and we're going to read it. Yeah, we sure are. All right, texting Melissa, he's at my ex's house. Why was he at your apartment? Can I call you 5 minutes? Give me 30. To George's mom. George is trying to get a hold of you. If he hasn't already, the number that will show up is the jail number. Thank you, Janice, for getting him out. He wanted me to let you know he will definitely be at work tomorrow to open. Also, the other condition is he needs to stay away from her for a while. Please have George call me and text me tonight when he gets home. I should see you in 5 minutes. Go ahead and call the bonds or whoever you use. Also, the other condition is he needs to stay away from me. Okay, that's a duplicate. This is Sarah. I think you meant to send this to George's dad. Yes, thank you. I think you two should take a break from each other. I mean, everyone. And no one is put on this earth to be hit, and I do not condone that or well tolerate. I'm so sorry he did that to you. The only reason I'm loaning the money is because I need him to work. Otherwise, you could stay there, and he needs to be punished for what he did. You should ignore him for a couple of weeks and give him the cold shoulder. That is the worst thing you can do to a person, and that will really punish him. And you know he'll come back. He loves you. LOL. Hey, Janice. Not solid on that advice, but let's continue on. So that is from that 6:15 call. Yeah, we're not taking Janice's advice either. Janice is like, I bailed him out because I need him to come into work. Janice, no. You two should stay away from each other. Yes, the rest of it we're gonna ignore.
Page 38, notes.
This is from June 26,
Creation
2019.
time, June 26, 2019, 5:56:57 a.m. 6:14, X videos, 10:03 a.m. Sarah Banks, 5:03 Bank, 6:13. Metro activation 6:12. Skipping down. X videos 6:02, 6:13 p.m. X videos.
Who's
6:1.
Christine?
X videos 5:31, 9:56a. Who's Christine? Paren FB. Going to meet up? Question. Calling her beautiful? Question. Said she thought you were avoiding her when down here. Said no. I was not beautiful. FB-nonchalant Quay. Thanks for adding me. You are exquisite. Facebook messaging Camille 6:13, 9:42. Facebook or FB Pamela Erickson sending pictures of yourself, telling her good morning 7:14, 12:13 a.m. FB-Crystal going to woo her, sweep her off her feet, going to change her mind. Luck is my middle name. Sent her pics, kiss emojis. Called her beautiful after returning to the convo. Said you had to pick up your brother. Sent pics of beer. Sent her struts. Could have been me. Sent her songs, but not me.
What in the world
Message,
is this?
Funny kiss emojis. Convo. Sent puppy kiss emoji.
Continued combo.
Would love to take her out and see a movie. Told her about what we do in the shadows. Would love to watch Creed 2 with her. Want to snuggle with her and eat popcorn. Sent heart-hugging animal emoji. Want to play a board game with her. Asked to FaceTime call her. Called her amazing. Messaging at 7:30 6:14, 6:15, 2 days. FB-Crystal liking all her posts. Quote, losing someone who doesn't respect or appreciate you is actually a gain, not a loss. Can't compare me to the next girl because there is no competition. I'm one of a kind and that's real. Continuing on to page 39, same note. I found everything on your phone, all your messenger texts telling Christine you want to meet up.
Is this a notes app note? Is this a text? Sorry, I'm backing up real quick. My brain stopped. It seems like this is a notes app note. That is a what? Yeah, that's not a text. Okay. That seems like a argument waiting to happen of what? Facebook going through somebody's Facebook?
In the shadows,
going through his
would love
Facebook.
to watch Animal liking all her posts. Quote,
These are notes for the fight.
continuing on to page 39, same note. I found everything on your phone, all your messenger texts telling Christine you want to meet up with her when she's here, calling her beautiful, thanking nonchalant Quay for adding you and calling her exquisite, telling Pamela Erickson good morning and sending pictures at 12:38 a.m., messaging Camille, then the whole 2-day convo with Crystal, how dare you, and send pictures wearing my wedding ring. You're a cheating, lying scumbag. I will never trust you. Why don't you put your mugshot up, or I will, since I have your phone, and log in and
So
tell
there was a
everyone why
phone.
you were in jail for the 3rd time. Let them know you beat your wife and she put you there because she couldn't take it anymore. I want nothing to do with you ever again. I've become a different person since you've been gone, with less stress, anxiety, and worry. I feel safe, comfortable, happy.
You seem super happy with this this notes soliloquy.
Here with you not here or seeing you at all. I can say through I do have heartbreak after going through your phone. Thank you for always proving me right. I knew when you told me your mom gave you one that you'd be back to your slimy ways. You will never change. I hope it was all worth it, all of it, including losing my debit card for the 3rd time to buy beer and cigarettes.
Losing
To put you back where you belong.
the debit
I know
card.
for a fact you were not worth any of it. I just can't believe after everything I've done for you, including all I did to get you out of jail, and you do this to me. This is cheating. Goes on to page 40.
Like she's gathering
Goes on to
evidence
page 41,
and
and ends with never truly yours.
ends with never truly yours. Wow. And then there's edits of it. And for those of you that are like, this reads like her letters to the judge, right? Well, who else did she have to send all of her thoughts to while she was in custody? Other than her, other than the judge. So yes, this is, yep.
Page 42, June 26th, 2019, 8:06 p.m., 16 seconds. Outgoing from owner to Mo.
This is still
Just wanted to let you
6:26.
know to tell Jorge I found all his messages, kissy face heart emojis with Crystal and other bitches on FB, along with all his porn after he swore to me he wasn't doing any of that anymore. I'm not doing anything more for him, and he will try and keep him in jail as long as I can. Cheating snake weasel. Ask him all about it or have your parents the next time they talk to him. I'm not anymore. So hurtful after all I've done for him. He can rot in there for all I care. Going on to page 43, to Mo from owner. And I will be there for the hearing next week and his arraignment on both charges. Peace out, fucks, AKA Torres.
Shouldn't that be plural? Plural? No. Oh, she
And page 43,
sent the email.
from owner to Mo, 6/26/2019, 9:59:14 p.m.
So she takes the Notes app ranting situation and emails it to Mo or texts it to Mo and CCs her ex-husband on a group text or a group whatever. So sends it to Brian Boone and sends it to Mo. Can you imagine your ex sending you that? I mean, maybe Brian Boone can because this is his ex, but can you imagine? Mo is the brother George's brother.
Begins, hi, I was thinking if you could get out, I'd really love it if you'd take me to a movie, or we could snuggle like we do and watch Creed 2, get some popcorn and pretzels, maybe.
She pulled the things he put in the Facebook messages and then sent them to his brother to send them to him while he's in custody, saying, hey, if you could get out, now I want to do this. This is becoming Sarah Boone's Pina Colada song. Oh my God. Sorry, I can't deal with the fuckery. I'm not trying to make light. I'm just getting angrier.
We talk about what kind of other movies we like or find a fun board game to play together. I know your favorite is Avalon. What do you think? I was also thinking the other day about how much I miss you sending me pictures of yourself throughout the day, sending me songs you wanted to hear or thought I'd like.
His
But what I
fractious
really
music.
miss are the kissy love emojis you would send just because I really miss those, especially the ones with hearts. They'd always make me smile. I knew you were thinking of.
Send me what you're sending to the other people on Facebook. Goes through his phone, goes through his Facebook, pulls it all together and is like, why aren't you doing this with me? Oh my God.
You do Crystal, though. Even asked her to FaceTime. What would you do if you found me having this convo with Ben or John or anyone other than you? I'd be beaten to a bloody pulp. And don't do any of these things anymore, but yet you wear your wedding ring and mine around your neck and tell me how much you love me. But you're telling this woman who looks like TPT you want to snuggle with, take out to a movie, play board games.
Oh, and then it turns.
Questions. Sending music, cutesy, kissy love emojis to like you used to me. Telling her you want to woo her, sweep her off her feet. How do you think that makes me feel? Why don't you say that to me?
Uh-huh. You.
Going on
Chad, I don't know what TPT is. No idea.
through the rest of page 43.
And on,
44.
and on, and on, and
Reading
on.
on page 44, dirty
And
cheat.
on.
Enjoy your porn and jerking yourself off secretly so your parents don't see you and your ugly new girlfriends. I can't wait to finally be with a real man, Ben,
exhausted.
who will and has taken care of me. Can't wait to see what he's like in bed. I already know he kisses. Hope it was all worth
I can't get over that she has CC'd her ex-husband on this.
it. I'm free. As you told Crystal in your messenger text, you're single with a little cutesy dancing dinosaur. Wow. Now you really are. You're despicable.
You took him off the lease and kicked him out.
Next text is XOXO.
This is all the
From
same
Mo.
fucking day. Oh my God. Thank you guys in the chat for defining TPT. That's
Page 50.
That's delightful.
6/28, 2019, 10:55:47 p.m. from owner to Mo. Just know, I can do so much more damage than all of you put together. Know that.
Oh,
Going
and
on
now
to
we've got the
page
know that.
51. Try me.
I mean, she wasn't wrong. Counsel, where are you going? We're scrolling.
Page 72,
He's
July 20th.
He's control effing himself through this exhibit because he was clearly looking for the text about the black eye because now black is highlighted. Oh.
2019, 11:34 p.m. From Janice to owner. No metadata, but from Janice. Sorry it's so late. I just read your text. He seemed fine when I saw him at your apartment this morning. He answered the door right away, but was quite bummed out that he overslept. But I was okay and told him, no problem, just get ready and come to work in about half an hour. Then I texted your phone and asked if he would rather work the afternoon shift and get some sleep, but he never answered, so I have no idea where he is or what he's doing. What happened last night, he had a black eye. He said it was new because I asked him and I told him to put makeup on it. He said he had that taken care of. Did you two get in it again? He acted like when I told him he had a black guy, at first he didn't know what I was talking about. I guess he kind of blacked out. You can call me back if you want. (11:30 p.m. 38 seconds). From owner to mom, Jorge. Janice just called me looking for Jorge and she's pissed. Congrats.
I've seen a lot of questions in the chat about why Sarah Boone wasn't diagnosed with other things. They didn't do a full battery because different than civil cases that we've watched, this is doing the battery of tests just as it goes to BSS. So they were not, I think, looking for a full assessment. So thank you in the chat for not speculating. I know it gets harder and harder the more we go through this trial. I appreciate it because they're really only looking for the defense. They're not looking for everything else like we saw in Depp v. Heard because it's not a civil case. So I appreciate all of you. I know there are things in here that scream loud. So thank you, but they were looking at stuff specific to this case.
Page 82.
With much more surface level testing.
8/21, August 21st, 2019. From Jorge to owner. I love you, my friend, my love, my queen, my everything. Your Honor, that concludes everything I'm going to publish to the jury.
Okay. And with that, we're done with the text messages.
Yes.
They're approaching. I don't know if the defense will want to read anything in. The jury will have all 108 pages of this. I have no idea what it would be like to sit in court and see all of your text messages read into the record. I imagine she's writing vociferously to her lawyers. All right, let's see. I wonder if they're gonna let the jury out because they've got to do jury instructions. That's all that they've got to do.
All the exhibits and text messages into the review portions of what was.
I love having Zoom time.
Members of the jury, thank you for your patience. I just have a short instruction to read to you. Members of the jury, the state showed you portions of what was entered into as State's Exhibit 21. It is not the entirety of State's Exhibit 21. The entirety of State's Exhibit 1 will go back to you into the deliberation room with a laptop for you to review all the exhibits and text messages and the total conversations over and above what was highlighted by the state. With that, State, do you have any other witnesses, evidence, or testimony to provide?
Your Honor, at this time, the state rests its rebuttal case.
Okay. Anything further from the defense?
No.
You want to approach?
No.
I just think we have some issues outside the presence of the jury that we need to address.
Okay.
I have one thought, though, that requires a quick approach.
Come on up.
They were just at the bench. Couldn't we have done it all at once? Aaron, I like Matt Margolis quite a lot, said, I think tweeted something like dance like no one's watching, text like a federal prosecutor has been watching for years. It's good advice. Dance like no one's watching, text like your lawyer's reading. The defense isn't going to do a rebuttal. I think they're going to talk about the jury instructions. They can let the jury out to do this. I do think her attorneys did a better job for her than she would. Oh, that is a bunch of text. That's a lot of Post-it notes, Sarah. Post-its on Post-its on Post-its. So, we will see. It looks like George's family is there today. I can't imagine that is easy. I hope they weren't there yesterday for those videos, because that would be heartbreaking. So.
And for some things I have to discuss with counsel outside of your presence. We'll bring you back in for additional instructions on where we think we're going to go after that. Similar instruction that I've given you over the last couple of days. Please do not conduct any independent research or investigation with regards to the persons, places, things, or charge involved in this case. And do not have any discussions amongst yourselves or anyone else about them. And we'll bring you back in as promptly as possible. Thank you.
Brenda in the chat asked, why didn't his family speak? His brother was the first witness for the state, but if they are not percipient witnesses, there's nothing they can add to the trial because they're not witnesses. But they can make impact statements if she is convicted and to be sentenced, but that would come down the road.
Can be seated. Thank you.
Yes, well, let's see what we're going to get into, Miguelina, and then we will.
Rested. Mr. Owens, do you have any intention on putting on a rebuttal in this case, sir?
No.
Yes, sir.
Miguelina, yeah, if you want to let the text crew or the app, my brain has switched back into trials path. If you want to let the app know we are done with the text messages, the state has rested their rebuttal, and we'll be talking, I think, about jury instructions. I don't want to let the app know that we're going to just immediately go to lunch, though, because I don't know what's coming.
We did not intend to put on a rebuttal for the defense.
Okay, thank you. All right, Ms.
So
Boone,
give
I've
us
got
a
a couple
second.
of questions to go over with you, ma'am. You were previously sworn this morning.
I think they'll spend an hour
You've
going
had the
through
opportunity
jury
to
instructions.
review and participate in the trial. You've had the opportunity to review the rebuttal case as provided by the state. You've had the opportunity to review and listen to that evidence and witness any cross-examinations as it relates to the state's witnesses in their rebuttal case. Are you satisfied with your attorney's representation of you in this matter?
Definitely.
And are you still on board with the strategy that has been utilized in your defense?
Yes.
Now, your lawyers yesterday told the court that they may want to put on a rebuttal, which would be a limited rebuttal to the evidence presented by the state in their rebuttal, both yesterday and today. Your lawyers have indicated that they do not intend on doing that. Similar to other conversations we've had, ma'am, I don't want to know specifics. I just want to know if you and your lawyers have had these conversations. Have you had a conversation with your attorneys about putting on a rebuttal or a reply in response to the state's rebuttal?
Yes.
You had that conversation.
Yes.
Are you on board with the strategy employed by your lawyers that they are not seeking to put on a rebuttal in this case?
I am.
Okay. All right. Is there anything else that we need to address?
Yeah, the jury
States?
instructions.
Judge, you remember you were going to speak?
Yes, thank you, sir. Ms. Boone, at the conclusion of the state's presentation of State's Exhibit
Thank you, Janice.
21,
Janice
Mr.
was like,
Owens had
"It wasn't
approached
me."
and advised the court of some objections.
We adore you, Janice.
Specifically with regard to the co-ownership or co-usage of the phone. The court is not permitted to comment on the evidence. And your lawyer was seeking an instruction from the court to advise our jury that both you and Mr. Torres had access to that cell phone. I am prohibited from commenting on the evidence. Now, that doesn't prevent your lawyer or the state from speaking about that
came
in their
out in
closing
evidence.
arguments.
Yeah.
Just as a matter of law, I am not able to advise the jury as to what that evidence is. The
That
second
came out-
request pertained to
I think that was a request because Owen said, Your Honor, remember, can you address this? I think Sarah asked her lawyers, and the lawyers were like, excuse me, Judge, can you remind her that we can't do that? So I think the judge was telling her, can we remember that we can't do that? The attorneys can comment on it. The attorneys can make argument about it, but the judge can't say both people had access to that phone because she wants to control the perception, right?
The state moving
Her
from
attorneys,
place to
that's not
place
their
to
request.
place through those 108 pages, moving from timestamp to timestamp. The state chose to present that evidence in that manner, which is why
These
I
are
gave
Sarah
that instruction
requests.
to the jury that not the entirety of Exhibit 21 was provided to them as to what the state produced, and they'll have to have the opportunity to review that in its entirety when they go to deliberate. Do you have any questions about that so far?
So far, no.
Okay. The last portion, ma'am, pertained to the cadence or tone in which you and Mr. Torres communicated with each other. I have no knowledge as to how you and Mr. Torres communicated in text form as to what.
What the fuck did the defense ask that the judge is now addressing the tone of the text messages? What is happening? This is the defense passing the buck on to the judge. I think with Sarah Boone, maybe there's not much else you can do for client management. And I think the defense was just like, Your Honor, can we address these things? Which is why they are doing it at sidebar, even when the jury's out, because they're doing it at sidebar, even when the jury's out. But Owens, you tell her.
Tone in which you and Mr. Torres
Wild.
communicated with each other. I have no knowledge as to how you and Mr. Torres communicated in text form as to what the tone was behind those words. Your lawyer advised me that there was an objection and you had some concerns as to the way Mr. J may have read those text messages to the jury. I found that the way that he read them was benign, in a flat tone, and did not exacerbate or excite any of the language that was in there. He had read them in as a monotone way as possible in presenting to the jury.
Yep.
And I didn't notice any changes in his cadence or heightening or lowering in the volume or tense or tone utilized in presenting that information to the jury.
The judge is putting this on the record because the record will be silent as to this when, if she is convicted, there will be an appeal. And if there is an appeal, the record will be silent as to how the prosecutor read this. There's no way to know that. So the judge is now making a thorough record of, in court, the prosecutor read these as monotone as possible to read them into the record. That's why the court is putting this all on the record, because now we have a sidebar where Sarah had an issue apparently with the way the prosecutor read them in. And we are now making a thorough record for appeal, I think, at this point.
Do you have any other questions for me, ma'am?
No.
Anything else we need to address, Mr. Owens?
No, sir.
Anything else we need to address, State?
No, sir.
Your Honor,
Okay.
it's not fair. He read them.
How would we like to proceed with the charging conference? Do we want to bring back on our jury? It is 10:33 and advise them this is when we think you want to come back because we're going to be addressing the law to provide to you, and that's something I need to do outside of your presence. How do we want to proceed at this time?
I think, hopefully, at 10:33 to about noon should do it for 3.6F. It is convoluted, but I think
That's a
the
long
parties have narrowed
charging
it down to really just a couple of things.
argument.
Okay.
So I would suggest saying something along the lines of, we have to finish up getting the
It's a
jury
long
charge
charging
ready
argument.
for you. That's something that we have to do now after the evidence is concluded, and we'll see at 1.
I say 1:30, Judge, in your
Wow.
caution, because, Mr. Henderson, I know this is going to be an issue, and it's going to take a little bit of time, and then we want to go to lunch and give them a chance, because there's going to be a
You don't eat during trial, Owens.
speech session. I don't know if you give them.
I don't think that's healthy to do. It's just reality.
My statement, or how you do
We
that.
may, depending on just the time of it.
But from 1:30, that's going to go to 2:30, 3:30, 4:30. So just before 5, I think that's plenty of time in case he goes a little bit longer or I go a little bit longer.
And I still have to read the jury instructions as well. So, I mean, with 34 pages, and
It's gonna take an
read
hour?
quickly, as Madam Court Reporter will advise me.
Yes.
Yes, so once we make all these changes, every member in the box will have a paper copy. You, Mr. Owens, and your team, along with Ms. Boone, will have a copy. The state will have a copy. Madam Court Reporter will have a copy, and I will. And I will read line by line all the way up into the 2.7
Sarah.
instruction. At that point in time, I will stop. I will advise our jury that we're going to begin with closings. State will go, you will go, state will have an opportunity for rebuttal,
And then the
I'll
rest-
finish with the verdict and final instructions.
Yeah.
Discharge our
I
alternates
prefer
at
that
that
way.
time.
I prefer the
I'll go back and
pre-instruct.
thank them and give them their jury certificate forms, and then we'll release the jury. I'll have a final colloquy with your client, and then we'll review all the evidence to send back with the exception of the baseball bat.
And perhaps in case they haven't inferred, let them know that they're getting the case tonight, so make plans to stay later.
Yes.
What?
How late are you gonna keep them?
9 o'clock is
What?
the norm. I may, because it's the weekend and it's Friday,
9 o'clock is the norm? Florida lawyers, how do y'all do that? Look, man, LA County has a whole bunch of rules, and everybody's out at 4:30. Everybody's out at 4:30. Court reporters are off at 4:30. Sheriffs have to get everybody back to custody at 4:30. At 4:30, everything is done. And if you go like a half hour over in court, there will be bailiffs standing in the courtroom, like staring down the judge, being like, "TikTok motherfuckers, we've got to get everybody on a bus and get this courthouse shut down." 4:30 is a hard, we're done stop based on the sheriff's union, the court reporters union, and other court rules. It is done at 4:30. So at 4:30, you're like, okay, we can get some work done. 9? Law nerds, we're going to be here for Friday night. Just make plans. I will probably stop this stream and start a jury watch stream for later, since they're going to be there till 9. I mean, other jurisdictions let people deliberate on the weekend and just work through. I get it, but it's so strange to me. All right, well, at least we know 9 p.m. Eastern time is when they will let the jurors go through tonight. But the judge, I think, is about to say, but it's going to be the weekend, so I'll let them go longer if they want.
I may seek special dispensation from the chief to stay longer. I plan on communicating with the chief during the lunch hour as to that issue,
I think that would be great.
if she'll let me. I don't know if it's at her discretion. I
Right,
know
'cause
I
the
have to seek
sheriff's-
approval after 7. I'm not worried about that.
Back on Monday?
I know, and I would prefer them to work late into the evening if they're on board with doing that.
Owens wants to fly home because this legal team is not from the Orlando area and has to spend, it seems, their own money to stay. And Owens is like, I don't want to stay over the weekend. Owens is like, can we let them just work late? I want to go home.
Rather than coming back Monday. Okay, all right.
Wow.
If you all would be so kind to give me a moment so I can go back up to chambers, get with Ms. Barrios, and I'll give paper copies of everything from the revisions that we made this morning. Let's go ahead and bring back in our jury. And I agree with Mr. Owens. I'd rather us waiting on them than them waiting on us. So I think 1:30 is the way to fly. Let's go ahead and bring back in our jury.
Don't worry, we're not going anywhere. We are going to stay for what seems like it's going to be an extended jury instructions conference. I think it will be illuminating. We're going to go through the jury instructions on all the defenses. So those self-defense instructions are going to have a lot in here. So the jury's going to come in and get dismissed for lunch.
All right, thank you. All right, can you raise those hands one more time for me? All right, record reflect, hands have been raised as compliance with regard to the court's instructions. Members of the jury, all the evidence and testimony sought to be provided by the state and the defense have been provided to us over the last week. At this point in time, the state and the defense and I need to discuss the law to be given to you in instructions. That's going to take a little bit of time. So we're going to go ahead and excuse you at this point in time for a longer lunch break than what you've had previously. And we're going to ask you to come back here at 1:30.
Go enjoy
At that point in time,
the
the court
day.
will begin to instruct you on the law that you are to apply in this case. Then the parties will begin with their closing arguments. The state will go first, then the defense. Then the state will have the opportunity to rebut any of the defense's arguments. After hearing the closing arguments, the court will provide you final instructions before releasing you to deliberate in this matter. We may work past 9 o'clock tonight. We may go late into the evening. So if there are any plans or things that you need to reach out to, as we discussed last week during jury selection, that we could work till late as 9, and we may work later than that this evening. If there's anyone that
Guilty Pleasure in the chat said, could they announce a verdict today? I think all the parties are hoping, if they give the jury time tonight, that they will come back with a verdict today.
has any concerns as to working that late, please raise your hands at this time. Court sees no hands.
Oh, they're in.
I would also ask of you, if you could,
The juries are like,
please
"We
reach
ride."
out to any family members or friends to, one, advise them that you're on the jury and will be deliberating this evening. And if there's any accommodations or issues with minor children or family that need to be taken care of, I would ask you that you take care of that during our lunch break.
And the emergency phone number, since they won't have phones.
Yes, we will provide you, the court deputy will provide you the emergency phone number when we get back from lunch so that you can provide that during a break that we'll have this afternoon to any friends or family or loved ones if they need to get in contact with you. I will give you a similar instruction that I've given you over the last couple of days. I know you're probably tired of it, but I got to give it to you one more time. Jurors, you must not conduct any investigation on your own. This includes reading newspapers, watching television, or using a computer, cell phone, the internet, any electronic device, or any other means at all to get information related to this case or the people and places involved in this case. This applies whether you are in the courthouse, at home, or anywhere else. You must not visit places mentioned in the trial or use the internet to look at maps or pictures to see any place discussed during the trial. Jurors, do not watch local news or read local newspapers. Jurors must not have discussions of any sort with friends, family members, or even your fellow jurors about the case or the people and places involved. So do not let anyone make comments to you or ask questions about the trial. I want to stress again that just as you must not talk about this case face-to-face, you must not talk about this case by using an electronic device. You must not communicate, you must not use phones, computers, or electronic devices to communicate.
All the things.
Do not send or accept any messages related to this case or your jury service.
No YouTube-y things.
Do not discuss this case or ask for advice by any means at all, including posting information on an internet website, chat room, or blog.
I think we're
With
a
that,
chat
members
room.
of the jury, I thank you for your attentiveness, service, and sacrifice, and we'll see you at 1:30. Juror number 2 in the back. Yes, sir.
Question. So
Answer.
with the parking, we're going to be here for some time. Can we leave and come back and get restamped with a new thing?
He's like, can we go out to lunch? Like,
We will have you that answer when we come back.
Okay.
Madam Clerk's going to figure that out for you.
Okay.
All right, thank you very much.
He's like, we're gonna have a long lunch break. Can I just go home over lunch? Sir, they'll take care of your parking. It seems that the jurors have been on it. When they come back from break, the jurors are like, yes, we know the instruction. Yes, let's ride. He's like, can we work longer? They're like, yes, let's go. Let's go. Let's be done. The jurors seem invested.
Okay. Could you do that, Officer Jones? So I've been advised by, you know what, rather than double speak, could you just tell me what it was? Say it for the record, what it was.
If judges approve that they are to go off campus or out of the courthouse garage, they can come back and get newsstand cards and everything.
So they can leave this point during lunchtime.
He's like,
And I'll approve
approved.
that. So, State, anything else we got to discuss other than the jury instructions? Defense?
No, you
Okay, court's going to run upstairs, put the finishing touches on what we agreed to this morning. I'll bring back paper copies for everyone, and then we can continue the charging conference. At that time, court's going to be in a short recess. We'll be back as promptly as possible. Thank you.
All right, we're going to do a quick summary and then we're going to zoom so that we are back as they are back. So let's do a quick summary and then we will be back. I think we can zoom past their break. I think we have enough space for that. So let's finish the evidence, shall we? We are at a very early lunch break on day 6 of the Sarah Boone trial. The court advised the jury that they would be working late tonight, probably past 9 p.m., so that they may hopefully come back with a verdict tonight. Closing arguments are going to be after the lunch break, but we're not done yet with the jury instructions conference because the instructions on self-defense are going to take some work, and it seems like there is quite a lot of disagreement between the parties on what those instructions should be. The state ended their rebuttal case. The defense does not have a rebuttal case, and the state ended by reading in some of the text messages from a cell phone extraction, which were illuminating. Some parallel in time to some of the videos we saw from body cam yesterday. We don't know when the videos were taken of Jorge Torres from Sarah Boone, the vertical videos on her phone. We didn't have dates on those. The jury will have those extractions. You can see when videos are taken on the phone if the prosecution connects those together. But in those text messages, we saw things like George going to stay at his mom's house and them texting back and forth, and Sarah Boone saying, come over if you want your documents back, and sending a picture of the birth certificate, and then sending a picture of the birth certificate ripped up and saying, see, look at what you made me do. So we saw quite a lot of that behavior that we saw yesterday in the videos via the text messages, and more of that, I have your possessions, they are mine. We saw a text message where Sarah said, your birth certificate, your ID, even though they have your name on them, they are mine. I helped you get them. So it was quite a ride through text, including one that seemed to be a notes app pre-planned argument of like all the things she seemed to believe that he had done wrong, and then her arguments about them. And then that got sent to his brother and her ex-husband. The texts were quite a illuminating and wild trek through somebody's phone. So may you never be in court with all your texts being read. Mine would be fairly boring text between me and Dr. B. What's for dinner tonight? What time are you going to be home? Should we get tickets to go see Creed? It's probably the last like 5 text messages in my phone. See you soon. Going to bed now. So with that, we are going to zoom and get into the instruction conference. These instructions are going to matter quite a bit. How they tell the jury what self-defense is, how they tell the jury that plays in, can help or not. We've seen jury instructions go badly. So when the jury instructions are clear, I think it's much easier for the jury. And then remember, the judge did say that the jury can come back or will work past 9 o'clock tonight, Eastern time. So it looks like we're going to be on jury watch this evening. Don't worry, we'll do a verdict watch together. So we're going to zoom past the court break and get right into this charging conference. If you didn't already take a little bit of a stretch, then maybe we should just do that now. We'll just... ASMR Kitten asked, is 6 days a quick turnaround? For a case with a defense case of self-defense and a rebuttal, yeah, it's a pretty quick case. I've seen homicide cases go faster. I've seen them go longer. But with a self-defense and with experts, it's a pretty quick turnaround. Then again, Los Angeles court days are much shorter than these court days. These court days have been very long court days. So, all right, let's get us zoomed. We're only about 10 minutes behind on this jury instruction conference at this point. So, and then when the attorneys break, we will break for lunch and go from there. All right, so I'm going to answer questions.
But all the revisions that we spoke about this
I'll
morning
answer
have
questions in
been
the
included.
downtime.
With that,
So we're going through
I
this.
think that takes us to page 9 of 28 in the 3.6F instruction.
Katie asked a great question. How will we know if they come back with a verdict? I think the stream will be left up if tonight, and I will let you know on the Law Nerd app. So if you want to go to lawnerd.com, I know we can't all hang, but when we know they have a verdict, I will let you know in the app. But we will do a verdict watch, and if we we'll put a stream up so the chat can go, and then we will send a note in the Law Nerd app when we see that they have a verdict. Because again, when they have a verdict in court, I expect the cameras will go back to court and the jury will come in, so we can do that in real time. So we'll be working through Friday as well. Thank you, mods. Thank you, Team Baker.
The defendant's revised,
but we'll set up a separate stream for it.
To 3.6. Just for the court's clarification, is what is in page 9 of 28 of what was provided to the parties, is that the same as the separate defense 3.6F instruction?
Oh, the World Series does start tonight.
It was only provided for more convenience for you to copy.
Go Dodgers.
Got it. Okay, so should we be relying on the 3.6F instruction you, Ms. Henderson, sent last night?
Yes, sir.
Okay, all right. State, do you have that?
I have a digital copy, that's fine.
Okay, all right. Tell me when you have it pulled up in front of you, sir, and then we'll...
It's pulled up, and I had sent everybody the state's digital copy as well.
Okay, very good. All right. Let me pull up the digital copy that I have. Give me a moment.
Yes, sir.
Crispy Cookie said, can the jury come back with a greater charge? No, they cannot. The jury can't come back and be like, murder one, it's murder one. They can't do that. They can come back on second-degree murder, manslaughter, or that misdemeanor that the judge is allowing in as a lesser included. I don't disagree with the judge legally. It fits. I just think it's kind of wild. So, like totally said, hey, y'all, do we realize this was a 44-year-old woman texting? Yes.
All right, the court has the 3.6F instruction as provided by the defense.
No, we're back to our
As to the
OG
first
Friday night
paragraph,
streams.
It is a defense to
The fact that my kiddo has an away football game, which means they are not doing their halftime show, is why Friday night is not stressing me out. If it was their last home game and there was going to be a halftime show, I would be like, what do we do? Because it's getting to be the end of Bantober. We're almost at the end of Bantober. So
the crime, bracket S, bracket of second-degree murder and culpable negligence if the actions of Sarah Boone constituted the justifiable use of or threatened use of deadly force. What say the state as to this instruction? And should not manslaughter be included?
It should be second-degree murder, comma, manslaughter, and culpable negligence, even though culpable negligence doesn't involve an intentional act. But I'm not going to fight over that.
Okay. Any objection to that addition?
No, Your Honor.
Okay.
Judge?
Yes, sir.
Can I interrupt for just a minute? Because there's a special instruction that the state is requesting.
dude, that's not what they're talking about at the minute. Can you wait?
Yes.
And that goes, it's going to come before the self-defense.
When it was used in the previous case that I cited, that I used it in 12 years ago, it's part of the instructions in second-degree murder.
Yes.
Is where I would be requesting it.
And this is just so that we're all on the same page. Forgive me. This is the state's request for special jury instruction on causation.
Yes, sir. I suggest we table that for now and just get into self-defense.
Okay. All right.
we-
So we'll revisit the state's request at that point in time.
I'm with the state on this. It's like, counsel, can we go in order? It's like, wait, can we just this? No. Can we go in order? So the state's like, can we go in order?
So is the second or the first full paragraph is read, is that acceptable to the defense?
Yes, Your Honor.
Okay. Moving now to the deadly force definition. That seems to track the language of the proposed jury instruction completely. Any revisions to that state?
No, sir.
Defense. It's your instruction, so I'm assuming you've got no quarrel with it.
No, Your Honor.
Moving to the next paragraph, I also believe that that's from the Form 3.6 instruction. State, any issue with the third full paragraph?
So in my request, I struck through or threatening to use each time because the evidence doesn't support.
Because there's
that.
no threat,
What the
right?
evidence supports is she did actually use force. It wasn't a threat of force. So I think it's unnecessary and confusing and not supported by the evidence to have that clause.
That makes sense.
In each of the paragraphs where it's mentioned.
Response, defense.
Judge,
That
I
makes
have no
sense to me.
problem with that.
Yeah.
I was just, when I put it in.
No objection. Move on.
I just was going on some statements that the state had made and different arguments. So.
All right.
Just wanna talk
No
about
objection.
aggravated assault.
No
Okay.
objection.
So just so that I'm clear, you've got no objection to the removal of that language. So the third paragraph would now read, Sarah Boone does not have the burden of proving that she was justified in using deadly force. Instead, for you to find Sarah Boone guilty, the state must prove beyond a reasonable doubt that Sarah Boone was not justified in using deadly force. Is that correct, state?
Yes, sir.
Is that correct, defense?
Yes.
All right, very good. Yes, sir.
To make it quicker,
And Mr. Henderson, you don't need to stand up every time, sir. I appreciate it.
I'm sorry, but it's old.
I get it.
But it's out of habit.
He said, I'm sorry, but that's an old habit.
Judge, every time that comes up,
You lose it?
yes.
Understood. So then just, let's go back
Thank
to
you,
the
Mr.
title
Henderson.
then. Can we revise the title to 3.6F, justifiable use of deadly force, and remove that bracketed or threatened use language?
Yes.
It should just be used.
Okay, very good. All right.
I'm with you.
The next sentence, the law on the justifiable use of deadly force is as follows. Is that acceptable? State.
Just the strike through
Uh,
or threatening.
As I read it, yes.
Yep.
Is that acceptable defense?
Yes, Your
Well, that'll make things
Moving now,
faster.
Sarah Boone was justified in using deadly force if she
If.
reasonably
If.
believed that such force or threat of force was necessary to prevent A, imminent death or great bodily harm to herself. Is that acceptable to the state?
It's acceptable, just confirm that they don't want me.
Yes, confirmed, only what would be read would be A.
That's correct.
Okay, all right. Is that acceptable, state, with that understanding?
Yes, sir.
Okay, moving now to the next portion. Sarah Boone had no duty to retreat before using deadly force. I mean, my review of the case law, and I don't recall which one it is that if you're on your own home, you don't have to retreat.
My understanding of the facts was that she used force first by zipping him up in the suitcase and doing so that, one, she could make him feel like he had made her feel in the past for choking and cheating on her, and two, to give her a platform to be able to speak to him as a captive audience, and he would have to listen. Because she took the actions of an initial aggressor, it is our position that there is a duty to retreat caused by the initial aggression, as that is addressed lower in the jury instructions.
Response, defense.
Judge, I have a different view of the evidence.
Right.
I think what the evidence has said about the initial in the suitcase is that Mr. Torres was getting into the suitcase and positioning himself into the suitcase when Ms. Boone came down. There was laughter between the two of them. The suitcase was zipped, and it was a consensual deal. It was a consensual thing. She didn't use any threat or use of force at that time to zip him in the suitcase. Furthermore, during the demonstration and when they were demonstrating the suitcase and the zipping ability, I know time has passed, but I hadn't seen anything different to keep someone in there who didn't want to be in there. If someone didn't want to be in there, it would be almost literally impossible to zip that suitcase because how much force it took to zip that suitcase. So the evidence doesn't support it.
Doesn't support a duty to retreat?
Correct. Because what they're saying, going back even before we
I'm
had
not
stand your
tracking
ground,
his
just going
argument.
back to the Castle Doctrine, there was never a duty to retreat from your home.
So then if I understand your argument, you are not seeking to have this included then?
I am seeking,
Because if
I
you're
want-
saying she had no duty to retreat,
That's correct.
this talks about,
That she did.
hang on, let me just reread it. Okay, so I think I follow your argument. Okay.
what I'm saying is that it should be no duty to retreat, that Sarah Boone had no duty to retreat. That's what we're requesting. I believe the state's objecting to that and saying that it is a dispute, so they want the next paragraph as to the court. But there is nothing that showed at that time, because the state's arguing that she forcefully put him in the suitcase.
Response.
No,
That's
they're
a
not.
strong argument.
They're not
That's
saying
the state's argument.
they're not saying she forcefully put him in the suitcase. They're saying she zipped him up and had a reason to zip him up and wanted to zip him up.
We know what the evidence in this case is. The evidence that she provided was he got into that suitcase by himself.
And she decided to zip it.
Playing hide and seek, and he was inside but not completely hidden. The lid was flapping over him. She came over and zipped it shut, to whether it's 100% or near 100% shut. And it was all in fun and jest at first, but he did indicate, and we saw it on the video, image IMG_1062, Sarah, I can't breathe, Sarah, I can't breathe. He was being held against his will in that suitcase. That there is no requirement that she initially forced him into it or not. It's no different than two people wrestling and play fighting, and one person has another person in a headlock, and then there comes a point in time where I'm tapping out. Jorge Torres was tapping out, and that's on video, and it's in her testimony. It's uncontroverted.
Right, it's in the video.
There is sufficient evidence for there to be a dispute as to whether or not she was the initial aggressor.
But does
and
the
whether
law
that generates
require
a
her to retreat?
Quite frankly, it's undisputed evidence because it's uniquely only her testimony coupled with the video.
Interesting argument.
She restrained him in that suitcase on purpose and intentionally. And if you look at the elements of aggravated assault,
Makes so much difference when he leans near the mic.
our proposed jury instruction, that is exactly what was going on. She intended for him to feel fearful of an inability to breathe, to make it feel like he had made her feel when he had choked her. An aggravated assault is defined as follows: Sarah Boone intentionally and unlawfully threatened, either by word or act, to do violence to Jorge Torres. She would not let him out. She would not release the headlock when he indicated he could not breathe. At the time, Sarah Boone appeared to have the ability to carry out the threat. Well, the video evidence is res ipsa loquitur. He could not get out on his own. He could not get out on his own at 11:12.
I literally said that to Judge Abbott yesterday.
He could not get out on his own at 11:23 in the second movie. And quite frankly, he couldn't get out at 11:03 during the still photo as well. Element 3. The act of Sarah Boone created in the mind of Jorge Torres a well-founded fear that violence was about to take place. Absolutely. Sarah, I can't breathe. Babe, I can't fucking breathe. Sarah, shh, go fuck yourself. The assault was made with a deadly weapon, element 4. An object not designed to inflict bodily harm may nevertheless be a deadly weapon if it is used or threatened to be used in a manner likely to cause death or great bodily harm. Well, ladies and gentlemen, it did cause death, so that's not undisputed. So it's our position that she was the initial aggressor based on her testimony that we received in court, and that is going to put into play a duty to retreat, and that the parties can argue about that.
Anything further, Mr. Henderson?
Yes, Judge. I want to clarify this because the initial thing in getting into the suitcase, the act is zipping the suitcase up. That act of zipping the suitcase up was not done forcefully. The testimony was he agreed. He was in the suitcase. He was the one who got into the suitcase to begin with. He agreed. The suitcase was zipped up, and there was no argument at that time. All right,
so we have them.
Just by the demonstration that they gave, you could see somebody to get in that suitcase or not get out of it at that time wanted to be in that suitcase. And there's nothing to dispute what she says, that he agreed, she zipped the suitcase, and they both laughed and thought it was funny. Now, the next thing that the state goes to is an omission. It is not an act. It is an omission at that point in time where she's saying, when they say, oh, he can't breathe, well, she doesn't
do anything. She leaves him.
So they're saying, they're trying to make that an act when it is not, when she just did not let him out. It's different. And what we're talking about is just the duty to retreat at this time. We're not even talking about the other parts as the thing, but as to the duty to retreat, she's in her home. And at that point in time, when that act took place, she had no duty to retreat.
Here's what the form instruction says. If it is undisputed by the parties that the defendant had no duty to retreat, give the following sentence. Defendant had no duty to retreat before using or threatening to use deadly force. Instruction goes on to read, if the parties dispute whether the defendant had a duty to retreat, give the following paragraph.
All right.
Sounds like both of y'all, are disputing whether or not there's a duty to retreat.
Yeah.
So I think I have to, based on what the Florida Supreme Court's instruction to me is to give that second
the disputed paragraph.
State, anything further?
No, thank you.
Defense, anything further?
Just note the objection, but I understand the court's ruling.
Okay, all right. So the language in the red line from the defense as to Sarah Boone had no duty to retreat before using deadly force will be removed, and I will add in the state's proposed language which tracks the form instruction. Is there any objection? Do you want me to read that to you, Mr. Henderson?
No, I'll read it real quick, Judge.
Okay. And I just want to make sure we're all on the same page. That's the state's proposed revisions to the 3.6F on the top of page 2 of 7.
Yes. I'd ask that the court would read it.
Sure. Okay. if Sarah Boone was not committing any crime other than the alleged second-degree murder or manslaughter for... Okay, I will add that. Thank you. For which, so it'll read, if Sarah Boone was not committing any crime other than the alleged second-degree murder or manslaughter or culpable negligence for which the defendant is claiming self-defense or defense of others, and if she was in a place where she had a right to be, then the defendant had no duty to retreat before using deadly force. On the other hand, 1, if at the time Sarah Boone used deadly force, she was committing an aggravated assault, or if at the time Sarah Boone used deadly force, she was not in a place where she had a right to be, then the defendant had a duty to retreat. The duty to retreat means the defendant had the legal obligation to use every reasonable means to avoid any danger before using deadly force. The law does not require the defendant to retreat if she was placed in imminent danger of death or great bodily harm or imminent danger of the commission of, parentheses, applicable forcible felony, end parentheses, against herself, and it would have increased her own danger to retreat, or if retreat would have been futile. But if the defendant had a duty to retreat, and if she could have safely retreated but did not do so, then her use of deadly force was not justifiable. I do have a question as to the applicable forcible felony portion of that.
Assault.
That's for her, for the A and B that we already previously discussed, not for the victim.
That is correct. So then that sentence would be revised to, the law does not require the defendant to retreat if she was placed in imminent danger of death or great bodily harm, and it would have increased her own danger to retreat.
These are the jury instructions. So these are what the jury gets to decide. And
What
this
say
is
you,
how the jury decides.
Mr. Henderson?
Judge, on enter objection as to the instruction, as the state has included to get this instruction, an aggravated assault, which is not charged in the information.
State response.
Judge, I'm happy to hop up into that one as well.
Okay.
I understand what Martinez versus State says, and I'm sure you've all read the opinion. It's in my motions, and I understand what it holds. What it says all throughout the opinion is there needs to be an independent forcible felony. And then at the very, very end of the opinion, then it says there needs to be an independent felony charged. Why I'm asking for a special jury instruction, and I've made that request in writing, is because under the standard jury instruction that we are going through right now, it says, according to Martinez versus State, that the independent forcible felony needs to be charged. The whole purpose of this is you can't engage into a circular logic argument that defeats Ms. Boone's right to self-defense. So it would be preposterous to include in this jury instruction, Ms. Boone did not have a right to use justifiable use of deadly force by committing second-degree murder against the victim when that's the charged offense. But she, of course, would have the right to use deadly force to defend herself against the victim, and that would be correct. But what we have in this case, and what the state has alerted the court and the defendant to well before trial was, the evidence shows that she committed a separate aggravated assault. She, at the time that she had already zipped him shut in there, and again,
hit him with a bat.
Just because she releases that quote-unquote chokehold by sitting on the couch, she is exerting that force through distance because she's the one that zipped him shut. So she, in using that force, is the one who did that on purpose to make him feel like he was choking and make him feel like he had made her feel like when she was getting cheated on, and to intentionally confine him in a place so that she could speak to him about her thoughts. As I already outlined, it's the state's position, and the evidence does support that this is an aggravated assault. She intentionally
Confined
put him
him.
in fear of death.
Why don't you just use
She
the false
relished.
imprisonment?
She relished it for that 2-minute video.
Why not have such a fight?
That is prior to when she says, well, now he's sticking his fingers out and I get scared by that action. And by that action, it's Jorge Torres just trying to exert the will to live and to survive and be on this earth. That now that action, if his attempt to escape out of the suitcase that she has left him zipped up in is this independent threat of great bodily harm and death to her. She testifies if he gets out, it's her belief that he will beat her up, kill her, disfigure her, so on and so forth. And her testimony at trial, I believe she said was, he said that I will end you. So what we have here is they, by their own admissions, through the testimony that she provided, that there is a separate and distinct independent forcible felony from what ends up being the second-degree murder. What ends up now being the second-degree murder is at this point in time when she says, well, he's trying to get out. I'm afraid if he gets out, I'm going to get disfigured or killed. And so that is why Ms. Boone makes the decision, and I'm not even going down the aggravated battery path, but she batters him with a bat on the hands and batters him, pokes him.
Isn't false imprisonment a forcible felony? Can't you just use that?
Basically beats him into submission so that he stops trying to escape. That's what the testimony was. And then she makes the decision to now leave him
We'll catch up
and go
when we get to the end.
upstairs and go to sleep without having relieved him from the force that she exerted earlier committing aggravated assault. So like the example I gave you earlier, this is absolutely no different than me pointing a gun at you, Judge, and putting you in fear of your life that I'm going to shoot you and a projectile is going to enter your body and kill you or give you great bodily harm. And you, in turn, after having been placed in fear by me pointing a gun at you, you begin to defend yourself and exert your right to live on this earth by pulling your own firearm. And now, do I, as the initial aggressor, the initial person who committed the forcible felony of aggravated assault on you, under the law, I don't have the right now to defend myself against you. I need to retreat. I need to make it clear, sorry man, my bad, drop my gun and walk away. That is what is the law. 776041 is a very short,
So you're saying George's
very simple statute.
fingers at that point, she should have
And it has not
retreat.
changed since
What?
2014. This has been the law. This was the law at the time of this offense in 2020. 776041 provides, the justification described in the preceding sections of this chapter is not available to a person who, 1, is attempting to commit, committing, or escaping the commission of a forcible felony. So taking away the firearm example, it's a chokehold. His cause of death, according to the medical examiner, was asphyxiation by position. And
So here's the problem that they're having. Sarah Boone is asserting self-defense. But the victim has to do something for there to be self-defense. And Sarah Boone has to do something for there to be self-defense. So they are trying to better define the do something because it is an incredibly unique situation that the do something is zipping him into the suitcase, or as the defense is arguing, leaving him in the suitcase. So they are trying to narrow down what the jury instruction should read because this isn't a regular contemplated fact pattern. This is not how you generally see self-defense. So they are trying to figure out how to determine what the jury instruction should say because this is an incredibly unique set of circumstances. And so it's not as clean cut as other circumstances. So that's why he's trying to analogize the suitcase to a chokehold and use the analogy of if you pull a gun on someone and they pull a gun back, you now have to retreat versus if someone pulls a gun on you, and that's why he's making those analogies, because that's what the law normally sees in self-defense cases. This is different. So now they're arguing over whether or not the language of the jury instructions can be a non-charged offense, so they don't end up in like a boot loop of she was right to defend herself when she did X. So that's where we are trying to figure out what the language is, because the circumstances in the case are so unique. And that's where you see the argument over whether her act was the zipping or the leaving. And the law the attorneys and the judge have to figure out what the instruction's going to say.
And environmental suffocation.
Because that
caused
instruction's
by
going to be given.
Her not releasing a chokehold on him when he indicated, babe, I can't breathe, Sarah, help.
That's why he gave the tap out.
That is an independent forcible felony, separate and distinct now from what she says is the victim, like you, pulling a gun to defend yourself from me pulling a gun on you. Now, the threatened use of force that the victim is exerting is sticking his hands out and saying, I'm going to end you. That is the distinct break between the aggravated assault and now her continuing to use this unlawful force, which she's not entitled to do because she started it. She was the initial aggressor in committing this aggravated assault.
I don't know if that counts.
And
That's
she
the
ends
problem.
up just leaving him to die and never releasing the chokehold.
And the unlawful threat is what's on the video in your realm.
Yes.
Okay.
And any facts that support that should cause this jury instruction to be given. The absolute only hang-up about whether or not this jury instruction should be given is because Martinez slightly overstates what is necessary to prevent this circular logic, which is not going to occur in this case. There is not going to be any arguments by the state that she does not have the right to defend herself if she is in imminent fear or death of great bodily harm by the victim. She tests out of the suitcase and saying, I'm going to end you, put her in fear of imminent death and great bodily harm. And in turn, what she did was she decided to not let him out. And he ended up dying. And that is second-degree murder. That is separate than what preceded that. What preceded that was her not letting him out when you can see him pushing up on the suitcase in the video, begging to get let out, and she doesn't because she is doing this out of anger, hatred, ill will, and spite to teach him a lesson and put him in fear of death or great bodily harm. That's an aggravated assault. I would absolutely charge her with aggravated assault and aggravated battery, separate independent forcible felonies, if I could. But I did not learn this information until after the statute of limitations had passed. That is through no fault of the state's. So we absolutely would, if we could. And we are not going to make the argument and defeat her defense of second-degree murder by saying, well, you can't defend yourself with second. I understand what they're getting at in Martinez. That's not this case, though. It's broken down into those parts.
Can I have the citation for Martinez? Because unless I missed it in your motions, I didn't see Martinez cited in the motions.
I'm sorry.
And forgive me if I...
No, it's been in previous motions.
Again, it should... I think they can conform to proof.
With regard to the Miranda.
But if there's a statute of limitations issue, there might be a statute of limitations issue because this is 4 years out for false imprisonment as well. But what the prosecutor is saying is, look, we have to formulate a self-defense instruction. The defendant has a right to a self-defense instruction. But if we put the second degree murder in the self-defense instruction, it becomes a circular loop of, saying she was not justified in doing the second degree murder when she used self-defense, and that defeats the purpose of saying the self-defense negates the second degree murder. So everybody's on the same page if they are trying to formulate an instruction that allows for self-defense in light of the case law Martinez that they're citing, but they don't agree with how they articulate it. So the prosecution and defense are both working to make sure the self-defense instruction makes sense. They're not working really against each other in this. They're trying to figure out the cleanest way to do it is what they're doing. So that's where they are trying to figure out how it is lawful so that this does not become an issue on appeal, that if she is convicted, then this jury instruction becomes an issue, because jury instructions are one of those top things that can be an issue on appeal that can warrant granting a new trial. If you do the jury instructions wrong, a new trial can be granted pretty easily by the Court of Appeals. It's like, you did that wrong. Go away. So this is really deeply nuanced and it's hard. They're all looking at the instructions. We are not, but this is a deeply nuanced argument about what the language of the jury instruction should be.
The issue.
No, I am referring to.
So they're talking about the
There's
Martinez
a
case
pleading
law.
entitled State's Request for Forcible Felony Instruction and Request for Initial Aggressor Instruction, which we've kind of popped into now since aggravated assault.
For
was being
those of you in the
mentioned
chat, I do
paragraph.
not poll on verdicts.
In
At some point, I will poll on how long the jury might be out, but I do not poll on verdicts. That is for the jury to decide, not us. So it is my choice not to poll on verdicts. We also haven't heard closing yet. I think people have made up their mind, but we don't poll on verdicts, and we generally block those words in the chat as we get closer, so there are no spoilers. But we will poll on how long we think the jury will be out.
paragraph.
There it is.
And no, these
Yeah,
Amy
paragraphs 12
Amy asked
through,
if these could have been done earlier. No,
31 are the
The
legal
evidence has to
analysis,
come
and
in.
Martinez is cited in there.
and they've been going top to bottom
At
on court
paragraph
days.
19 at
There really wasn't other
981,
time.
Southern 2nd 449, Florida 2008. And more importantly, what Martinez doesn't say is that there's like some requirement that the verdicts would be interlocking. Like there's no requirement that second-degree murder be count 1 and aggravated assault be count 2, and then if they return a not guilty verdict on aggravated assault, then there has to be a not guilty verdict on the second-degree murder. That's not the case, because there's so many different prongs to the self-defense instructions. So it's not required to be charged for some reason of an interlocking verdict. And the whole spirit of that opinion is that it is to make sure that we do not defeat her self-defense argument that she's entitled to make about why she committed second-degree murder. All we're saying is you're not entitled to defend yourself in that manner if you committed an aggravated assault to start this. And that's what the facts show. It's a little complicated, and there's another special jury instruction related to this force by distance. It's like tying somebody to some train tracks and walking away. I mean, are you still choking the person? No, but are they restrained in a manner that if a train comes, they will die? Yes. So the special
Wouldn't that
circumstances
be a false
of this
imprisonment?
case and the facts are going to warrant, in the state's estimation, the forcible felony paragraph, and then that language being placed into this initial paragraph that we're talking about.
Reading Martinez, give me a moment.
Yes, sir.
And I'm pulling up the motions, but they don't have the instruction
And
attached.
just for the record, the 3 prongs for a special jury instruction, which I cited in a couple of my other pleadings. A special jury instruction is warranted when A, the special instruction is supported by the evidence.
That is in his pleadings.
Is the case. It's in fact undisputed since there was only one person there. B, the standard instruction did not adequately cover the legal theory it is meant to. That is also true. And C, the special instruction was a correct statement of the law and not misleading or confusing. That is also the case. Stevens, Stephen's versus State, 787, Southern 2nd, 747, and I mistakenly put 657, I imagine.
I think it's 755 is the pinpoint.
2001.
Yeah, I reviewed that already. Thank you. Response.
Response is clear, Judge. They're trying to make exceptions for the law. That doesn't work here.
So
Simply
what do you
this.
want to do?
What the requirement is under Martinez to get the aggressor is this. It's only applicable and only in cases where the defendant was charged with either an independent forcible felony, that's Martinez, or B, felony murder. That's a different case. And Martinez, they have not charged an independent forcible felony.
No, they haven't.
So it doesn't apply. It tells us right there. That's the standard jury instruction.
So what's
For
the
him to
solution?
come back here and say, well, really, Judge, they overstated Martinez. Martinez is still good law. It has not been changed. That's the rule. That's the requirement.
But this is relying, the Martinez opinion states, indeed, consistent with this case law in 2006, we approved an amendment to the self-defense jury instruction to specifically provide that the forcible felony instruction should be given, quote, only if the defendant is charged with more than one forcible felony. That doesn't seem to be what the new instruction says, unless I'm missing something.
Oh.
I'm sorry, can you repeat that?
Sure. The sentence says, indeed, consistent with this case law, in 2006, we approved an amendment to the self-defense jury instruction to specifically provide that the forcible felony instruction should be given, quote, only if the defendant is charged with more than one forcible felony. And unless I'm missing something, a 3.6F instruction doesn't say that now. The form instruction.
Did defense give the older
When it comes to the
version?
aggressor in the standard jury instructions, when it comes to aggressor, and they're talking about under 776.041 sub 1, it's to only be given if and only in cases where the defendant is charged with either an independent forcible felony. You cannot give this instruction unless there's an independent
It said
forcible
more than-
felony that Ms. Boone has been charged with, and there just isn't one.
But where does it say that in the form instruction?
The judge is saying that
Yes.
It's page 1428.
That the updated form instruction doesn't say that.
776041, 1.
Is that under the initial aggressor?
Only in cases where the defendant is charged with either A, an independent forcible felony, Martinez versus State, 981-449, Florida, 2008.
Hang on.
Or the felony. And we're acknowledging that. But when you look at the case and what it is stating is the purpose of that is there has to be in the evidence an independent forcible felony. And that is what occurred in this case. She committed an aggravated assault. After that, the defendant is saying the victim placed her in fear of imminent harm or death by trying to escape her aggravated assault, by sticking his fingers out, and by saying, as he's trying to escape, I'm going to end you.
But isn't that in the giving the aggressor definition? Is that, but unless I've missed something, that's not what we're talking about right now.
I agree, but I think it cohabitates together.
Okay.
Correct. And it's our position, we absolutely would charge her. And it's a legal technicality and part of this standard instruction that we can't because of the statute of limitations.
Right.
We all know,
But-
all of us here together as attorneys know that those facts, if believed by the jury, support that she violated Chapter 776041, 1. She should not be able to get away with murder because of a statute of limitations technicality that was through no fault of the state's own. The purpose and spirit of
I mean,
Martinez is
you
to make sure
should know what the
that
jury
none of
instructions
there
say,
are
though.
any- Ladies and gentlemen of the jury, she had no right to defend herself from an imminent threat of harm by killing somebody. That's not what we're going to say. We understand that. What we are going to say is, ladies and gentlemen of the jury, she had no right to leave him in that suitcase out of fear and great bodily harm or imminent death because she committed an aggravated assault to put him in that predicament.
And the
That's-
defense is saying,
that's
no,
the
she
evidence in
didn't.
case
The
that
defense is saying
Department
zipping him up is not an aggravated assault.
That's why we're making a special instruction request based on the unique facts and circumstances of this particular case.
For those of you in the chat saying this is a great law school exam question, it might be. But I see what the issue is. And I don't know how they are going. This is why jury instructions are so important. How they navigate that is going to be interesting. Ian, that was me sighing. That was not the judge. That was me. That was me. But the judge's face is also me. He's just like, huh. Astiana in the chat said, wait, no, that's the wrong one. I'm gonna get to that one. I don't know if Florida has a false imprisonment leading to death charge. They didn't charge it here. And there was another question about her firing her attorneys and whether or not that ran out the statute of limitations. She didn't fire her attorneys. She asked for them to be fired. Most of them quit. Some of them had conflicts and bounced, but they quit. So closings should be at 1:30 p.m. We'll send out an update in the Lawnard app when they are getting ready to get started.
The language in the instruction in pertinent part says he or she was committing an act, insert the defendant's criminal activity that the defendant act, but the criminal activity cannot be the charged crimes for which the defendant is claiming self-defense or the
That's the
defense of
problem.
others. The charged crime is second-degree murder. So I'm struggling with understanding
What the
the
criminal
other
activity
crime is, because I'm not hearing any argument as to the applicability of aggravated assault.
Judge, because, and I didn't make any argument about aggravated assault applying because they can't get over the first hurdle. The first hurdle is it has to be charged. It's not charged. That's what the case law says. I mean, this is pretty clear to me unless I'm looking at it wrong when it says this is not to be given if there isn't an independent forcible felony charge.
I mean,
Any other response, State?
Just that it defeats the purpose of the statute and is manifestly unjust when it is a legal technicality of no import. There is no interlocking verdict required. If we were able to charge aggravated assault, there's no requirement that they both be
can you just
found
conform it
guilty.
to proof?
They can
No, because
go
our
ahead
statute
and
has
hear this
passed.
instruction and find her not guilty of aggravated assault and still convict her of second-degree murder because of all the plethora of permutations we have in this instruction.
But in Martinez, the underlying charge was attempted murder and aggravated battery, both of which were charged, and we don't have that here.
Buttercup said the judge has to read
But
the law
it's still
first
going
before
to
closings.
the
Yes.
Act and of those facts. We are talking about separate, clearly distinct.
This is going to keep going. This is why they needed this much time for the conference. The jury instructions must be done before closing because the lawyers will argue them in closing. But the judge can give the instructions either right before they close or right after. But this all has to be done before they close because they have to know what they're arguing. And the language of the jury instruction can be a big part of closing. The nuance of this instruction is circular, which is where they are having problems is that the felony act, if it has to be a charged crime, you can't just say zipping the suitcase. But the felony act needs to be listed, but it can't be the crime that self-defense is being asserted to. And she's not charged with anything else. And that's why they're going round and round.
Facts here that support there's an aggravated assault that separately gets committed first, and then in response to the victim responding to that aggravated assault, she leaves him in the chokehold to die because if she lets him out, it's her belief she's going to face death or great bodily harm because she committed a forcible felony.
I mean, none of it's a problem if they don't give all the self-defense instructions, but that's not going to happen.
This is purely a legal technicality.
I mean,
the entire opinion on Martinez.
Sir, courts of appeals love nothing more than a legal technicality. They're like, ding, that's not correct. So, this is an interesting
Until
problem.
The very last paragraph uses this language.
If the law says she has to be charged with it before it can be listed there, I don't know how you get around that. But the judge also says that that's not exactly what this instruction says. And you can see that the judge is like, This is an interesting problem. That's his, this is an interesting legal problem face. Because it is. So like I said, why does she still use her ex-husband's last
They
name?
use language like the
I would
underlying
imagine it's
facts
'cause
of
it's
the
also her kid's
present
last name.
case demonstrate why it would be illogical to conclude that section 776041, paren 1, applies where there is no independent forcible felony. It doesn't say where there is no independent forcible felony charged. It goes on and uses that same language all throughout the opinion, and then in the very last paragraph in the conclusion, it changes to, in conclusion, we hold that it is error for a trial court to read the forcible felony instruction to the jury where the defendant is not charged with an independent forcible felony. But there is an independent forcible felony in the facts. There is a statute that says that Ms. Boone should not be able to get the avoid the girth of this jury instruction.
Sir.
She violated, according to the facts that she...
Do not come up in here calling the jury instructions girthy. And I saw some of you chatting about whether it was Sarah Boone's money. She had a fairly large, it seemed, buyout of the marital home at the time of the divorce. At the time of the divorce that she was mostly living off of was the buyout from the marital home, which is how she was mostly maintaining her life, because she was only getting about $1,000 a month spousal, but she was living off of that buyout of the Winter Park marital home. So at the time she got divorced, there was some money.
She violated 776041, paren 1. She was committing an independent forcible felony, and therefore should not be able to get away with this instruction not being given, because the technicality that the state can't charge a case or can't charge a count that is not required to be interlocked by verdict. Thank you.
It's a hard argument. And it seems like the judge is contemplating this a different way. Yep. That is the judge's, this is a difficult problem face.
Footnote 4 provides, explanation in the Martinez opinion as to certain circumstances and whether or not in that hypothetical that the Supreme Court gave, whether the robbery is a separate and independent forcible felony and the forcible felony instruction is applicable. But the conclusion seems to state that it has to be charged, that it is an error for the trial court to read the forcible felony instruction to the jury where the defendant is not charged with the independent forcible felony.
And that's what the defense said. It seems that that's what the law says.
Anything else, Mr. J?
Yeah, I don't think you get it.
Then how do we want to accomplish this? Because I don't know how I can read the proposed language by the state. And there's a disagreement as to whether there's a duty to retreat. It's not undisputed. It is, in fact, disputed.
Well, their complaint is in the sentence, on the other hand, if at the time Sarah Boone used deadly force, she was, and I just think you strike through committing an aggravated assault. And go to, if at the time Sarah Boone used the deadly force. Okay.
Francis in the chat said, charge her then, question mark, the statute of limitations is passed, so they can't conform the charging document to proof at trial because they are outside the statute of limitations for almost, I would imagine for most things, because for most things it's going to be
Unless
3
you just
or
want to
4.
go to 2. On the other hand, if at the time defendant used deadly force, she was not in a place where she had a right to be, then the defendant had an obligation to, or excuse me, then the defendant had a duty to retreat.
She had a right to be
excise
there.
1 completely. I don't know what else to do.
But she had a right to be
Right.
there.
Under the Castle Doctrine and the case law.
And the jury's going to be like, she had a right to be there. That's her house. He's not on the lease.
Okay, then I think we go with the first paragraph and then we just deal with the initial aggressor at the end, which is kind of the exception to that. So
Okay, so then
Sarah Boone
Sarah Boone had no duty to retreat before using deadly force.
Yes.
Okay, is that acceptable to the defense?
Yes,
I think it puts us back in the position where we started at anyway.
yes.
Okay, all right.
They just simplified what they are going to read. That Sarah Boone had no duty to retreat before using deadly force.
Attorney General wants to potentially prosecute us.
Objection noted. It looks like the next parts of the form instruction, if the defendant was in a dwelling, was excised, the give A, B, or C was excised. Are you on board with that state?
Yes, sir.
Then the next paragraph, a person is not justified in
And moving
using
on.
force to resist an arrest. Clearly, that's not applicable. I don't think that's at odds.
So they're narrowing down the
However,
instructions
if an
now.
officer used excessive, I also don't believe that's applicable based on the facts. We then proceed to the given.
I've seen lots of requests to explain. They were going round and round and round on the nuance of a duty to retreat instruction. And at the end, under the case law and under the jury instructions, they were not able to accomplish what the state was asking for. The state was asking for the weird thing, not the defense. And because of that, they ended up simplifying the instruction because this is self-defense, talking about Sarah's right to use force and saying she did not have a duty to retreat before using deadly force because she was in her own home. However, I don't know if any of that's going to matter to the jury because she zipped him into the suitcase before she thought she was threatened. So at the end of the day, I think this is a lot of legal wrangling for something that the jury is going to be like, yeah, no, that doesn't apply. But they have to go through all of the jury instructions, and the state has asked for some special instructions, which is not necessarily a given, and they did not get that part of the special instruction. They got a more limited version of the instruction to conform with law because it would have been error to do it otherwise. So that hopefully narrows it down.
In all cases,
So now they're moving on.
language. Any objection to this language state? Sure.
I
bottom
don't
of
know if
page
this is
2
going to
of the
matter to the jury
defendant's
much at all because he was already in the
3.6F
suitcase.
red line.
So because he's already in the suitcase, he's already in the suitcase. The jury's going to be like, well,
On the
he's
form
already in the
instruction, it's
suitcase.
the bottom of page 3 of 7.
So I don't know if the jury will
Given
care
all
about duty to
cases,
retreat.
Right after Jackson v. State.
It's not really a duty to retreat
Yes,
case
the agreed upon strike terms of or threatened use.
because she says she feels threatened after he's in a suitcase.
Deadly force, you must consider the circumstances at the time.
Look,
Any objection?
if the jury is like, he was already in the suitcase, girl, you're not threatened, none of that argument is going to matter to them at all.
No objection to that, Judge.
We'll excise the threatened use, so it'll all read use of deadly force in that paragraph.
Yeah, there's no threatened use. That should be out on all the instructions. They talked about that a bit earlier to make the language all conform. What you don't want is internal inconsistencies in the jury instructions where it says something one way in one place and says something
Now we have a
one way in
proposed
another case.
instruction,
Oh, yes, apparently I'm hiding
I believe,
Owens.
from the defense regarding battered
The rest of the
spouse.
defense team is down there.
Table the battered spouse proposed instruction since both parties have that.
Sure. Moving now to the presumption of fear, that's been struck out by both parties and agreed to. Moving to the exceptions of presumption of fear, that's been struck out by both parties and not necessary. That takes us to
It might be one of the
a
other
person
things.
who unlawfully by force enters or attempts to enter, that's not applicable. Definition of dwelling is not applicable.
that the other
Residence
guy?
and vehicle are not applicable. That takes us now to
That might be
the
the other dude.
aggressor language.
The rest of the defense team is outside of camera
No
view.
additional arguments as to why the facts show she was the official aggressor, and thankfully for the state, there's no requirement under this provision that there be an independent forcible violence.
Okay. Looks like we have a disagreement between the parties as to the application of the aggressor instruction. It's
I
struck
bet you
out on
do.
the defense's side and not in the state side. What say you, Mr. Henry?
We are now getting into argument of the initial aggressor instruction. The defense, be shocked, has stricken that from their jury instructions. So the defense struck out initial aggressor. The prosecution is like, no, that's a no. Yeah, we're going to need that instruction. So now we're going to argue over the instructions. Southern Belle said, so she's justified in killing him? No, they're just arguing over the instructions. None of this makes any determination on the facts of the case. The jury decides those facts. They are arguing over what the jury will be told. So this is not a judgment call. This is just, how do we explain the law? And the law of self-defense can be incredibly complex. How do we explain this law to the jury so they can make a decision? So they are just arguing what law applies and how do we explain it? So that's what they're getting into now. And they're going to get into argument over initial aggressor instructions and how to tell the jury about the fact that they can consider that.
Anderson.
Give me 1 second.
Sure.
Please.
Yes, sir.
Vegan Lawnard in the chat asked how the Lawnard Lounge in the app and the YouTube membership were different. The Lawnard Lounge has more community chatting and more community sharing. It's more like our own special little chat group, but you still have access to all the YouTube videos, but you don't get the slow mode that you get here because that's a YouTube feature, and the badges here, that's a YouTube feature. Though we do have some things similar that will be app specific because those two things don't cross over, but you still have access to all of those videos and what have you. You just don't have the highlighted name and the icons here. The judge is pulling up instructions. We're going to
041,
zoom till
17.
they're talking.
Yes, sir.
Okay. If I could have one more.
Yes, sir.
I like that one of the other attorneys is sitting with Sarah to explain kind of where she's at. So the attorney making the arguments is not also trying to explain to Sarah. Very, very helpful.
That the only, Judge, my argument would be that the only evidence, the evidence from Sarah Boone stated that she did not do anything forcefully wise until after Mr. Torres had made verbal threats and was coming out of the suitcase. So that's my objection is based on that. No other legal argument.
Any other argument state?
Oh, he's kind of acquiescing.
Play wrestling and not releasing the chokehold when your buddy tapped out.
And I mean, isn't there evidence as to what Ms. Boone had told the experts, which seems to be at odds with that issue, and it's really a factual issue and a determination for the jury to make that determination
That's gonna
on
come in.
what the real facts are?
You heard the defense say, it's this, no further argument. That's kind of an acquiescence.
I can't disagree with that.
Okay.
Yeah.
Then
He's
with
like,
regard to the proposed language as the
So that's gonna come in.
706.041 sub 2 instruction, however, the use of deadly force is not justified if you find that Sarah Boone was attempting to committing, or escaping after the commission of aggravated assault. An aggravated assault is defined.
sir.
No.
No?
That's the friend one.
Yes.
Am I on the wrong section? I apologize. I am at the wrong section. Forgive me. So it is the, however,
With my strike throughs, it's however, the use of deadly force
is not justified if you find that Sarah Boone used force to initially provoke the threatened use of force against herself unless, one, the threat of force is
I'm going to back this up. This is going to be the jury instruction on initial aggressor that will tell the jury, you can decide that Sarah Boone's use of force is not justified if you find she provoked the force. And in this case, she's saying the force are his words and his, she described them, little fingers coming out of the suitcase. So this jury instruction that the judge is reading, and I'm going to back up so we can be like, hey, let's read this. This is the instruction that says, if you find she provoked it, before Jorge Torres said, I can't breathe, let me the fuck out of here, and the rest of it, then you can disregard her use of force. So let me back that up because it's helpful to hear the language from the judge. And now we're at the point where the judge is reading this instruction in this is the version that's going to come in.
after the commission of aggravated assault.
Nope, that's
And
not the right
aggravated
one.
assault is
No.
No?
This one. So
Am
this
I on the
is
wrong
an important instruction.
section? I
for
apologize.
the
I am
state.
at the wrong section. Forgive me. So it is the, however,
With my strike-throughs, it's however, the use of deadly force.
is not justified if you find that Sarah Boone used force to initially provoke the threatened use of force against herself unless, one, the threat of force asserted towards the defendant was so great that she reasonably believed that she was in imminent danger of death or great bodily harm and had exhausted every reasonable means to escape the danger other than using deadly force on George, that's spelled incorrectly, Torres, or two, in good faith, Sarah Boone withdrew from physical contact with George Torres as clearly indicated to George Torres that she wanted to withdraw and stop the use of deadly force, but George Torres continued or resumed threatened use of force.
Yes, sir.
What's
So-
your, just for clarification purposes, anything else as to that instruction, defense?
Just one thing I need to put on the record, Judge.
Yes, sir.
The force at that time, as testified to, was the poking of the bat on the
That was
outside of the
after.
suitcase. There was one strike when the hand was outside. These were bruises. I think there was something that came to the injury to the head area, though. The injury to the head could be serious, but in this instruction, it's talking about deadly force. And none of those, as to the testimony from the medical examiner, none of those injuries caused the death.
The suitcase was the deadly force.
The continued restraint.
The confinement.
On him that she did not undo is the force that we're talking about. It's just like in the cases that I cited in my special state's request for special jury instruction regarding withdrawing.
No state,
contacts.
chat.
Batteries don't need.
The clerk of court who is working very hard on jury instructions is printing things out. So you can hear the printer in the background. That's the kind of mechanical whining. That is the printer in the courtroom running.
To be skin to skin.
Courtrooms are
Get
busy.
a battery on somebody while driving your car and striking their car. A false imprisonment does not mean you have to choke somebody. You can falsely imprison somebody by barricading them into a room with a grocery cart. She unlawfully exerted that force and did not withdraw from using that force when her wrestling partner, so to speak, tapped out.
He keeps using that analogy because it's in the case law. I've seen a couple people ask, why wasn't this a kidnapping? Most states require some distance of movement if there's a kidnapping. So moving someone from this location to that location, and that was not done here. So more like a false imprisonment. They didn't charge false imprisonment. I don't know why they didn't charge false imprisonment, but more of a false imprisonment. He was asking to get out and she wasn't letting him out.
Okay. I'm going to include the instruction for now.
Yeah, I think it's
The
an
next
appropriate
paragraph
instruction.
reads, if you find that Sarah Boone, who, because of prior threats or difficulties,
No objection to the state.
all right, that'll be included. The next paragraph, if you find that at the time of the alleged aggravated assault and or criminal mischief,
Yeah, there just needs to be secondary murder, manslaughter, or culpable negligence, and we don't object if there were specific acts put into evidence.
any objection to changing the beginning of that sentence, defense, if you find that at the time of the alleged murder in the second degree, manslaughter, culpable negligence, Sarah Boone knew that George Torres had committed an act.
Yes.
Okay, thank you.
And we requested the strike through at the end or threatened to use.
Agreed.
Give me a moment.
All right, the judge is going through the next.
So that sentence would now, or that section would now read, if you find that at the time of the alleged second degree murder, manslaughter, or culpable negligence, Sarah Boone knew that George Torres Jr. had committed an act or acts of violence, you may consider that fact in determining whether Sarah Boone reasonably believed it was necessary for her to use deadly force. Acceptable?
Yes, sir. I just don't know that we use Junior after his name anywhere else.
So they're trying to conform it.
To you, Mr. Henderson.
Yes, Your Honor.
All right, moving to the next line. If you consider that George Torres, removing Junior, had a reputation for being a violent and dangerous person. I don't know, did we hear evidence of reputation?
No.
The state's position is going to be there was no reputation
No.
evidence. Ms. Boone offered an opinion, but as
We did not.
reputation evidence has to come from a broad enough aspect of the community, whether it be a church or a neighborhood or perhaps even a large family. But
Defense?
I'm rethinking that, Judge.
No worries, take your time.
I'm rethinking it. Big reputation. We did not hear reputation for violence. We heard Sarah's statement that there was violence
generally-
between them.
And reputation evidence, generally, it has to be something that is known.
Fancy, yes, we're still in the jury instruction conference. It should be noted in the pinned comment.
I know the only thing that I can relate to is the fact that individually, she experienced certain things that could build that reputation, but that's unheard. I
She's
think
the
there's
defendant,
evidence, though, from people, at least that they knew about it or were told about it.
From
Most of
her.
that was stopped. But I could go to at least the one.
Brian Boone said she was the aggressor.
On a text
So,
message
you
that
know,
was introduced earlier today.
I mean, that was hearsay,
that
but
talked about him beating his former wife or ex-wife.
that was
How's
not
that
proven.
reputation?
Thank you.
It sounds like that's a specific instance based on that text message.
Correct. I agree.
Okay, so in agreeing, we're going to excise the reputation section, correct? Okay, thank you.
The defense is like,
Court will excise
yeah,
that.
there's nothing I can do with that.
the physical abilities that's mandatory.
You have to just kind of acquiesce at that point.
What about the one that precedes that? If you find that George Torres had a reputation, well, also that reputation would be removed as well, correct, Mr. Henderson? If you find that George Torres Jr. had a reputation for being a violent and dangerous person, you may consider this fact in determining whether he was the initial aggressor.
Chat, I will be
Okay, so that'll be
right back. I need to
excised as
chat
well.
with Dr. B for just
State
a
has no
moment.
objection to
I'm gonna leave
the
this rolling.
physical.
Don't worry, I'm not going anywhere.
Ability section. I'll just remove the word.
I'll just be off screen for a
junior
moment.
After Torres. Any other questions with regard to the 3.6F instruction?
Your Honor, state doesn't object to what we have produced as the final product. I'm impressed we did it so quickly. We just note our objection for the record to preserve a challenge to Martinez's opinion.
Understood. Do the parties, well, let me ask this question. Mr. Henderson, anything else we need to address with regard to the 3.6F instruction?
No, sir, I'd just like to preserve the objections that I made during this conference.
Objections preserved?
Your objections
Do the
are
parties
preserved,
wish the
sir.
court to
All of your objections are
reread
preserved.
the 3.6F instruction that we just went through, just to make sure we're all on the same page?
Yes, sir.
Can we do it at a time where?
He was
Is
like,
in-
I'm not
is in
camera
final
ready.
form? Yeah, absolutely.
fine.
Okay.
Perhaps a written copy that we can take during snack time.
Sure, absolutely. All right. Where does that take us now? Does that take us to the 3.6G instruction?
I believe so.
Okay, give me a moment.
Why is Dr. B lurking? Because we have a few things we just need to take care of. And we have a moment. Life things. Becca
I
Moon
have
asked, will this,
state's
Becca
proposed-
Mason asked, will this be used on appeal? I mean, they seem to
3G
be
instruction.
doing everything well with the jury instructions. So if there's an appeal, I mean, maybe, but I don't see anything that's a problem. So
I
far,
have
they've
the
been
form instruction from the Supreme
conscientious.
Court. And I have the,
No, the jury is out for lunch. So
defense's
they
proposed
were sent for a long lunch. So they're out
revisions.
frolicking
Just move everything around
with
here. Give me a
food,
second.
hopefully. MJ asked if I've been covering YSL. I will circle back to everything that's been
Okay.
going on, but no, I've just been covering this right now. Every other case that I'm covering, I will either cover right now in the Emily Show podcast on Wednesday or Quick Bits. Those are all on the audio feed. If you have the Lawnerd app, you'll get all of those notifications. Quick Bits is on that channel. And
right.
It's
As
all
to
on the
title,
audio feed for the Emily
I
Show
believe that
on
based on what we
podcasting
discussed,
apps
the
and here
or
on
threatened
YouTube.
use should be removed. Is that correct?
That's correct.
All right. As to the first sentence, it is a defense to the crimes of second-degree murder and culpable negligence.
This is into
The
the
actions of
self-defense
Sarah
instruction.
Boone constituted the justifiable use of threatened use, as we're removing justifiable use of non-deadly force. We're removing threatening, and we would also be including manslaughter, correct?
Yeah, because
State?
threatening
Yes, sir.
didn't happen.
Offense to the crime of second-degree murder, manslaughter, in Oxford, or culpable negligence.
This is the full self-defense instruction.
I too am a big fan of the Oxford comma. So the defense would, or the instruction would now read, it is a defense to the crimes of second.
Of course you are, Your Honor, because lawyers are nerds and nerds in the best way. I too am a big fan of the Oxford comma, big fan of justice.
Degree murder, comma, manslaughter, comma, and culpable negligence if the actions of Sarah Boone constituted the justifiable use of non-deadly force. Acceptable state.
Yes, sir.
Acceptable defense.
Yes, Your Honor.
Definition of non-deadly force is not at issue. Next paragraph. Sarah Boone does not have the burden of proving that she was justified in using non-deadly force. Instead, for you to find Sarah Boone guilty, the state must prove beyond a reasonable doubt that Sarah Boone was not justified in using non-deadly force.
This is
Acceptable
the
state.
self-defense instruction.
Yes, Your Honor.
The law on justifiable use of non-deadly force is as follows. Sarah Boone was justified in using non-deadly force against Jorge Torres, excising Jr., and had no duty to retreat if she reasonably believed that such conduct was necessary to defend herself against A, Jorge Torres, excising Jr., imminent use of unlawful force. Is that instruction acceptable?
Yes, sir. I don't know if you mean to include the A if we're not using the B. I would just suggest you make.
Yeah, you probably can just remove the A.
Any objection?
No objection.
Okay. Any other issues with the instruction as read so far? State.
No, sir. Thank you.
Defense.
None, Your Honor.
Okay.
I appreciate the amount of
Looks like
lards.
there are several
Also
agreements
appreciate
with the
Oxford
balance of
commas.
this instruction as to the defense of property is not applicable. The 776.0134, dwelling and residence and vehicle, and force with regard to law enforcement, all of which is not applicable in the instant case. That takes us to the give in all cases.
You can see that the judge
We
is
would
like,
be
we're getting there, we're
removing
getting there, we're getting
the
there.
threatened use of non-deadly force in that section. Any other changes is to the give in all cases section.
Nothing to say. Thank you.
Defense.
None, Judge, no objection.
Okay. Let's table the proposed instruction on the battered spouse for the moment.
I think they're going to do that one last because it's also going to be, I would imagine, more of an argument. Jury will be back at
And the state
1:30.
will be making its request for the forcible felony instruction.
Under Martinez.
Yes, and we understand the court's ruling, and we're sending a strongly worded disagreement to the court Supreme Court.
Received and understood, but based on what the court said earlier as to the conclusion in the Martinez section, I'm disinclined to add your proposed instruction.
I think that's
That
appropriate under
takes
the
us
case
now
law.
to the 776.0412 section. Looks like we have a little bit of a disagreement here. Is it the same arguments that we received in the 3.6F instruction?
It's the same fact.
Any other additional arguments, sir?
No, Your Honor.
All right, for the reasons previously identified, the court will accept the state's proposed portion as to the 776.0412 instruction. Then it takes us to the prior threats.
Same requests and objections as in 3.6F from the state, sir. For the end of the instruction.
I agree it should track what the
Forgive me. Other than reputation, what were the other issues?
Prior threats should come in.
Mm-hmm.
Specific acts should come in.
Okay, thank you. Reputation should be excised.
The 2 paragraphs of reputation excised, and then physical abilities gets read in all cases.
Agreed?
Correct.
Okay.
Agreed.
All right.
Not that I have a vote, but
And
also
then we'll
agree.
remove the threaten language in there, correct?
Yes, that's correct.
Give me a moment.
All right, they are getting through the self-defense instructions. They are
Okay.
leaving the
Any
battered
other
spouse instruction to last.
Questions with regard to the 3.6G instruction state?
So
Thank you, sir.
Defense?
None, Your Honor.
those
Okay.
numbers correlate with the
I believe
model
that-
jury instructions. This might be the last one.
Double check my notes. Believe then that addresses those issues based on what we did not discuss this morning in the charging conference. And I think that now takes us to the state's requests and the defense's request for special instructions.
Special instructions for battered
battered
spouse
spouse one.
for battered spouse syndrome, because there might not be a model jury instruction, especially if it doesn't come up that often. So there are times where the lawyers can craft special instructions to explain an area of the law or an area of the case, and sometimes you just have to write a jury instruction to specifically address the unique facts of your case. And the defense and prosecution both have proposals, and now the judge has to find a way to meld those proposals.
First, conflicting requests.
Yes. Specifically, we're making reference to the state's request for special jury instruction regarding battered spouse syndrome filed, I believe it's not dated, but I think it was either the 23rd or the 24th that you filed these, Mr. J, and the court record will speak for itself as to when they were filed. Okay. Courts reviewed that motion and reviewed the proposed instruction by the defense. State, let me hear from you first.
With their instruction, I think the problem with it is that it kind of blurs the subjectivity component versus the objective reasonable person standard. So if we make this change to their instruction, then I'm actually okay with it. What I would suggest that change be is in the second paragraph. If you find the evidence that Sarah Boone suffers from battered spouse syndrome credible, you may consider this evidence to assist you in determining whether a person in Sarah Boone's circumstances would reasonably believe that such force was necessary to defend herself against the imminent use of unlawful force by the victim, no junior. I don't know if it's necessary with the date. That makes it clear, because that's what the case law says. The case law makes it very clear it's about the objective component.
I agree with you.
And then I would just ask for my last sentence, which is like other witnesses, you may believe or disbelieve all or any part of the testimony regarding battered spouse syndrome.
Let's say the defense. And if necessary, I can read.
Yes, could you do that?
So it looks like there's no, first of all, just so the record's very clear, Stevens v. State identifies the special instruction circumstances. Special instruction is subpoenaed by the evidence in this case. Yes, absolutely.
Yes.
The standard instruction did not adequately cover the legal theory it is meant to. There is no standard instruction on battered spouse over and above what's included in the self-defense instruction. The special instruction was a correct statement of law and not misleading or confusing. We're addressing that third prong of Stevens at this time. The proposed instruction would read, you have heard
That's where we
evidence
are.
that Sarah Boone suffers from battered spouse syndrome. If you find the evidence that Sarah Boone suffers from battered spouse syndrome credible, you may consider this evidence to assist you in determining whether a person in Sarah Boone's circumstances would reasonably believe that such force was necessary to defend herself against the imminent use of unlawful force by Jorge Torres. It would then go on to read, like other witnesses, you may believe or disbelieve all or any part of the testimony regarding battered spouse
I think
syndrome.
that's a fair instruction.
Agreeable.
Okay.
Okay.
Appreciate y'all working together.
They
on
all
that.
agree that
Give me
it's a fair
moment
instruction.
to finalize.
So the reason they are writing a special instruction is because they have found that there is no standard jury instruction. There is only a self-defense instruction. And the reason battered spouse comes in to this case is to try to help the jury understand the lens of quote unquote reasonable. So the language in the second degree murder calls for reasonableness, but so does self-defense. So would a reasonable person in Sarah Boone's situation, not a reasonable person who's never experienced trauma or violence, someone who has battered spouse, would someone else in that circumstance have found that the threat posed by Jorge Torres was such that the response was in self-defense? So it helps the jury choose to look through that lens if they want to. If they don't want to, they don't have to. So it's letting the jury know you can view quote unquote reasonableness through the lens of Sarah Boone and her experience with battered spouse vis-a-vis reasonableness with someone who does not have that experience. But if the jury can find, yes, she has battered spouse, yes, this has been going on, but no, this still does not make her response reasonable. So this is instructing the jury of how to use that that testimony, where they put that testimony. And where they put that testimony is how they view the lens of reasonableness. Hopefully that makes sense. So now they are agreeing on that instruction that the jury will be read. So
Finalize this.
that's... So hopefully that helps.
As such, the third prong of Stevens has been made, and the court will give the special instruction as identified on the record. Now, the only question I also have is, do we want this as its own instruction, or do we want this included where it currently is in the 3.6F and 3.6G instruction? State.
I would suggest it be 3.65, right after the two instructions about use of force.
I agree with that.
Okay. Do we want
I
to
agree with
label
that.
it or just have it as special instruction and then read it? Do we want to have the title special instruction on battered spouse? I welcome.
I'm fine with the same battered spouse syndrome.
That's fine.
Okay, so it'll be
Agreed.
special instruction on battered spouse syndrome. Is that acceptable?
Yes, sir.
Is that acceptable?
Yes.
All right, thank you.
Look at that. They are moving right along.
All right. And that will follow after the 3.6G instruction, correct?
Yes, sir.
Acceptable, Mr. Henderson?
Yes, sir.
So the instructions
All right,
should be
that takes
explained
care
by the
of
attorneys
that.
in closing. We'll see how well they do that.
All that should be left. Oh, go ahead.
Yes, I'm sorry, sir.
I'm sorry. I think we might be required to read it both times after each one.
What?
I have no problem with adding a paragraph into it that says this applies to both the justifiable use of deadly force and non-deadly force.
Closed captioning, don't block our judge. Sorry, that was...
That's fixed.
Okay.
Okay.
Where, gentlemen, do you
them.
want that?
After the big paragraph that ends with Jorge Torres and before like any other witness.
Sure. Okay, so let's go over that language one more time so that we're all on the same page. Mr. J, what is it that you propose?
To put between the paragraph that ends with Jorge Torres and before the paragraph of like other witnesses or whatever I said, you can consider this testimony and evidence in the applicability or the use of whatever word people agree on of both deadly force and non-deadly force instructions, something to that effect. If that's too convoluted, I'm fine.
Chris in the chat said, EDB, I've learned so much from you. I
I
never
tell you
understood
what,
the
I'd
importance
rather
of jury
just
instructions
repeat it.
before finding your community. You're
That gets
welcome.
way complicated. I'd rather just repeat it under 3.6F and 3.6G.
Agree.
Okay.
So here's
Does that
what they're
work
going
with
to
you,
do.
Mr. Henderson?
Yes, sir.
All right, thank you, sir.
Because both of the self-defense instructions include language of reasonableness, they are going to put the kind of caveat on how to assess reasonableness under both instructions instead of just once, so that you'll hear it twice under each self-defense instruction. When the judge reads these in like
All right.
30 minutes.
Okay. Okay.
Because it's, what, almost 1
Moving
o'clock
now to
local
the
time?
state's request for special instruction regarding withdrawing from physical contact, filed October 23, 2024. Court has reviewed it. I guess the first question is, is there proposed language?
Trying to see if I'd actually put that in there.
Oh, but I am
I
behind.
don't know that I see it, Mr. J.
Oh, paragraph 15. Physical contact includes any restraint on George Torres, apostrophe, movement.
And this would be after the initial aggressor portion in the 3.6F and 3.6G, correct?
Yes, sir.
Okay, what say you, Mr. Henderson?
If I could have one.
Yes, of course.
I'm going to zoom while he's looking at that and taking a minute to talk to his client. All right. This is why we love the zoom during jury trial conference.
Therefore, at the conclusion of the two paragraphs regarding initial aggressor, it should come in not there, but shouldn't it come in because that's not there anymore? Initially provoked.
Yeah, in the 3.6F instruction, references to initial aggressor have been removed.
Yes. So now is the state asking for it to come in as the initially provoked?
Unless I missed something.
My understanding was that it was the two paragraphs about aggressor are coming in. What's not coming in is the Martinez forcible felony. The facts of the case.
Right, but the language, you said at the conclusion of the paragraphs regarding initial aggressor, the words initial aggressor don't appear in the 3.6F. It's only after that. However, the use of deadly force is not justified if you find Sarah Boone used force to initially provoke the threatened use of force against herself unless, and then it's paragraphs 1 and 2. Is that where you're asking it to be?
Hold on, let me pull through.
Sure.
I understand.
Okay, they're trying to figure out where they're going to place that.
So in 3.6F,
Alexandria said, can we zoom until they're done? This is pretty important, so no. I know it can be a little deeply legal, but it is important. And
should be, however, the use of deadly force is not justified if you find that Sarah Boone used force to initially provoke
Correct.
the
That's what I
threatened
have.
use of force against herself unless, parens 1 and 2.
Correct.
And then after 2, as an explanation for what is listed in paren 2 as from physical contact, just that elaboration of what we're talking about.
I got it.
Because
Okay.
the unique circumstances of this case, the remote force.
Okay, I got it. I just want to make sure we're all on the same page as to where. What say you as to the proposed language of physical contact includes any restraint
I
on
love
George
what say
Torres'
you.
movement as
formal
that
in
portion in
court.
3.6F and in 3.6G?
No.
hear ye,
Okay.
hear ye.
All right,
What say you?
Court's going to grant the state's request for special instruction regarding withdrawing from physical contact. And the language of physical contact includes any restraint on George Torres' movement will be included after the, however, the use of deadly force language after paragraph 2 in the 3.6F instruction. And in the 3.6G instruction, it will be at the end after the physical abilities section. Also, it's George is spelled incorrectly. That will be remedied.
Okay. Sue said, can we bring back court wigs? No, I've heard they're incredibly expensive.
3.6G,
So no.
it shouldn't go after physical.
They would make me sweat.
Oh, I'm sorry. You're correct. I apologize.
No problem.
So they are moving right along. We have gotten through this trial with only a handful of
Okay,
what if any
got it.
or
That
derivations
takes us
thereof.
now to the state's request for special jury instructions on causation, filed October 23,
But that
2024.
BSS instruction
I
went
have
faster than I
reviewed
thought.
it, and the proposed instruction on paragraph 3 therein.
Judge, the reason we're bringing this up is just during the cross-examination of Dr. Z, or Zadovich, we poked the bear a little bit about his cardiovascular condition. My memory of the testimony was that she's emphatic that that was not the cause of his death. But because of that, and because of now the request of culpable negligence, misdemeanor for a lesser, I feel it might be warranted to give this explanation of causation in the second-degree murder and manslaughter instructions.
Defense, what say you?
Judge, I would object.
So the state is proposing a special instructions to tell the jury how to find that the defendant caused the death of the victim. And they are proposing that it says, but for the defendant's criminal act, George Torres' death would not have occurred. George Torres' death was not beyond the scope of any fair assessment of the danger created by the defendant's criminal act. Oh, I can see where the defense might have an issue with that. 3, it is not unjust or unfair to hold Sarah Boone criminally responsible for the death of George Torres. I think they might have an issue with that too. So they, because that's telling the jury how to decide, I think. So point 1, maybe. Point 2 and 3, maybe not. So let's see what the defense objects to.
The proposed instruction that I have it as one, but for the defendant's criminal act, which we have a standard jury instruction that said the death was caused by the criminal act of the defendant, and that's what they're required to prove. This language, to me, would lessen that requirement by saying, but for the defendant's criminal act. Then the second part, when it goes up to George Torres' death, was not beyond the scope of any fair assessment of the danger created by the defendant's criminal act. I think that's covered, Judge, in the fact that the state does not have to prove that Ms. Boone had the intent to kill George Torres. So that makes it confusing to me when the standard instruction basically simplifies it in my mind, and it keeps them right where they're supposed to be with that instruction.
He's like, we don't need anything more. Let's not be extra. He's like, no need to get wild.
Then, as to the third part,
I'll withdraw my request for that.
Okay.
If heart disease gets brought up in closing.
All right, fine. So withdrawn. Court takes no action on the state's request for special jury instruction on causation. That leaves us now with the state's request for forcible felony instruction and request for initial aggressor instruction.
That's our.
All right, we're getting back to that. Cat Lover 1956 at EDB. Have you ever had such long jury instructions in your job? These are not long. These are actually pretty succinct. They're just arguing over what they're going to be. But I did a lot of more. I did, in addition to doing like homicide cases and stuff like that, some complex fraud cases, and they were much longer. These at 30 pages are not wild. These are a pretty normal amount of jury instructions. The self-defense instruction will be a little bit long, but these are not outrageously long jury instructions by any means.
That's already been addressed, has it not?
I was just treating it as a special jury instruction for my argument.
Understood. All right, are there any other instructions sought by the state at this time?
I believe we've concluded the section.
Defense.
no other ones.
All right, here's what I'm going to do. I'm going to take all this upstairs. I'm going to re-review it. I'm going to merge it all into one document, and I will send it to all the parties.
Good work,
Let's plan
everybody.
on being back here at 1:30, and we'll address
Good
any
work.
other concerns of the jury instructions at that point in time. State, anything else we need to address?
125.
Well, let's make it 1:20.
All right, thank you.
Defense.
Nothing.
All right, we'll see you all at 1:20. Thank you.
It's lunchtime. We've got like 25 minutes for lunch. I'm going to need that time. You're going to need that time. And then we're going to get into closing arguments. So the attorneys have a little bit more time for lunch because I was a little behind because we did some stopping and starting. So the attorneys will have a little bit more time for lunch than we will, but that's okay. We've got plenty of time. We're at home. We don't have to go do anything. A lot of attorneys don't even eat lunch during trial days. I would imagine there were lots of you asking where I thought Owens was. I don't know if he was still in the courtroom or not, but there's a defense team. Other defense attorneys can handle this. He might be prepping closing arguments and taking a minute out of court to do that, which is a incredible luxury. So he might be prepping closing arguments, because if they had divided up the work, then you've got the attorney who's taking care of that work in court, and there's not much else needed. And then you've got a secondary attorney that was communicating with Sarah Boone and keeping her in the loop so that the attorney on the record could focus on what he was doing. There are quite a lot of attorneys in this case. Like, it is a fleet of lawyers in this case. So they have lots of backup and support so they can divide up the work as needed. So the jury will be back at 1:30. The attorneys will be back a little bit before 1:30 just to go over the final judicially merged jury instructions. I imagine there won't be any issues with that. The judge is going to go edit those, print it out for everybody. And then what you will see when we get to jury instructions, and I might 1.25 it, is the judge reading all those in. Maybe I won't. They are important. But the judge reading in all of the jury instructions to the jurors, stopping when you get to the, you get right before the final charging instruction, then closing arguments, then the last like 3 jury instructions, then the jury will go back to deliberate. The judge has given the jury the heads up that they might be working well past 9 p.m. tonight. After closing arguments and after the jury is sent back to deliberation, we will populate a new stream. In case there is a verdict tonight, we will do a verdict stream. I would be very surprised if the jury does not come back with a verdict at some point today or tonight. But we will separate that into a second stream. So what I will say is, if you are like, hey, I'm not sure where and what I will be doing tonight, I'm going to be watching the Los Angeles Dodgers play. That's fine. The Lawnerd app will let you know when we have a verdict. I will be keeping an eye on it. Team Baker will be keeping an eye on it. The Lawnards will be keeping an eye on it and letting me know. And then we will let you know in the app when we are going live for a verdict. So if there is a verdict tonight, we're going to do that together. So if we need to like pause baseball, we'll do that. We'll pause the sports ball. Look, baseball has some of the best snacks. Those Dodger dogs are good. We'll pause baseball and we will come back and do a verdict. So I'm going to do the briefest of brief summaries for everybody who is just with us now, and I'm going to go get some food. The jury charging conference actually went fairly smoothly. There was some argument on points of law for some of the instructions, but at the end of the day, much was agreed upon. The defense made some arguments and the judge was like, anything else? And he's like, no, no, nothing else, because those are instructions that are coming in. So we're going to see instructions on battered spouse syndrome as it applies to reasonableness in the perception of fear for self-defense. We're going to see those self-defense instructions. We're going to see instructions about whether or not Sarah Boone was the initial aggressor. And if she is the initial aggressor, then they can discount self-defense entirely. I expect that we will hear the attorneys explaining some of those key jury instructions during their closing arguments. But if they don't, I think it is a failure. I said that in the Karen Reed case, that I thought both sides not really explaining the jury instructions was a failure on both of their parts. They only had an hour to close. I think they should have pushed back on it in that case, because explaining the jury instructions to the jury is critical. And I love it when attorneys go through the elements and say, this is how you know we've proven this. You're going to be asked to decide this. And we saw in opening that Owens wanted to bring in giant poster boards of jury instructions and say, hey, this is the instruction. And the court's like, this is not argument. So the poster boards, I think, will be back. And I think we'll see the defense going through that. The prosecution should too. Explaining to the jury what the instructions are, I think, is critical, because how else do they know how to work through that? Jury instructions can be difficult. They can be lengthy. I once had a judge threaten to fine me because I threw a little shade at the legislature and the jury instruction committee. I said, I know these things aren't written in like human. These are written very much in legal, and that is a difficult thing. But, you know, blame the jury instruction committee and the legislature is kind of a joke. And afterwards, the judge called me in and my boss in and said it was an inappropriate statement regarding the jury instruction committee. And I'm like, these jury instructions some kind of suck. So, you know, Your Honor, seriously. So, anyway, the instructions can be difficult. So going through them is necessary. This was a very old school judge, and I shockingly was not a super old school lawyer. And so there were times when I would look at my Southern California jury and be like, you guys, and she was just like, Ms. Baker, you cannot call the jury, you guys. Sure, Your Honor. Got it. If they don't like it, let them hold it against me. So I'm going to go grab some lunch. I suggest you do the same. Take a stretch, take a water break. We will be back actually fairly shortly because it looks like court's going to be back in about 15 minutes. So we are going to, Miguelina, do we have our lunch break up? We're going to go to our lunch break, y'all. I'm going to put on we're going to change it up a little bit with our music. We've only got about 15 minutes. So we'll change it up a little today. So let's just go to lunch real quick with a little bit of a change up, and then I will be back. See you guys soon. That's not the right one, Emily. Take two. All right, y'all. Hi. We're going to be coming back. Court's not back, but I'm going to answer some questions since, well, court's not back yet. They were supposed to be back about 15 minutes ago. So instead of just chilling, I figured, well, I'll eat while the judge is giving jury instructions. I can answer questions now. And then when the judge reads 30 minutes of jury instructions, I can finish eating lunch. So I figure we might as well just like pop the court in the corner. Hey, I actually like the way that works. Emily, are you just over here playing with layouts for stream? Yeah, I am. That actually works really well for me. So we're just going to leave. We're going to leave the court down there on its own. Just a reminder, today we're going to be on verdict watch. I don't know if this will be a quick verdict. I don't know if they'll want to rewatch videos. I don't think I would. I don't know if the jury will want to read those text messages that came in today. I don't know if I would. I mean, maybe they want the tea. I don't know. So will it be a quick verdict? I don't know. I will pull on it in a little bit, but if you want to be on verdict watch with us, I guess I should have done this first. Lawnard app, free, iOS, Android. We built it for you so you don't miss a moment when you are busy. Also, if you guys are busy today and have to pop in and out, when closing argument starts, we will also send a push notification to the app because it's going to be at least 30 minutes of jury instructions. And who knows what's going to happen before they even get to jury instructions. So with that, we will need to go through all of that in a bit. So we're just going to leave court on so we can all see together the moment they are ready. Am I just playing with layouts at this point? Yes. Why? Well, because why not? So I'm going to go through chats and super chats. If you guys have questions for me, it's easy if you at my name, so it highlights in the chat, or if you put the red question mark emojis, it makes it easier for me to see. With over 20,000 people in chat, it does get busy and sometimes it's difficult for me to see, even when I have them in background mode. So, or even when I have it in with the black background, sometimes it can be hard for me to see. So thank you all, and I will get to as many questions as we can, and why not? So that, all of the things with that. So Judy said George's ex and daughter said prosecution did not have any contact with them for the 4 years leading up to trial. That, I really hate that, Judy. I know they were on court TV today. I'll take a look at that later. I don't like that at all. They should have contact with the family, and I don't love that for the family. Janet G said recently downloaded the Lawnard app. Need to say, love it. Thank you. We built it for you. Yes, there is a paid section of the app, but the app is also free. So we built it as a way to, well, I was petty. No, I wasn't petty. I set a boundary that we're not going to allow the text crew to continue to gouge us with prices. And they changed our contract in the middle of the Depp Heard trial. And I was like, we will find a solution ourselves. And with our international Lawnards, we wanted to make sure they could have access to. And with our paid text messaging service, we couldn't do that. So we thought that this would be better for us. Patty said, EDB, why didn't the state have their own psychologist assess Sarah? They did. That was the witness we saw yesterday whose testimony was incredibly fractured. She was a psychiatrist, but we saw her yesterday and she did a very brief assessment because that's generally all the state has access to for affirmative defenses. So that's all paid for by the government. The ghosted woman said, Emily, didn't she have an obligation to help him if he was in distress? I mean, she caused the distress. That's why she's being criminally charged with it. So the charging is a little bit different than charging someone with a failure to render aid because she caused the situation. So they're charging her with causing the situation. Failure to render aid implies that you have an obligation to render aid to someone and then don't. She caused the situation, so she's charged with murder. Well, second degree. Meowtho9 said, do you think the defense delaying the trial yesterday hurt them? No, I don't. I think the videos hurt them. I think all the delays in the morning were probably forgotten. I think by the time we got through the afternoon, we're like, oh, there was a doctor on the stand this morning, right? No, I think they were doing their job, and I think they raised the objections they needed to raise. That testimony came in really choppy. I don't know if it even matters. I don't even know if that choppy testimony matters after those videos she took. I think it just kind of all goes, yeah, well, those fucking videos. I think this case is Sarah against Sarah. Sarah taking video to try to bolster her arguments. She said she took the videos of George to show him after he had been drinking what he does to her. So her videos she takes to use against, well, him, but these were being used against her, and I think to great effect. So I think it will be to great effect. I saw a question and then the chat jumped so fast I couldn't pull it up on screen. Rolling along said, EDB, please make the next gavel to gavel not so distressing. I don't know going into it how distressing they're going to be always. I didn't know all this video existed. Criminal cases tend to be the ones that are on video the most. So it's hard to cover civil cases because they're normally not broadcast. So that becomes difficult. Criminal cases are difficult. Mutant Alchemist said, how thick a skin did you need to have as a prosecutor? Pretty thick. How often were you painted as unethical or immoral by the defense? Not often. Unethical, I don't think ever. Immoral, I also don't think ever. The defense didn't always like what I was doing, but I also made sure I treated everyone with dignity. I think everybody deserves dignity, especially in the court proceedings. It shouldn't feel like a personal attack when you're in court. So I tried to pick cases that didn't trigger me into I can't, like just all of the I can't. I talked about that a bit in our members only live. There were types of cases that I noped out of because of that. And I think that's a fair boundary to set as a prosecutor. But like allegations of prosecutorial misconduct, no. Did every defense attorney and I get along wonderfully? No. But during different coverage here, I've had a lot of them reach out to me and be like, it's good to see you on the internet. So I find if you work and treat people well, they will also treat you well. And if you treat people as humans, even if you disagree, you can generally find a way to work together. I think the people who are often the most upset with me for doing my job were the families of the defendants. And I understand that. I completely understand that. When you are the one prosecuting someone that they love, you are the face of the government trying to put the person they love in prison. So I understand that frustration. That didn't mean I didn't get name called on jail calls quite a lot. They were normally about my face, my voice, and my weight. So that's always a delight. Child of God said, are there lesser included charges the jury can pick from? Yes, there are. Child of God. In this case, there are 2 that the judge is giving instructions on, and those are going, actually, let me move this because now I can't, that's better. We like that better. Let's just do that. There are 2 lesser includeds, and in this case, it's going to be the second-degree murder, manslaughter, and then there is a misdemeanor negligence charge. They're not going to know about that, but there's a misdemeanor negligence charge. Lauren, I don't think on jail calls they're worried about whether it's rude to me or not. More rude was some of the graphic phone sex, I think. I was like, I'd rather have you make fun of me than have to listen to some of all of that. It's like, I am at work. Casey asked, why was this not a first-degree murder? I think a first degree would have been a reach. I understand on the evidence there is room to look at premeditation. I really think it would be a reach to try to argue to the jury that when she zipped him in the suitcase, she was like, yeah, this is going to be it. I think once he was begging for his life and telling her he can't breathe, then she knows that he's in distress. I don't know if she would have perceived that when she zipped him in. Like, it's different than grabbing a more traditional weapon. It's just different. So I think her zipping him in and then him saying, I can't breathe, her choosing to not let him out becomes the thing. And I think that fits more in the second degree and manslaughter. So I do think that fits more in the second degree and manslaughter. I'm sure some think even the second degree is a reach, but given all the videos we've seen, I can see why the prosecutors went after the second degree, because the videos are pretty horrific. And the videos are pretty horrific. So Meg McCabe said, what was your easiest case? I had the easy ones tend to plea and don't go very far. But I had fraud case where there were co-defendants and the defendant got up on the stand and thought he was much smarter than I was. Fraud defendants tend to have some of those traits where they think they're the smartest person in the room and that no one's ever going to catch up to what they're doing. And in testimony, he said to me flippantly, well, that's why I told him to do elements of crime. And very much didn't think much of me being a female, very much didn't think much of me being a prosecutor, and thought he was the smartest person in the room. And so on cross-examination, just like all of the words came out of his mouth. And that ended up being pretty easy. And at that point, it was hard to just stop asking questions and sit down because it's like, oh, he just said he did everything. Quit while you're ahead. But then in my brain, I'm just like, ooh, keep going. And then I'm like, quit while you're ahead. Quit while you're ahead. Sit down. Don't let him explain what he did. Don't let him explain it further. So that was one of the easier trials because, he admitted it all on the stand and that didn't make it very complex for the jury. I've had some funny cases. I've had some horribly sad cases. I mean, it's a long career, and anyone who works in long careers, it's just a lot. So Michelle said that George's family was on court TV this morning. Not sure why his family wasn't called for trial because they weren't witnesses. If they had witnessed something, then first person witnesses can come in, and George's brother did come in and testified first for the state. But oftentimes family members haven't seen the thing that happened. And if they didn't see the thing that happened or hear something that happened, they're not witnesses to the case. They can come in if there is a conviction for impact statements, and that comes in more at sentencing. So oftentimes we don't hear much from the victim at all. In this case, we heard quite a lot from the victim because of the videos Sarah Boone took. So that's how we ended up hearing more from the victim in this case. So them talking about how much they loved their family member isn't appropriate evidence for trial. The trial is really, truly focused on the defendant and did the defendant do what the state said that they did because of the way that our constitutional rights are set up. So that it distresses me. I did not see on court TV if the prosecution didn't communicate with him much, but I don't love hearing that. But prosecutorial offices don't always have great relationships depending on the office and how much time they have and how many cases they have with families. It just depends. This case was pending for 4 years, though. Again, every office does things differently. Every prosecutor does things differently. Lauren said, good morning. Thank you for all your hard work. I was finally able to become a member. You're welcome. And there's been so many gifted memberships. So for everyone who's a new member, welcome. It is lovely to have you, and to all of you that have gifted memberships over the course of this trial and others. You are incredibly generous, and I appreciate you. Thank you, Melanie, for the gifted memberships. It's one of the things I try to do when I pop into people's lives as well, because it's really lovely to be able to welcome people into a community they want to be in. Lizzie Beth, thank you for the gifted memberships. Victoria asked, what's my prediction of deliberation time? I think probably quick. I think they'll be back today. I will be very surprised if they're not back today. I'd be surprised if they want to carry this over the weekend, especially the judge giving them time today. Rui said, I'm so glad I took an annual leave day today. I'm really looking forward to the charging conference. It will be really interesting. I think the charging conference was really interesting. I know there's times it feels a little thick. It's hard when you can't watch it along, when you don't have like the written with you. That can be really challenging, but I'm glad we had it. I am surprised that they are not back on the record. It is almost 2:00 local time. That's a half an hour after when the judge said they would be back. So I am surprised that they are not back. Adeletto said, I'm behind, but wanted to give you snaps for EDB referencing. Victor Fuentes. My Kevin and Bean heart is happy. Allie and Bean have been have a podcast. I know they do. Too much information. Too much information. Yes, I am an OG Los Angelino, even though I have moved to Middle Tennessee. But the Kevin and Bean show was a huge part of my broadcasting upbringing and what I listened to from the time I was in early junior high. Back in the day when we used to just turn on the radio because there was not much of another option other than our tapes, because I'm old. but I love it. I don't know. There's times my teen is like, oh, I was talking to my friend about XYZ music and they've never heard like Stairway to Heaven. And I was just like, how is that possible? And my husband's like, dude, people aren't listening to music in the car in the same way. Kids have their headphones in, even in the car. So, you know, you're not like forced to listen to your mom and dad's music. I'm like, and that is a tragedy. Being forced to listen to your parents' music makes you a better human. Says me, but my parents listened to good music. So Stairway to Heaven was a mandatory along with other things, but I think my dad had pretty good taste in music. So it's easy. Danielle said petition to have Judge K for all trials. Yeah, granted. I mean, I don't know how the state of Florida will feel about that. I don't know about how different jurisdictions will feel about us like importing him into Massachusetts, but I agree. Can we export him to Massachusetts for a little bit? Can you imagine? The chat, I see a number of you in the chat asking how long till court is back. They were supposed to be back 30 minutes ago. So now we're just at the mercy of the court. Let me check on the app that can't figure out what its name is real quick, and see if anybody's in the courtroom and has any statement of what's going on. But remember, before I share things, I generally look for multiple statements of what's going on. So, excuse me, I will try to look for that, but I am not seeing, let's see. I'm not seeing much about whether or not there is any idea of what is holding up court, but they had a lot to do with jury instructions. So I don't know. Let's see. Yeah, I don't see much. Yeah, I don't see much. So I will keep an eye out on that. But thank you, chat, for no breaking news. I appreciate it. Will the moderators and production team keep an eye on that? So thank you. They will look, but they might be trying to finish jury instructions amongst other things. So we'll see. Let's see. Emily, audio with police. She acted like she was yelling at George. We never heard him. Had bruises. Do we know she didn't do them to herself? We only know what's been put in. The jury will get to decide. So the jury will really get to decide. There were definitely injuries to her, but the prosecutor asked in cross-examination, do you know how these happened? And the expert was like, no. Emily Ippolito, I put that up in the app and I put a short up on Instagram on that. I'm going to keep this to this. But I haven't seen, yeah, I agree, Miguelina. I haven't seen any updates on why court is delayed. It might be as simple as they are trying to print out the jury instructions. Carrie and the cat said, couldn't figure out why my anxiety has been wild with this case. It's the testimony and videos. I'm so ready for closing. I'd be bailing if this were longer. It's understandable. Just watching it, there is like a secondhand stress with that. So just watching it is difficult. Baby Bear said, girl, I want to take you to a sidebar. I want to go to sidebar when they talk at sidebar. I hate not being able to hear sidebars. I want to hear all the sidebars. But it's hard not hearing the sidebars, and we don't know. Let's see. Phyllis asked, regardless of what she gets, if it is to serve time, will she most likely get time served for her incarcerated years? Not necessarily. If she gets 15 years, she'll still have another 5 or more to do. If she gets 22 years, more than that. If she gets 22 years to life, then it's more open-ended. So no, not necessarily. I mean, if they convict her of the lesser included, then yes, she would be out. So we will see. Let's see. I love goat cheese. I mean, same. Why aren't jury instructions changed to the neutral pronoun like there? I have no idea. I am not on the charging committees, so I do not know what conversations the jury instruction committees have had in the last 5-6+ years. I don't know because I don't sit on those committees, so I don't know what conversations they are having. What I will say is the law changes incredibly slowly. Christy says, please remember to like the video and subscribe. Thank you. And thank you. We're moving towards 800,000, which is exciting. Keisha said, Owens, if I I hope I pronounced that correctly. Keisha Brunson said Owens always had to keep arguing even when the judge agrees with him. I think he loves to talk. Sometimes I just wonder if he's like got a head of steam and he can't like stop and just like back up for it. So I don't know. BKY689 said, do you think the judge checks in with her more because of all the notes she sent prior to court, to the court prior to trial? Yeah, 100%. I 100% think the way that the judge checks in with Sarah Boone in this case has to do with the way she behaved in self-representation. Yes, I absolutely do. Sean said, listening to the videos yesterday of Sarah taunting George and treating him like a child gave me flashbacks of my ex-wife. I now feel sorry for him. I think the videos are going to be incredibly damning to Sarah Boone. Even if the jury is looking at the injuries with her and saying there are injuries with both, and there has been fighting with both, I don't know if the jury is going to think that she taunted him into that, or that the situation that night doesn't even matter to the things that happened prior, because the situation that night, there's no evidence that anything else happened there. So it's really going to be up for the jury about whether they narrow in on that night. It's incredibly sad. But when you're looking at who had control here and his ability to cash a paycheck, him being on the lease or not being on the lease, you're looking at her having a lot of the control there, even though he had somewhere to go. And then you've got her on those videos saying that's not approved, saying, look at what you made me do, saying, know that. Like, you have some really damning stuff in those videos that's going to be really hard for the defense to argue around, because Sarah sat on the stand and said, I was always in fear. And then she's got her phone like all up in his face till the point where he's like, can you not put your phone in my face? You know, getting up in somebody's face that you're afraid of is maybe going to contradict the jury's own life experience, perhaps. So we'll see what they do with that. Southern Belle asked, did they do closing yet? No, they're just not back. I don't know why. They're just not back. And now I regret everything. I should have just stayed playing Candy Crush. Not Candy Crush on my phone. But they talked about it in court, playing honestly, Midas Merge on my phone. But no, I would rather be here with you. We're going to answer questions, so why not? Beached asks, is the plea deal still on the table for Sarah? But no. I mean, she could plead open to the court for 22 years or more. There's not a chance. I wouldn't even speak the words plea deal. I would suspect that this has more to do with printing out the jury instructions or a juror getting back late from lunch. That's what I would suspect. I wouldn't even whisper the words plea deal. The judge is coming back to the bench. Hello, Your Honor, you were missed. What the fuck? We missed you. Let's go back to live court. Yay. It's been a min. The court's back over a half hour late, which is unusual for this court. Sorry, boot loop. The judge can't be happy about
We're
that.
back on the record. Case number 2020 CF 2603, State of Florida versus Sarah Boone. Limited appearances for the state, please.
Dave Cacciatore on behalf of the state. Will J. for the state.
Defense.
James Owens from Miss Boone.
Tony Anderson for Sarah Boone. Coming back over there. Sarah Boone.
Ms. Boone is seated at counsel's table wearing the same clothing from this morning. I apologize for my lateness. I realized that there were some typos after I'd sent this to print and needed to take them all apart to fix it. So thank you for your patience as we work through that.
I'm just going to take a minute. I'm just going to take a brief minute to harken back to 70 seconds ago when I said it is most likely that there is an issue with the jury instructions. And the judge came out and said, I'm so sorry, there was an issue with the jury instructions. Look, man, I don't know a lot of shit, but I know some shit. Thank you. Thank you. Thank you. Look, I've worked in court a long time.
State.
You noticed that in the non-deadly force,
Page 12.
there was a couple strike-throughs with the use.
I saw.
However, there was also a mistake with leaving a paragraph about reputation. reputation in at the very end of 3.6G, and that should have been a mirror of the relative physical capabilities of the parties.
I do see that.
Other than that, I saw the he, she bracketed still.
I fixed that on page 16.
Then it's just that one, I think, that Mr. Henderson and I noticed.
Okay, all right.
Coffee Girl 6'9", the Lawnards are glad to be
I
with
can
you
have Madam
too.
Clerk start fixing them here.
Days can be
Yeah, I think we
difficult.
should proceed and get going if we can.
But they will have nothing in their hands.
All right, well,
That's the issue.
That's the issue.
let's face that one.
Sorry. All
Yeah.
right, thank you. Just give us a minute to fix all this.
I want to have it in my hands too. If I'm the state, and if I'm the defense, I want the jury to have the instructions in their hands. Can we just look at the judge? Please don't go all the way back to the seal. Please don't go to the seal.
And
Please
just
don't
so
go to
that
the
I'm
seal.
clear, back on the record, we're referring to the bottom of page 12, 3.6G, paragraph 2, where the use is struck through, correct?
Yes, sir.
And then we're referring to the top of page 13 as to that 2 lines as to reputation. Is that correct?
Yes, sir. That should be physical capability paragraph or sentence.
Let me pull back up to 3.6G instruction.
Jessica, thank you for the gift of memberships. We're going to pull some of those up. Jury instructions are not easy, and they have to be right, but I want the jury to have them in their hands, especially when they're complex. This is not a simple case. It's not 3 elements, and there's a lot to have there. Nest Dog asked earlier, wait, I thought she can't appeal. Sarah Boone absolutely has the right to appeal if convicted, but she can't appeal that these weren't the lawyers that she wanted.
So that reputation paragraph
she can appeal.
should
She
be
can absolutely appeal.
removed in its entirety, and it should be the
In considering the issue of self-defense, you may take into account the relative physical abilities and capacities of Sarah Boone and George Torres.
There it is. Thank you.
The Chocolate in the chat said, I can't help but wonder if Sarah finds this whole process enjoyable because of the attention. You know, I wouldn't have really thought about it much until we saw all of the body cam footage from yesterday, and she seems to enjoy being in court. So there is that. So yes, she can appeal, but not on the grounds that, like, she didn't choose these attorneys or anything like that. But if she finds the attorneys to be ineffective, she could appeal on that.
Correct.
I don't think they have been. I don't even think we're close to that. But I haven't seen, I think the court has gone above and beyond to protect this case on appeal. And I think the defense has gotten some W's that were close calls. And I think in trial, oftentimes the close calls,
Was there anything else?
depends on
other
the
than
judge,
that?
but those close calls went to her
If you find
in
George
this.
Torres had a reputation for being a violent and dangerous person, you may consider this fact in determining whether he was the initial aggressor. Anything else that needs to be added to the jury instructions from the state side of the ledger?
Well, the reputation should be deleted.
Correct. I agree with you. Yes.
Mudrucker, yeah, ineffective is a very, very high bar to clear.
What's going on here?
These attorneys, in the time they had, I might not always
Reputation, Judge?
agreed with
That's
what
correct.
they did or liked what they did. I might take picky issue with some of those things, but they did not do a bad job. They made good legal arguments for her. Arguments made difficult by the facts here. Arguments made difficult by their client, videoing everything and talking to the police and all of that. But it's not that they didn't do their job. They did their job. And I think did their job well, given the amount of time that they had. There are things, again, that that I have taken issue with, but the legal sufficiency of
Mr.
their
Jay,
defense
was there
was
another
good.
line that we had added to the end of that?
Danny, Stormborn said, still all the respect to them for even doing it. They tried. They did. And they raised some legal arguments that wouldn't have been raised. They brought defenses that Sarah Boone wouldn't have been able to bring on their own. And at the end of the day, if Sarah Boone is convicted, there's not going to be an argument. It's because she
Maybe that's
didn't
what I was
have
thinking of.
representation.
Maybe that's what I was thinking of.
So that's not going to be the argument.
So the sentence should read, in considering the issue of self-defense, you may take into account the relative physical abilities and capacities of Sarah Boone and George Torres. Is that correct?
Yes, sir.
All right, thank you.
36F.
Correct. It matches 36F now. I apologize. I'm going to have Madam Clerk, I'll email it to her now, have her print out pages 25 copies of 12 and 13, and we'll start taking apart our jury instructions and re-adding them. And I thank you for your patience. 12 and 13, that's it.
Derek in the chat asked, how can the state not know the case well enough to have missed the statute of limitations? I'm just going to turn down the volume of the court while they're flipping papers. Because I don't think the state ever saw there being a valid self-defense here. When you look at cases where you're going to see a self-defense, it oftentimes is pretty obvious from the facts that there's a self-defense. I think when the state looked at this case, they're like, he wasn't doing anything. They all had a great day. She zipped him into a suitcase, yelled at him on video, went, fuck you, and left him there and went upstairs. I don't think the state ever contemplated a self-defense until later. However, I don't know if her early on defense attorneys indicated that they might want a battered spouse defense. If her early on defense attorneys said that, then they should have perceived the issue and could have fixed it. At the end of the day, I don't think it's really going to matter at all. But if her early on defense attorneys told them that, because I think some of those doctors came into the case pretty early on, then they had the heads up that that's what the defense was thinking.
Owens, are you going to be utilizing the verdict form?
And I think I heard a bang, but I don't know if we did.
I may, where is it going to be at your event?
We did.
I'll ask you for it.
Oh, we did.
Very good, sir. Thank you.
Cheers to us. Thanks, Lawnards. Welcome, new Lawnards.
You get a chance.
No, go ahead, sir. I can multitask.
There's a mic here.
He can multitask and he loves an Oxford comma. Could we love Judge K anymore?
I know there's a mic right here.
I will confirm with court admin that that microphone is on. I believe it is. They turned it on during openings. I'll confirm now.
You're worried about the mic?
And then Judge, last
Do you think Owens watched back opening and was like, my audio was appalling?
fingerprint table as my podium?
That's fine.
I may just slide it back so I'm.
That's fine, sir.
I'll do the bing bumper when we have a moment.
And then Judge, I've got.
He was like, "Where's my moment?"
And I've got some demonstrative aids. One is this. It was originally a quote by Dr. Michael Brannon.
Judge.
The state does go first in closing. They're
What are the
prepping.
other enlargements, sir?
It's a. It's the one I tried to get in.
I hear no objection.
Opening, which was the justif.
Owens is trying to say, I've got this, and the state's over there going, no objection, no objection, no objection. The state's like, can we just...
Viable use of non-deadly force.
No objection.
Those two. And then, you remember my reasonable doubt? I was using it for...
You've seen them?
I
Okay.
had no objection to those 5. I didn't like the 3 charts. The defense agreed that we've done reasonable doubt charts they won't use, so I think we're...
Owens, we don't need you to argue anything. We got it.
We're good with their demonstrative aids during closings.
The state's like, sir, it's fine.
Okay, very good.
We don't need to address it.
Videos that I'm going to want to play, and Shelby Andrews is going to walk up.
The state's like, yeah, it's
They're
fine.
evidence, right?
They are.
Yep.
Okay.
One of them's been pared down.
The state's trying to shut him
That's
off.
fine. As long as it's in evidence, you can present whatever you'd like.
And Judge, do you want to talk about time for closing?
We can. What do you think, State? You advised an hour and a half.
Yeah.
Total?
I think we both said hour and a half, but as the court knows, you can't really hold us to it until it gets a little ridiculous.
That's true. How much do you anticipate, sir?
Well, Judge, she's charged with murder. We've had a 2-week trial.
No, you haven't.
I've got a lot to say.
Facts. Oh, Your Honor, I've got a lot to say. Facts, Owen. Facts. You and I agree on that. 10 out of 10. The prosecution's like, we think an hour and a half, but you can't really hold us to it, so it doesn't really matter. We can kind of do what we need to do. So it looks like we're going to get about 3 hours of closing. Maybe plus.
I've got a lot of notes.
We're good. Let's go.
Say again?
I'm not hearing any
you know,
Okay. The only
stammering
thing, the only
for
thing I would
clamoring from the
ask is
state.
after the state has had their first opening, give them a short
Agreed.
break, and then let me start.
Agreed. We'll take our afternoon break at that point in time, then we can proceed with the defense closing and then rebuttal.
That makes
I have
sense.
received approval from the chief to work after 9 o'clock. So we can go till about 10, maybe a little bit thereafter.
I mean,
And then you're saying with the jury. And
Correct.
then at 10 o'clock, if we hit some number, 10 or 11, then we would come back Monday?
That's correct.
10 or 11 p.m. Eastern tonight, chat. 10 or 11 Eastern. We'll have a stream ready to go just in case. We'll leave the chat open and then we'll go live when a verdict comes in. I've kind of cleared my plans for the night. Dr. B is going to a concert. Kiddos are handled, so we're here. We'll have the chat open on that. It'll be open for a while for members. And then if we get closer to a verdict to everybody, because the mods need a break. So we will have that chat open for members, and then we'll open it up as we get, well, if we get update that there's a verdict. So I will be keeping an eye. I will let you know in where. Everybody say it together with me. The Lawnard app. Look, Team Baker worked real hard on the Lawnard app, so I'm going to keep promoting it. Plus, we've got, over 80,000 of you Lawnards in there, and we'd love to keep you up to date. So Jen in the chat said, did they read the text messages yet? Yes, they did. And that should be timestamped down below, but it's really hard while I'm still live to run it back, but you can run it back. That was this morning. And you probably have time to get caught back up, honestly, because they're still doing administrative work in the court. So let's...
Thank you.
Lenatter said, when she turned down the plea deal, I began to think she might actually have a case, but then I watched the trial and realized she didn't. Have you seen a defendant with this kind of hubris before? Oh, yeah, all the time. I did fraud cases. I loved fraud cases. Yes, I've seen lots of defendants who are like, you just don't understand my side. You don't understand. And if I can explain it to you again, you'll understand. You just don't understand. Why aren't you seeing it my way? And Sarah Boone is a defendant who's like, you just don't understand. Why aren't you seeing it my way? Why don't you understand? This is not fair to me. Why don't you get it? What's wrong with you that you don't get it? That is not uncommon. So, and it's not uncommon that she turned down a plea. She's like, the jury's going to see it my way. I don't know if that's the case. Shazam, thank you for the 5 gifted memberships. We've had a lot of time to chat today. So please tell me you are going to go through the sidebar transcripts with us. I need to look at how we obtain them in Florida, but yeah, I can grab the transcripts. If you guys are interested in going through the sidebars, I can look at obtaining the transcripts and doing that. It's much easier on like a 6-day trial than on like a weeks and weeks long trial. So for all of you asking if we can export this judge to Massachusetts, I don't disagree with you. Dana Rose said, Owens and Sarah Boone, 2 people who love to hear themselves talk. I mean, they are loquacious. I mean, I am also loquacious. So they're like, I get it. I'm also chatty. So I feel that. We did Bing again, and I think we should run the bumper. It's been a minute since we have run it, and during trial we find lots of new law nerds. So for that, I have a counter. Let me show you real quick. In the background here, that's up here, and it makes a little bing noise. So we just started calling it the you binged when we had new subscriber numbers. So honestly, the app and seeing you guys joining the app is huge for me. For my 12-year-old, this forward-facing subscriber number is the huge part of everything I do. So to my 12-year-old, it matters deeply. For me, it's lovely to know how many of you are subscribed, but it is what it is. So we're going to roll that because they're all sitting here doing paperwork. Oh, it binged! Move your head! That bumper is from our 100K subscriber celebration. Do we have any Zoom room on this? No. Did they just mute the court? When did we lose court audio? I binged and now there's like no audio in court. Miguelina, will you see if that's me or them? Because I wonder if they turned off the microphones when the judge turned around, because now I've got no sound coming from the court at all. And we had background noise before that. I'm wondering if I just need to put the stream.
So we can go till
they muted it. Okay. All right, good. Well, they muted the stream. That's not us. We're just gonna keep on chatting. And hopefully this won't be horrendously loud when it comes back on. So yeah, thank you, Miguelina, that they turned the mics off. So we are just chilling. Let's see. BDE, Big Dyslexic Energy in the chat said, do you think Sarah, I dropped my pen, had any strategy at this point in getting media attention? No. Or do you think she entirely stumbled into it? I don't think there was a media attention strategy here. I think the oddness of the case, plus the fact that she went through so many lawyers, became very newsworthy. I don't, lawyer, might know better than me. He's local, how it became more newsworthy locally. But then her representing herself is what really grabbed quite a lot of attention, because the letters to the court, because it's unusual and it's out of the regular course of and pattern of trial. Her letters to the court, I think, grabbed quite a lot of attention, and then she started getting annoyed at the attention, and then started kind of pushing back and forth. So that was interesting. Sarah Shuffles says, so close to 800K, let's make it happen, chat. I mean, there's almost 30,000 of you here. There's definitely enough of you here to make it happen. But I also respect that sometimes people are like, I don't want to subscribe. That's fine. Just download the app. EDB opening a lawyer-based bar called Sidebar. I'm sure there are sidebars somewhere. I'm sure there are sidebars near courthouses. I am sure that there are. Just instead of a sports bar, you just run like historic trials on the TVs all the time. Then it's going to become like a whole like true crime themed bar. You just run trials all the time, make it look like an old library with like dark brown leather furniture and like old school law books from all over the world, and you can only drink whiskey. Maybe the sidebar. Let's see. Kimberly said, did you ever want to be a judge? Not really. It's my face is loud, and it's heavy on the decision making all day long, which is fatiguing, and you don't really get to be an advocate. You are a neutral bystander. I also don't have the all the patience, and I think the judicial temperament of patience is really needed. I also don't think I could sit through trial without being like, really? This is what you're saying? I don't think I could. I don't think I could. Lisa said, will Sarah Boone say something out loud if found guilty? I don't think so. I think we won't see much. She might make if she is convicted, she may make a statement at her own sentencing. She may not. She's been very respectful during this trial, and was very restrained and respectful in her commentary. I don't think she will. So we'll see. Sally, thank you. Subscribe to the 800K Bing. Robin said, I'm at Disney World and begging my husband to drop me off at the courthouse. He said no. You still have time. Robin E., there is still time to make it to closing arguments. Look, court is running like an hour behind now, so there is still time to make it to closing arguments. There's time. Just take the Mickey ears off before you go to closing arguments. And this time of day, it would probably be pretty fast to get in the courthouse. You're not going to hit like a long line. So Allison said, Law & Order app is great. Knew when to be back. And for those of you that have it, when closing arguments start, when, if ever, closing arguments start, we will let you know. Like I kind of know the pattern of the jury instructions. As we get towards the end of the jury instructions, I will send out a notification that we are about to start closing, because we're now an hour behind where they were supposed to be. Court's dynamic. Who knows when we start? So, and the app development team and Team Baker built an app that I think we all love. So, Miguelina, the pattern of closing arguments will be...
State, are you ready to proceed?
Jury instructions first.
Defense, are you ready to proceed?
That'll take about 30 minutes. So jury instructions read to the jury, it'll take 30, 45 minutes. then the state's closing, then the defense closing, then the state's rebuttal. Then the final jury charge, which will be less than 10 minutes. Then the jury will go back to deliberate.
We're ready, Judge.
Let's go ahead and bring in our jury.
Bring the jury.
I've never been so happy to hear those words.
Bring the jury. Bring the jury.
I also miss Judge Newman. Judge Newman's face wasn't as snarky. This judge on occasion is like, how are we getting there? Which I love. But now we're going to bring the jury. I imagine for the defendant at this point, your heart has to be pounding. This is the most important part of your case. You don't know what if any videos the prosecution's going to play of the shit that you've done. And it's going to be wild. So we've got about 30 minutes of jury instructions. They're going to instruct the jury. And then we'll go. So let us see what happens. But this has gone pretty quickly. Victoria, will they poll the jury when they come back with a verdict? I don't know the procedure for this court. I would hope so. Most courts poll the jury. I mean, most courts poll the jury. So I saw a question, any time limit on closing statements or closing arguments? The judge did not impose a time limit. He asked for an estimate so they could decide when to take the afternoon comfort break so the jury could stretch. But each side said they had at least an hour and a half. So we're looking at 3 hours, maybe more.
Jury entering.
So we're going to get into instructions to the jury before closing arguments. And then we will get to closing arguments. And as I said, we'll update you in the app.
State, do you recognize our jury?
Yes, Your Honor.
Defense, do you recognize our jury?
Yes.
Everyone can be seated. Thank you.
Karen
of the
in
jury,
the
thank
chat
you for
asked, do
your
jurors
patience.
get the transcripts? It depends on what it
We had
is.
a long conversation about the jury
If it's
instructions.
video, yes.
And I missed a typo or two after I had printed everything, and took us a while to print everything out.
Look
I'm going to ask the
at
courtroom deputy to
how
come
much
forward
paper.
and pass these out to you. If you can, please raise your hands to confirm that you complied with the court's instructions during the break. All right, record will reflect all hands have been raised. Members of the jury, we are at the conclusion of the evidence and testimony in this case. The court is now going to instruct you on the law. The courtroom deputy is providing you copies of the jury instructions. Like I said at the beginning, you're going to be able to take these back with you into the deliberation room. There's not going to be a quiz or a test at the end. You don't need to memorize anything. If you'd like to read along, you can. If you just want to listen, you can. It's completely up to you. Court's going to read most of the instructions and then turn it over to the lawyers for their closing arguments. The state will go first, as they have the burden. Then the defense will go. And then the state will have the opportunity to rebut. Then I will conclude the instructions and release you for your deliberations. After the state's closing, we're going to take our afternoon recess. At that point in time, I'll have the courtroom deputy provide you that emergency number. So if you need to reach out into your family or loved ones to let them know that you are on the jury and are deliberating, you can do that at that time. With that, members of the jury, the court's going to go ahead and begin reading you the jury instructions. Instruction 3.1, Introduction to Final Instructions. Members of the jury, I thank you for your attention during this trial. Please pay attention to the instructions I am about to give to you. 3.2, Statement of the Charge. Sarah Boone, the defendant in this case, has been accused of the crime of second-degree murder. 7.1, Introduction to Homicide. Sarah Boone is accused
Sounds like a
of
law school
second-degree
class.
murder. Murder in the second degree includes the lesser crime of manslaughter, both of which are unlawful. However, a killing that was excusable or that was committed by the justifiable use of deadly force is lawful. If you find Jorge Torres was killed by Sarah Boone, you will then consider the circumstances surrounding the killing in deciding if the killing was second-degree murder or was manslaughter, or whether the killing was excusable or resulted from justifiable use of deadly force. Justifiable homicide. The killing of a human being is justifiable homicide and lawful if necessarily done while resisting an attempt to murder or commit a felony upon the defendant, or to commit a felony in any dwelling house in which the defendant was at the time of the killing. Excusable homicide. The killing of a human being is excusable and therefore lawful under any one of the following three circumstances. 1, when the killing is committed by accident and misfortune in doing any lawful act by lawful means with usual, ordinary caution and without any unlawful intent. Or 2, when the killing occurs by accident and misfortune in the heat of passion upon any sudden and sufficient provocation. Or 3, when the killing is committed
reading voice
by
is
accident
excellent.
and misfortune resulting from a sudden combat, if a dangerous weapon is not used and the killing is not done in a cruel or unusual manner. A dangerous weapon is any object that will likely cause death or great bodily harm if used in the ordinary and usual manner contemplated by its design and construction. Great bodily harm means great, as distinguished from slight, trivial, minor, or moderate harm, and as such, does not include mere bruises. I now instruct you on the circumstances that must be proved before Sarah Boone may be found guilty of second-degree murder or any lesser included crime. 7.4, murder, second degree. To prove
Jury
the crime
instructions
of
before
second-degree
closing, y'all.
murder, the state must prove the following three elements beyond a
These are
reasonable
the
doubt.
elements.
1, George Torres is dead. 2, the death was caused by the criminal act of Sarah Boone. 3, there was an unlawful killing of George Torres by an act imminently dangerous to another and demonstrating a depraved mind without regard for human life.
They'll define that.
An act includes a series of related actions arising from and performed pursuant to a single design or purpose. An act is imminently dangerous to another and demonstrating a depraved mind if it is an act or series of acts that, 1, a person of ordinary judgment would know is reasonably certain to kill or do serious bodily injury to another, and 2, is done from ill will, hatred, spite, or an evil intent, and 3, is of such a nature that the act itself indicates an indifference to human life. In order to convict of second-degree murder, it is not necessary for the state to prove the defendant had an intent to cause death. 3.4, when there are lesser included crimes or attempts. In considering the evidence, you should consider the possibility that although the evidence may not convince you that the defendant committed the main crime of which she is charged, there may be evidence that she committed other acts that would constitute a lesser included crime or crimes. Therefore, if you decide that the main accusation has not been proved beyond a reasonable doubt, you will next need to decide if the defendant is guilty of any lesser included crime. The lesser crimes indicated in the
And then those will be
definition of
defined as well?
second-degree murder is manslaughter, culpable negligence. 7.7, manslaughter. To prove the crime of manslaughter, the state must prove the following two elements beyond a reasonable doubt. 1, George Torres is dead. 2A, Sarah Boone intentionally committed an act or acts that caused the death of George Torres. B, the death of George Torres was caused by the culpable negligence of Sarah Boone.
And that's the difference
Yes.
between that and second degree is the culpable negligence.
I apologize, or thank you for that clarification. Sarah Boone I'll reread those for you. 2A, Sarah Boone intentionally committed an act or acts that caused the death of George Torres, or B,
Right.
the death of George Torres was caused by the culpable negligence of Sarah Boone.
And that's the difference.
Every person
The
has a
reason
duty.
the prosecution spoke up there is because the judge had skipped the or, and if the jury thinks they have to find this and this, it can be very confusing. So the prosecution was like, there's an or there, and the judge reread it. So that's why there was that brief interruption. But lawyers have to read along with these and make sure they are verbally read exactly as they are on the sheet.
To act reasonably towards others. If there is a violation of that duty without any conscious intent to harm, that violation is negligence. The defendant cannot be guilty of manslaughter by committing a merely negligent act, or if the killing was either justifiable or excusable homicide, as I have previously instructed you. In order to convict of manslaughter by act, it is not necessary for the state to prove that the defendant had an intent to cause death, only an intent to commit an act that was not merely negligent, justified, or excusable, and which caused death. I will now define culpable negligence for you. As I have said,
It's a lower
every
standard.
person has a duty to act reasonably towards others. If there is a violation of that duty without any conscious intention to harm, that violation is negligence. But culpable negligence is more than a failure to use ordinary care
Conscious
towards
intention to
others.
harm is going to be
In order for negligence to be culpable, it must be gross and flagrant. Capable negligence is a course of conduct showing reckless disregard of human life or of the safety of persons exposed to its dangerous effects, or such an entire want of care as to raise a presumption of a conscious indifference to consequences, or which shows wantonness or recklessness, or a grossly careless disregard for the safety and welfare of the public, or such an indifference to the rights of others as is equivalent to an intentional violation of such rights. The negligent act or omission must have been committed with an utter disregard for the safety of others. Culpable negligence is consciously doing an act or following a course of conduct that the defendant must have known or reasonably should have known was likely to cause death or great bodily injury. 8.9, culpable negligence. To prove the crime of culpable negligence, the state must prove the following two elements beyond a reasonable doubt.
this
One,
is that misdemeanor.
Sarah Boone exposed Jorge Torres Jr. to a personal injury.
I'm surprised I
Two,
didn't edit out the
she
junior there.
did so through culpable negligence. Actual injury is not required. I will now define culpable negligence for you. Each of us has a duty to act reasonably towards others. If there is a violation of that duty without any conscious intent to harm, that violation is negligence. But culpable negligence is more than a failure to use ordinary care for others. In order for negligence to be culpable, it must be gross and flagrant. Culpable negligence is a course of conduct showing reckless disregard for human life or for the safety of persons exposed to its dangerous effects, or such an entire want of care as to raise a presumption of a conscious indifference to consequences, or which shows wantonness or recklessness, or a grossly careless disregard for the safety and welfare of the public, or shows such indifference to the rights of others as is equivalent to an intentional violation of such rights. 3.6D, as in Delta, voluntary intoxication. Voluntary
Yeah, it seemed like that was
intoxication
duplicated to
resulting
me
from
as
the
well.
use of alcohol is not a
On the
defense to a
culpable
crime.
negligence, it seemed like there were two
Evidence
two
of a
pages.
defendant's voluntary intoxication may not be taken into consideration to show that she lacked the specific intent to commit any crime. A
Voluntary
person is
intoxication
voluntarily
does not count.
intoxicated if he or she knowingly consumed a substance that he or she knew should have known could cause intoxication. Voluntary intoxication is not a defense to second-degree murder, manslaughter, or culpable negligence. 3.6F, as in Foxtrot, justifiable use of deadly force. It is a defense to the crimes of second-degree murder, manslaughter, and culpable negligence if the actions of Sarah Boone constituted the justifiable use or threatened use of deadly force. Deadly force means force likely to cause death or great bodily harm. Great bodily harm means great, as distinguished from slight, trivial, minor, or moderate harm.
Yes, all the
Sarah
words have to be
Boone does
defined.
not have the burden of proving that she was justified in using
The
deadly force.
self-defense.
Instead, for you to find Sarah Boone guilty, the state must prove beyond a reasonable doubt that Sarah Boone was not justified in using deadly force. The law on the justifiable use, deadly force, is as follows. Sarah Boone was justified in using deadly force if she reasonably believed that such force or threat of force was necessary to prevent imminent death or great bodily harm to herself. Sarah Boone had no duty to retreat before using deadly force. In deciding whether Sarah Boone was justified in the use of deadly force, you must consider the circumstances at the time the force or threat of force was used. The danger need not have been actual. However, to justify the use of deadly force, the appearance of imminent danger must have been so real that Sarah Boone actually believed the use of deadly force was necessary. Moreover, to justify the use of deadly force, a reasonably cautious and prudent person under the same circumstances would have believed the use of deadly force was necessary. However, the use of deadly force is not justified if you find that Sarah Boone used force to initially provoke the threatened use of force against herself, unless 1. The threat of force asserted towards the defendant was so great that she reasonably believed that she was in imminent danger of death or great bodily harm. Please silence your cell phones.
Ooh, the judge is not going to like that.
And had it exhausted.
And yes, that was the victim's family they were showing, including his brother.
Whoever phone is on, get out right now.
Get it, Your Honor! Woo! The bailiff is going to be like, whoop.
I'm going to read that.
When the judge is using that voice, look, it is so distracting when there is noise in court, when you are trying to pay attention. These are not easy to pay attention to, and it is critically important. So for somebody's phone to be going off, I'm not surprised the judge just absolutely was like, now. If it was a member of the victim's family, I don't think the judge would have responded that way. It would have been just a member of the gallery. If it was the victim's family, the judge would have said, I need you to take a minute and silence your phone. It was not, and that is why that response from the judge. But the get out now, I was like, damn, man. So the judge is going to reread that.
Members of the jury, I apologize.
You guys know breaking news in the chat. Thank you. I know there's a lot going on in the world, as always,
Paragraph
but
1.
We just do
The
this.
threat of force asserted toward the defendant was so great that she reasonably believed that she was in imminent danger of death or great bodily harm, and had exhausted every reasonable means to escape the danger, other than using deadly force on Jorge Torres. Or 2.
This instruction is
In good
critical
faith,
for the state.
Sarah Boone withdrew from physical contact with Jorge Torres and clearly indicated to Jorge Torres that she wanted to withdraw and stop the use of deadly force. But Jorge Torres continued or resumed the threatened use of force. Physical contact includes any restraint on Jorge Torres's movement. If you find that Sarah Boone, who because of prior threats or difficulties with Jorge Torres Jr., had reasonable grounds to believe that she was in danger of death or great bodily harm at the hands of Jorge Torres, you may consider this fact in determining whether the actions of Sarah Boone were those of a reasonable person. If you find that at the time of the alleged second-degree murder, manslaughter, or culpable negligence, Sarah Boone knew that George Torres had committed an act or acts of violence, you may consider that fact in determining whether Sarah Boone reasonably believed it was necessary for her to use deadly force. In considering the issue of self-defense, you may take into account the relative physical abilities and capacities of Sarah Boone and George Torres.
How many of you just turned your cell phones off in your own homes?
I am too.
Okay.
Was there
We
an,
will remedy that. Thank you, sir.
was there an error?
Is it just your copy, Mr. Owens?
Anybody else missing tenant?
That was a typo, it sounds like. That typo was in there earlier. I see somebody asking, will we find out who's kicked out of court? No, I don't think who's in the gallery matters that much for our purposes
We'll bring it to you, sir.
outside of the victim's family. I mean, my ringer's almost always off too.
And we'll wait till have this, sir, and we'll continue.
The chat is like, your ringer on in the year 2024? I mean, do people use their phones for fun anymore? I have mine silenced except for calls from my spouse and my kid.
Thank you.
If those went
Record
off.
reflect all thumbs.
But if I was in court, it would be on Do Not Disturb mode.
Page
so.
11, special instruction on battered spouse syndrome. You have heard evidence that...
I'm just going to answer it because I saw like 10 of you ask. If someone's kicked out of court like that, can they re-enter? No. This instruction is regarding the battered spouse syndrome and how the jury is to use it. Also a very important instruction for both parties.
Sarah Boone suffers from battered spouse syndrome. If you find the evidence that Sarah Boone suffers from battered spouse syndrome credible, you may consider this evidence to assist you in determining whether a person in Sarah Boone's circumstances would reasonably believe that such force was necessary to defend herself against the imminent use of unlawful force by George Torres. Like other witnesses, you may believe or disbelieve all or any part of the testimony regarding battered spouse syndrome. 3.6G, justifiable use of non-deadly force. It is a defense to the crimes of second-degree murder, manslaughter, and culpable negligence if the actions of Sarah Boone constituted the justifiable use non-deadly force. Non-deadly force means force not likely to cause death or great bodily harm. Great bodily harm means great, as distinguished from slight, trivial, minor, or moderate harm. Sarah Boone does not have the burden of proving that she was justified in using non-deadly force. Instead, for you to find Sarah Boone guilty, the state must prove beyond a reasonable doubt that Sarah Boone was not justified in using non-deadly force. The law on the justifiable use of non-deadly is as follows. Sarah Boone was justified in using non-deadly force against George Torres and had no duty to retreat if she reasonably believed that such conduct was necessary to defend herself against George Torres's imminent use of unlawful force. In deciding whether Sarah Boone was justified in the use of non-deadly force, you must consider the circumstances at the time the force or threat of force was used. The danger need not have been actual. However, to justify the use of non-deadly force, the appearance of imminent danger must have been so real that Sarah Boone actually believed the use of non-deadly force was necessary. Moreover, a reasonably cautious and prudent person under the same circumstances would have believed the use of non-deadly force was necessary. However, the use of non-deadly force is not justified if you find that Sarah Boone used force to initially provoke or threatened use of force against herself, unless one, the threatened force asserted towards Sarah Boone was so great that she reasonably believed that she was in imminent danger of death or great bodily harm and had exhausted every reasonable means to escape the danger other than using non-deadly force on George Torres. Or 2, in good faith, Sarah Boone withdrew from physical contact with Jorge Torres and indicated clearly to Jorge Torres that she wanted to withdraw and stop the use of non-deadly force. But Jorge Torres continued or resumed or threatened use of force. Physical contact includes any restraint on Jorge Torres' movement. If you find that
Any
Sarah
restraint.
Boone, who, because of prior threats or difficulties with Jorge Torres Jr., had reasonable grounds to believe that she was in danger of imminent use of unlawful force at the hands of Jorge Torres Jr., you may consider this fact in determining whether the actions of Sarah Boone were those of a reasonable person. If you find that at the time of the alleged second-degree murder and/or culpable negligence, Sarah Boone knew that Jorge Torres Jr. had committed an act or acts of violence, you may consider that fact in determining whether Sarah Boone reasonably believed it was necessary for her to use non-deadly force. In considering the issue of self-defense, you may take into account the relative physical abilities and capacities of Sarah Boone and Jorge Torres.
We should
Special
be almost
instruction
done.
on battered spouse syndrome. You have heard evidence that Sarah Boone suffers from battered spouse
This should be
syndrome.
one of the last instructions.
If you find the evidence that Sarah Boone suffers from battered spouse syndrome credible, you may consider this evidence to assist you in determining whether a person in Sarah Boone's circumstances would reasonably believe that such force was necessary to defend herself against the imminent use of unlawful force by Jorge Torres. Like other witnesses, you may believe or disbelieve all or any part of the testimony regarding battered spouse syndrome. 3.7, plea of not guilty, reasonable doubt, and burden of proof.
Yeah, this should be the last.
The defendant has entered a plea of not guilty. This means you must presume or believe the defendant is innocent. The presumption stays with the defendant as to each material allegation in the information through each stage of the trial, unless it has been overcome by the evidence to the exclusion of and beyond a reasonable doubt. To overcome the defendant's presumption of innocence, the state has the burden of proving the crime with which the defendant is charged was committed, and the defendant is the person who committed the crime. Whenever the words reasonable doubt are used, you must consider the following. Proof beyond a reasonable doubt does not mean proof beyond all doubt. A reasonable doubt is not a mere possible doubt, a speculative, imaginary, or forced doubt. Such a doubt must not influence you to return a verdict of not guilty if you have an abiding conviction of guilt. On the other hand, if after carefully considering, comparing, and weighing all the evidence, there is not an abiding conviction of guilt, or if, having a conviction, it is one which is not stable, but one which wavers and vacillates, then the charge is not proved beyond every reasonable doubt, and you must find the defendant not guilty because the doubt is reasonable. It is to the evidence introduced in this trial and to it alone that you are to look for that proof. A reasonable doubt as to the guilt of the defendant may arise from the evidence, conflict in the evidence, or the lack of evidence. If you have a reasonable doubt, you should find the defendant not guilty. If you have no reasonable doubt, you should find the defendant guilty. 3.9, weighing the evidence. It is up to you to decide what evidence is reliable. You should use your common sense in deciding which is the best evidence and which evidence should not be relied upon in considering your verdict. You may find some of the evidence not reliable or less reliable than other evidence. You should consider how the witnesses acted as well as what they said. Some things you should consider are: 1, did the witness seem to have an opportunity to see and know the things about which the witness testified? 2, did the witness seem to have an accurate memory? 3, was the witness honest and straightforward in answering the attorney's questions? 4, Did the witness have some interest in how the case should be decided? 5. Does the witness's testimony agree with the other testimony and other evidence in the case? 6. Did the witness at some other time make a statement that is inconsistent with the testimony he or she gave in court? Whether the state met its burden of proof does not depend upon the number of witnesses it has called or upon the number of exhibits it has offered, but instead upon the nature and quality of the evidence presented. The fact that a witness is employed in law enforcement does not mean that his or her testimony deserves more or less consideration than that of any other witness. Expert witnesses are like other witnesses, with one exception. The law
They know
permits
some
an
shit.
expert witness to give his or her opinion.
And have hypotheticals.
However, an expert opinion
It's
is
only worth
reliable
the expert.
only when given on a subject about which you believe him or her to be an expert. Like other witnesses, you may believe or disbelieve all or any part of an expert's testimony. The defendant in this case has become a witness. You should apply the same rules to consideration of her testimony that you apply to the testimony of the other witnesses. It is entirely proper for a lawyer to talk to a witness about what testimony the witness would give if called to the courtroom. The witness should not be discredited by talking to a lawyer about his or her testimony. You may rely upon your own conclusion about the credibility of any witness. A juror may believe or disbelieve all or any part of the evidence or the testimony of any witness. 3.9 Bravo, defendant statements. A
I would pay
statement
for him
claimed
to
to
say
have been
bravo,
made
bravo,
by the
fucking
defendant
bravo.
outside of court has been placed before you. Such a statement should always be considered with caution and be weighed with great care to make certain it was freely and voluntarily made. Therefore, you must determine from the evidence that the defendant's alleged statement was knowingly, voluntarily, and freely made. In making this determination, you should consider the total circumstances, including, but not limited to, 1. Whether, when the defendant made the statement, she had been threatened in order to get her to make it, and 2. Whether anyone had promised her anything in order to get her to make it. Law enforcement is not legally required to ask a suspect whether he or she wants to talk to law enforcement after Miranda warnings are read to a suspect. This is, however, one of the factors you may consider whether the defendant's statements were voluntarily made. If you conclude the defendant's out-of-court statement was not freely and voluntarily made, you should disregard it. 3.10, Rules for Deliberation. These are some general rules that apply to your discussion. You must follow these rules in order to return a lawful verdict. 1. You must follow the law as it is set out in these instructions. If you fail to follow the law, your verdict will be a miscarriage of justice. There is no reason for failing to follow the law in this matter. All of us are depending upon you to make a wise and legal decision in this matter. 2. This case must be decided only upon the evidence that you have heard from the testimony of the witnesses and have seen in the form of exhibits and evidence in these instructions. 3. This case must not be decided for or against anyone because you feel sorry for anyone or are angry at anyone. 4. Remember, the lawyers are not on trial. Your feelings about them should not influence your decision in this case. 5. Your duty is to determine if the defendant has been proven guilty or not in accord with the law. It is the judge's job to determine a proper sentence if the defendant is found guilty. 6. Whatever verdict you render must be unanimous. That is, each juror must agree to the same verdict. 7. Your verdict should not be influenced by feelings of prejudice, bias, or sympathy. your verdict must be based on the evidence and on the law contained in these instructions. 3.11.
That looks like a we're
Cautionary
almost
instruction.
done breath. Yep.
Deciding a verdict is exclusively your job. I cannot participate in that decision in any way. Please disregard anything I may have said or done that made you think I preferred one verdict over another.
Literally all you said was bless you and get out.
2.7, closing argument. Both the state and the defendant have now rested their case.
Now we're
The
at
attorneys
end.
now will present their final arguments. Please remember that what the attorneys say is not evidence
I love
or your
closings.
instruction on the law. However, do listen closely to their arguments. They are intended to aid you
They are to
in
help.
understanding the case.
Yay.
Each side will have equal time, but the state is entitled to divide this time between an opening argument and a rebuttal argument after the defense has given its closing argument.
All right, let's go,
With that,
everybody.
State, you may
State.
proceed.
State, stay with the microphones. Because opening was a challenge for everyone's ears. So we're going to have maybe an hour, I would think, of the state's closing. Let's see, it is 3:05 local time. So each side indicated they'd be about an hour and a half. And the prosecutors can divide their closing between attorneys?
This is a box.
Yep.
This is the box where Jorge Torres was killed. It's a small box, 28 by 20 by 8 7/8 inches. Jorge Torres was zipped up in this box.
He should have called it a coffin.
Jorge Torres
Just saying.
took his last panicked breaths
This suitcase was a coffin.
in this box. The medical examiner explained to us that with each breath Jorge Torres took in, there was less oxygen in this box. Jorge Torres was murdered in this box. Ladies and gentlemen, on behalf of myself, my trial partner, we thank you for your time and attention in this most important of trials. We now have the law from the judge in this case.
This is why I like the
This is
instruction.
what our duty is to follow. And let's have a discussion regarding that law that we've just been read and given.
This is why I like pre-instruction, because now we can say that you've heard this from the judge and now they hear it a second time and then a third time. It helps the jury understand.
First section of note we're going to come to is called Introduction to Homicide. But this being a legal document written by a bunch of lawyers who you've seen for the last 2 weeks,
They're hard to
arguing
understand.
with each other, pay careful attention to ands and ors. Remember, if an and is somewhere, we're going to need both things or all the things, and if an or is there, then only one of those things we're going to need. So as we start out here on Introduction to Homicide,
I like it when they go through
come to
the
first
the instructions.
section on justifiable homicide. And it reads, the killing of a human being is justifiable homicide and lawful if necessarily done while resisting an attempt to murder or commit a felony upon the defendant, or to commit a felony in any dwelling house in which the defendant was at the time. Ladies and gentlemen, this section is completely inapplicable. It's inapplicable because Jorge Torres was zipped up in that suitcase.
Right.
He couldn't commit or attempt to commit a murder on anybody. He couldn't even scratch his own head while he was in that suitcase. Next, we turn to excusable homicide. Here we have several paragraphs, and it reads, "The killing of a human being is excusable and therefore lawful under any one of the following three circumstances. When the killing is committed by accident, and in misfortune, in doing any lawful act by lawful means, with usual ordinary caution, and without any unlawful intent." Well, the problem in this circumstance for the defendant is that she took the law into her own hands. Her testimony was that when Jorge Torres was in here, he was laughing and giggling and they were joking. And then he started to complain that he couldn't breathe. And that's when she said that she wanted him to stay in there so he could feel uncomfortable. So he could feel her grievances. Ladies and gentlemen, that is not lawful. That is not the use of ordinary caution. And that is not applicable in this circumstance. Second, when the killing occurs by accident or misfortune in the heat of passion upon any sudden and sufficient provocation. Jorge Torres couldn't provoke anything from his circumstance. Jorge Torres was confined to this box.
Couldn't do anything.
Next, when the killing is committed by accident and misfortune resulting from a sudden combat, a dangerous weapon is not used,
Bless you.
the killing is not done in a cruel and unusual manner. Well, this fails on 2 counts. There was no sudden combat. In her words, this was laughing and joking and we're all having fun when she decides that it's going to get a little extra real for Jorge Torres. And it fails on the 2nd count because Jorge Torres was killed in a cruel and unusual manner. Next, we turn to our main charge of second-degree murder.
I like how he told the jury, look, you can ignore
The
these.
law informs
These don't
us
apply. Don't even worry yourself about
To
them.
prove the crime of second-degree murder, the
Not
state
needed.
must prove the following 3 elements
This is what you need to worry
beyond
about.
a reasonable doubt. I think it's important to stop right here. This sentence right here is telling us what has to be proven in order for the crime of second-degree murder to be, for the defendant to be found guilty in this case. We've been hearing all kinds of facts for almost 2 weeks now of trial. But these are the 3 facts that had to have been met by the reasonable doubt standard in order to be found guilty. Ladies and gentlemen, I submit to you that the state has proven second-degree murder beyond all doubt. And the proof of that guilt is overwhelming. But I will cite for each element just one fact that conclusively proves each of those elements beyond all doubt. As to the first fact, that Jorge Torres is dead,
Yep.
well, we have stipulation,
And the coroner,
amongst other things,
and the ME,
that agrees to that.
you've heard about his autopsy.
As to the second fact,
Was it caused by defendant?
death was caused by Sarah Boone.
Even she agrees.
Sarah Boone, in her own words, from the time that this case began on February 23rd, 2020, to when she took the witness stand a few days ago, was consistent about one statement. She zipped him up. She didn't zip him out. She zipped him up in the suitcase, and she refused to zip him out. 3, there was an
Imminently
unlawful
dangerous.
killing of Jorge Torres by an act imminently dangerous to another and demonstrating a depraved mind without regard for human life. The law goes on to define for us what a depraved mind is,
Did she care?
and also what an act is.
Did she care?
It's going to tell us
Or she like stay
that an
there?
act includes any series of related actions arising from and performed pursuant to a single design or purpose. An act is imminently dangerous to another in demonstrating a depraved mind if it is an act or a series of acts that, one, a person of ordinary judgment would know is reasonably certain to kill or do serious bodily harm to another, and is done from ill will, hatred, spite, or an evil intent,
And
is of such a nature that the act itself displays an indifference to human life.
says indicate.
Ladies and gentlemen, her conduct fits every one of those things. And if there was a scintilla of doubt that this was not the actions of a depraved mind, I point to you.
Is he going to play the video?
1062, and states 17. Mr. J, may you publish states
Yeah,
17?
play the video. That's a perfect place to play the video. It's a well-executed place to play the video. Here it is. I love it when they use the jury instructions in closing. It makes it so clear for the jury. It's like, if there was any question about what she thought, here's the answer. Their case is just push play.
Hello. Everything you've done to me. Hello. For everything you've done to me. Hello. Fuck you. Hello. Fuck you. Hello. Stupid. Hello. That's my name. Don't wear it up. I can't fucking breathe, babe. Seriously. Yeah, that's when you do me, shake me. Sarah.
don't know if they asked to approach. I don't know what they did, but the feed is still going. Court is still happening. I think they, it looks like I think that's the victim's mother. I wonder if she was crying in court and they asked her to leave. So it looks like the victim's mother is, I think that's the victim's mother is leaving court, and it might, or might have asked if she could leave court. The prosecution should have let them know that the video was going to be played in closing. They should have given the family the heads up, and then it looks like the attorneys are approaching. If she was sobbing, they might want to put that on the record. So it looks like they are still up at sidebar. Let me just back up because I paused. So outbursts in court during closing can be a problem, even if it's just a uncontrolled sob. So, yep. And then they said, you may continue. Heartbreaking, and the prosecution should have given them a heads up. I hope they did.
Sarah, I can't breathe, baby. That's on you. Sarah, I can't breathe. It's on you. Sarah. Real ransom. Might want to give it for it extra.
It's harder to watch after this trial. This is harder to watch than it was earlier.
I can't breathe, babe. Oh. That's what I feel like when you cheat on me. Sarah. Fuck you. Breathe, Sarah. Yeah. You should probably shut the fuck up.
Absolutely more chilling after seeing this entire trial, isn't
Ladies and
it?
gentlemen, that exhibit removes any scintilla of doubt about the depravity of the defendant's actions.
It's a strong argument.
But we know from the evidence that this was not the first time she had considered killing Jorge Torres. We know from the evidence that on January 13, 2020, approximately 1 month prior to Jorge Torres' murder, the defendant had a text message conversation. Please do something with yourself, Sarah. God bless you. And bless you and all of you too. I'll get rid of him. Then I'll be better. Torres. But ladies and gentlemen, in this case, the law actually specifically tells us that the intent to cause death is not necessary. In order to convict of second-degree murder, it is not necessary for the state to prove the defendant had an intent to cause death. Next, we turn. I'm going to bypass the lesser included offenses because though she is guilty of those offenses as well, the law instructs us that she is to be convicted of for the highest offense in which the evidence supports, which is second-degree murder in this case.
Y'all don't need to worry about those lessers.
So turning our
She's guilty of
attention
second
towards
degree.
voluntary intoxication. If there was any question about the fact that Sarah imbibed alcohol on the night that George Torres was murdered, and that maybe somehow that would excuse the conduct or be some type of defense for the conduct. Well, this tells us that that's not the case. Voluntary intoxication resulting from the use of alcohol is not a defense to a crime. Evidence of a defendant's voluntary intoxication may not be taken into consideration to show that she lacked the specific intent to commit any crime. A person is voluntarily intoxicated if he or she knowingly consumed a substance that he or she knew or should have known could cause intoxication. Voluntary intoxication is not a defense to second-degree murder, manslaughter, or culpable negligence. Ladies and gentlemen, there's ample evidence of the defendant's intoxication from watching her on the public surveillance, buying the bottles of wine with George Torres, to her admissions to drinking, to her voice that we heard on the video while she was torturing George Torres. Next, we come to defenses. First,
So now we're going to get into the self-defense
justifiable
instructions.
use of deadly force.
And we'll talk about justifiable, I imagine.
It tells us it is a defense to the crimes of second-degree murder, manslaughter, and culpable negligence if the actions of Sarah Boone were justifiable use or threatened use of deadly force. Sarah Boone does not have the burden of proving that she was justified in using deadly force.
True.
Instead, for you to find Sarah Boone guilty, the state must prove beyond a reasonable doubt that Sarah Boone
She was not justified.
justified in using deadly force. The law on the justifiable use of deadly force is as follows. Sarah Boone was justified in using deadly force if she reasonably believed that such force or threat of force was necessary to prevent the imminent death or great bodily harm to herself. Sarah Boone had no duty to retreat. Ladies and gentlemen, in a few moments, Mr. Owens will rise, and he is going to show you.
They're going to save a lot of their closing
Yes.
for rebuttal, I think. I love the use of the defense exhibits. I love it. The defense shouldn't have left those up there. If they were behind table, it would be awkward to go grab them, but they're
Yes.
sitting up there. He's going to show you all this stuff. It doesn't matter. Great move, counsel.
And this
Owen should have put those behind counsel table.
and he's going to talk
About this.
in this as well about the list of grievances that Sarah Boone had for George Torres. He's going to talk to you about curtain rods.
That's why you keep your exhibitees away from opposing counsel. And if you leave them up there, they might write on
Talk to you
them.
about black eyes.
He is. can feel the disdain, right?
He's going to talk to you about what an awful, awful boyfriend Jorge Torres was. And ladies and gentlemen, at the end of all of that, it still will not change the fact that
On this
the
day.
defendant is not entitled to the justifiable use of deadly force. Because as we continue to read this instruction, it tells us, in deciding whether Sarah Boone was justified in using the use of deadly force, you must consider the circumstances at the time the force or the threat of force was used. Danger need not have been actual. However, to justify the use of deadly force, the appearance of imminent danger must have been so real
At that time.
that Sarah Boone actually believed that deadly force was necessary. Moreover, to justify the use of deadly force, and this is important,
Reasonable.
a reasonably cautious and prudent person under the same circumstances would have believed the use of deadly force was necessary. Ladies and gentlemen, no reasonably prudent and cautious person would believe that a man to initially provoke
I don't know why the feed just jumped. Ugh.
used force to initially
That was the feed.
provoke threatened use of force against herself. Let's stop there before we consider the next two paragraphs. Some of the most critical testimony
Oh, nope,
in
it
this
jumped.
trial.
It jumped a minute. Hold on. That was odd. Sorry, y'all.
However, the use of deadly force is not justified if you find that Sarah Boone used force to initially provoke threatened use of force.
That's so strange. It jumped more than I anticipated, actually. That's incredibly strange. Apologies, law nerds.
Deadly force was necessary.
There we go.
Moreover, to justify the use of deadly force, and this is important,
All right, there we go. We're caught.
a reasonably cautious and prudent person under the same circumstances would have believed the use of deadly force was necessary. Ladies and gentlemen, no reasonably prudent and cautious person would believe that a man who could barely fit into this box, who was incapable of movement, who was begging for his life, who was slowly asphyxiating, suffocating with each breath, would have needed to use deadly force against him. The justifiable use of deadly force utterly fails, utterly crashes like a house of cards. But there's more.
But wait, there's more.
However, the use of deadly force is not justified if you find that Sarah Boone used force to initially provoke threatened use of force against herself. Let's stop there before we consider the next two paragraphs. Some of the most critical testimony in this trial
Did she provoke the use against her? What he said, did she provoke that?
is her testimony on the stand. It was a great day. We were doing puzzles and artwork, dancing with the dogs, listening to music. Tag, you're it, hide and go seek time. George gets into the suitcase. She comes and zips him up. They were still laughing about it. We're still laughing after he's zipped up in the suitcase. And then that's when George had the temerity to ask, George Torres had the temerity to ask to be unzipped from the suitcase. And that's when Sarah Boone decided he needed to suffer.
That's when she grabbed the
She
bat.
was the initial aggressor, ladies and gentlemen. She provoked the use of force in this case. In her own
If you can even call
words,
it that.
we were laughing and playing right before he wanted to be let out because he couldn't breathe. Paragraph 1. The threat of force asserted toward the defendant was so great that she reasonably believed that she was in imminent danger of death or great bodily harm and had exhausted every reasonable means to escape the danger other than using deadly force on George Torres.
Could she have done anything else?
He couldn't exert anything, ladies and gentlemen. He couldn't, George Torres couldn't even exert his arm out of the suitcase. How on earth could he have exerted a force so great to justify his...
Judge, I object.
Roach.
And there's the objection to argument. All right, now we can catch back up because now they're at sidebar with objection to argument. I appreciate that Owens said I object and just went to the bench, didn't say anything. That's appropriate. I don't see what's objectionable, but we'll see where we go after this.
This is of no help to the defendant.
He moved on.
Second paragraph.
He might have objected to facts not in evidence, but he's arguing he couldn't even get his arm out. That might have been the objection because you don't necessarily know what the victim could or could not have done. So it might have been that. So we'll see.
In good faith,
Because he did move on.
Sarah Boone withdrew from physical contact with George Torres and clearly indicated to George Torres that she wanted to withdraw and stop the use of deadly force. But George Torres continued or resumed threatened use of deadly force. Ladies and gentlemen, George Torres never got a chance to do anything. George Torres
Never got out.
never was able to mount any aggression towards the defendant. Therefore, this paragraph is inapplicable. And the law tells us as well that physical contact in this case includes any restraint on George Torres's movements. The law also tells us, again, you find that Sarah Boone, because of prior threats or difficulties with George Torres, had reasonable grounds to believe that she was in danger of great bodily harm, of death or great bodily harm at the hands of George Torres. You may consider this fact in determining whether the actions of Sarah Boone were reasonable. Now, we're going to get to battered spouse syndrome in a moment. But again, I submit to you, this will be the opportunity for the defense to air grievances in regards to George Torres. But again, those grievances will not change the law, and they will not change the fact that the justifiable use of deadly force fails as a defense for the defendant. If you find that at the time of the alleged second-degree murder, manslaughter, culpable negligence, Sarah Boone knew that George Torres had committed an act or acts of violence, you may consider that fact in determining whether Sarah Boone reasonably believed it was necessary for her to use deadly force. Considering the issue of deadly force, you may take into account the relative physical abilities and capacities of Sarah Boone and George Torres. Now we come to the
I like
special instruction
how he's going through the instructions.
on battered spouse. You have heard evidence that Sarah Boone suffers from battered spouse syndrome. If you find Sarah Boone suffered from battered spouse syndrome credible, you may consider this evidence to assist you in determining whether, in Sarah Boone's circumstances, would reasonably believe that such force was necessary to defend herself against the imminent use of unlawful force by George Torres. Like other witnesses, you may believe or disbelieve all or any part of the testimony in regards to battered spouse. Ladies and gentlemen, we've heard from 3 experts in the areas of battered spouse in this case. And I think at the outset,
3.
it's important to note what battered spouse is and isn't and what the law instructs us here. Battered spouse is not some carte blanche. Battered spouse is not a license to kill. The fact
Fair argument.
that George Torres at points mistreated Sarah Boone, did things that were worthy enough to get him arrested, to get restraining orders placed upon him, doesn't mean that she walks around with an ace in her pocket when it comes to George Torres. It doesn't mean that because he did
I don't think she
these
understood
awful
that.
bad things, that now through the rest of time she's a battered spouse and she just has the right to kill him or to make him suffer or to punish him or to make him feel uncomfortable or decide that he needs to be confined to a box.
He keeps looking right at her.
No. What the battered spouse syndrome instruction does, it talks about the imminency of fear. And when we heard about that testimony, we heard about it from Dr. Harper, and we heard about it from Dr. Brandon for the defense. And some of the testimony was a little difficult to understand at points, but there was one point in Dr. Brandon's testimony that was very critical. Dr. Brandon talked about rule-outs. He talked about the fact that when emotions and emotional reactions are involved, like trauma and trauma-based disorders, other possibilities have to be ruled out before we can even ascribe those actions to battered spouse syndrome. Other possibilities, according to Dr. Brandon, include alcohol abuse. Dr. Harper should have listened to Dr. Brandon's testimony, because Dr. Brandon
He's going to pit their experts
completely
against them.
undercut Dr. Harper's testimony.
Yep, he is.
Dr. Harper relied heavily on the words of the defendant, who was abusing alcohol at the time of these events. And then you heard from the expert for the state, Tanya Warner.
If they even
In
remember.
her opinion, was much more straightforward. Remember, Dr. Brandon did not render an opinion as to whether or not
He
she
explained.
suffered from battered spouse. Dr. Warner said affirmatively, yes, I believe she did suffer from battered spouse syndrome. But she also applied what Dr. Brandon was talking about. Other possibilities have to be ruled out as the trigger for a behavior, for an event. So, in Dr. Warner's estimation, the fact that at the time of this incident, they were laughing and joking and carrying on, meant that the trigger was not domestic violence or some threat. In the defendant's own words,
She said she got mad.
the trigger was him wanting to get out.
She said she got
And
mad.
her being reminded of the bad things that he had done to her. That's not imminence of fear. That's reminder of bad things a person has done. And again, even if you were to believe that she was battered spouse triggered at the time of this event, it still does not save the day. Because all the battered spouse trigger law tells us is that it goes to that imminency requirement. It doesn't say there's no imminency requirement. It doesn't say that, look, if you're suffering from battered spouse and you're triggered by battered spouse, then, hey, there's no more imminency requirement, do as you wish. It just gives the ladies and gentlemen of the jury another thing to consider in determining whether or not that threat was imminent. And we know from the evidence, we know from the videos, there was absolutely no threat. And we know there was no threat because Jorge Torres never got out of that box. He was never got out of that box until sometime on the early afternoon of February 24th.
When the defendant said she pulled out his little legs.
Mr.
Counsel.
J, can you please publish from stage 21?
I wonder if it's going to be her words saying that instead of him saying that. Since we're a little, well, we have brief moments of Zoom room, so I'm going to get us caught up. This video is horrible. If anyone wants to nope out, you have about maybe 2 minutes of this video to mute and then come back. This video is really hard to watch.
I'm going to go to court and I'm going to tell the judge, listen, my fiance has nothing to do with this. It's all my fault. We were both drinking and got out of hand. It's an isolated situation. It has never happened before. I love my fiance. She's a good woman. For being in trouble in her life, she has a 7-year-old son that she loves and cherishes.
A blind Boston Terrier.
She has 2 dogs. One is blind, one is deaf. She goes around and she's driving and sees an animal that's injured. She will stop in the middle of the street, no matter what kind of traffic it is, just to make sure that that animal doesn't get injured any more than what it already has. We both love each other. We both live together. Yes, every relationship has their arguments, but we are not the type of people that you guys are portraying us to be.
She
Especially her. So please, if you can,
dismiss
this case.
Closed.
Drop it. She is not the type of person.
Good person.
Great person.
Angel.
I know she's an angel. She's close to it.
Best thing that has ever happened to you.
Yes, ma'am. And I love you to death. And I hate that we're going through this right now.
Sonnet.
What?
And it good.
And good. I love you, baby. What else you want me to say?
What else do you want me to say? I didn't hear that yesterday.
God will prevail and He will take us out of this situation. Love you.
Clearly, Jorge Torres is dominating the defendant. Clearly,
Sarcasm.
Jorge Torres is the one telling the defendant what to do. Clearly, Jorge Torres is the one calling the shots at 4748 France Lane.
Just call it what it is.
Ladies and gentlemen,
I don't love
are we
sarcasm.
so sure that Jorge Torres wasn't the person suffering from battered spouse syndrome? Next, we're going to come to the justifiable use of non-deadly force.
I don't know where counsel's going, but
The language in the arguments are pretty close to what we've already heard in the deadly force instruction, including the key language that it requires a reasonably cautious and prudent person under the same circumstances would have believed the use of non-deadly force was necessary. Ladies and gentlemen, I submit to you that this was not a case of non-deadly force. Jorge Torres lost his life as a result of these actions. We have heard the testimony of Dr. Sarah Zadovich, who described his cause and manner of death, who described the mechanism of death, how that oxygen dissipated in that suitcase. And when we also look at the imminency, we heard in opening statements by Mr. Owens that, the big threat in this case,
I was hoping he would get to this.
the awful threat was in the magic 9 minutes between the video at 11:12 that she took, torturing George Torres, to her follow-up video at 11:23, after she had moved the suitcase. Mr. J, that you published from States 17, IMG 1063.
She recorded everything else. She photographed everything else. Why not then? Though I will say every time he says, Mr. J, can you cue that up? I'm thinking now, Silent Bob, now. And it's, my brain is not being kind to me with that. I'm going to try not to just, now you all can think it too. So welcome. All right. We're almost caught up with real time. That's why I tried to zoom while they were queuing up the tech. The suitcase is moved. It's back right side up. It looks zipped all the way.
It was a short video. Well, what's one of the things that we notice by this point?
Zipper.
You can hear how loud George's voice is on the 11:12 video. But now, roughly 11 minutes later from the time that started, you see that the makeshift coffin that he's in has been moved.
Sir, you can't listen to my stream while you're doing your closing arguments.
And his voice now is softer. The life is draining from George Torres, and it's evident in that video. And that, ladies and gentlemen, is evidence that there was no threat in the magic 9 minutes that was not recorded. There was only George Torres
dying
in this box, slowly being killed.
That was better than dying.
Next, we come to weighing the evidence.
Really good use of jury instructions.
This instruction tells us it is up to you to decide what evidence is reliable. You should use your common sense in deciding which is the best evidence,
Downshift the anger now.
and which evidence should not be relied upon in considering your verdict.
Downshift, just go back to
You may
teaching them.
find some of the evidence not reliable or less reliable than other evidence. You should consider how the witness acted as well as what they said. Some things you should consider.
Nightbot would like to tell the lawyer to stop
Did
speaking
the
in all
witness
caps.
have an opportunity to see and know the things about which the witness testified? In focusing on the defendant, absolutely. Two people walked through the front door on the evening of February 23rd, 2020 at 4748 France Court. George Torres and Sarah Boone. But only Sarah Boone ever walked out of that front door alive. Did the witness seem to have an accurate memory? This is an emphatic no. And
He's like, it's a hell no for me.
of her intoxication in versions of events is evidence of that.
God, she took the video.
Was the witness honest and straightforward in answering the attorney's questions? I would submit to you she wasn't. 4, did the witness have some interest in how the case should be decided? Clearly. Does the witness's testimony agree with the other testimony and other evidence in the case? And I would say largely no. Because on the issue of whether or not Jorge Torres could have threatened her the way she says that he did, the answer is clearly no, and we know that from the forensic data. We know that from the items itself. Did the witness at some other time make a statement that is inconsistent with the testimony he or she gave in court? In regards to the defendant, it's almost more appropriate to ask about the time she did make a consistent statement. You listened to her version of events on the 911 call, on the body cameras, on her first interviews with law enforcement, and then you hear her in her next interview the next day with Detective Copsell and Detective Lowen, and more details come out. Things change. First, she was never intoxicated, then she was intoxicated. Then there's just the whole fact of she omits the fact of, oh yeah, he was actually trying to attack me.
Yeah.
Oh yeah, I was in fear for my life.
Never talked about that.
When she said at every turn, no, it was just a great day. We were having fun. Oh my God, I can't believe this.
We were going to have sex
We were doing
later.
good. The only stress we had was about jobs.
I thought he was going to come
And
upstairs.
now,
Zoom, 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 zoom.
4.5 years after the fact, it's time to come up with a new story. But ladies and gentlemen, I submit to you that the truth does not change. The facts do not change. The videos do not change. And on any version of events that the defendant has given, they all add up to the fact that there is absolutely no doubt that she is guilty of murder.
You should be almost done then.
I ask you, ladies and gentlemen,
You should be almost done.
do you have any doubt about the defendant's guilt
You gotta point at her.
when she described using that baseball bat to hit Jorge Torres's fingers back in the suitcase when he attempted to save his life?
They can be yelled at.
Do you have any doubt when she is given how many versions of events in this case? Do you have any doubt after hearing the testimony of her neighbors about the loud crash and the arguing that night? Do you have any doubt after hearing the testimony of Dr. Sarah Zadovich? Do you have any doubt after watching the videos of Jorge Torres being murdered and her laughing about it
Telling him to shut the fuck up.
and talking about the fact that he cheated on her. Do you have any doubt, after reading the text messages from her phone, after seeing the videos of how she controlled and manipulated Jorge Torres? And if you say, Mr. Cacciatore, I still have a doubt.
Well, Mr.
then
Cacciatore, what's your
the
answer?
law asks you,
Is it
is
reasonable?
that doubt to an element? And is that doubt a mere possible doubt, a speculative, an imaginary, or a forced doubt? I submit to you the idea that she had to do this because she was a battered spouse is an imaginary doubt. It's a doubt born from the imagination of Sarah Boone. It is not a reasonable doubt. But if you find yourself back in that deliberation room and you are just trying to think of some way in which the defendant is not guilty, just searching, struggling for that way, that also is not a reasonable doubt, ladies and gentlemen. That is a forced doubt. Ladies and gentlemen, I'm confident that when you read the entirety of those jury instructions and apply the law to the facts that came out in this case, that you are going to come back with the only lawful verdict, which is guilty as charged, second-degree murder.
And he's done with that. We will see what is next. Thank you, chat, for staying on topic. I know there's a lot going on in the world and the law.
As I promised, we were going to take that afternoon break before the defense proceeds with their closing argument. You're going to leave everything behind. Similar instruction that I've given you before. Please don't conduct any independent investigation, research as to the person, places, thing, or charge involved in this case. And do not have any discussions among yourselves or anyone else. We'll bring it back in about 15 minutes. Thank you very much.
All right, there's going to be about a 15-minute break. Again, thank you, chat, for staying on topic with this trial. I know it's hard when there's a lot going on. I appreciate it. So, what did you guys think of that closing? I see that a lot of you liked it. I have to say I am incredibly biased towards this style of closing. Why? Because this is the style of closing that I preferred as a prosecutor. So it's like, I like to just be like, yeah, that's the way I like to do it too. Look at us. I like when the first part of the closing goes through the...
Okay, may proceed.
Goes through the jury instructions.
Sarah Boone's entitled.
He says he has a motion. Of course he does. I like it when they go through the jury instructions instead of a timeline. The jury's heard the facts. Go through the instructions and say this instruction, this fact, this instruction, this fact. You don't need every fact. You need the critical facts. And I think that he did that well. And now Owens has a motion because of course he does.
To a fair trial, I think.
Sarah has the right to a fair trial. I wonder if this is going to be about the outburst.
May be seated. Thank you.
Judge, I've got a motion.
Okay, may proceed.
He's already standing. I got a motion.
Sarah Boone's entitled to a fair trial. I think that right's been compromised.
How? How?
I don't know who scheduled to put the two detectives on the front row with the Torres family, the family of the victim. But they had to have known to tell them that the suitcase video, which has been around for 4.5 years, was going to be played during opening statement. And the state attorney's office or the sheriff's department had to advise them, or the victim's advocate had to advise them, that if they couldn't take it in front of a jury that's trying to decide the case, they needed to get out of the courtroom. Now, what happened here today should not ever happen.
What happened?
There should be safeguards in place. There's no room for this after 2 weeks of murder trial for something like that to happen.
It hasn't been 2 fucking weeks. It's been 6 days. Calm down. First of all, he's doing his job. Second of all, it makes me mad. I don't like this argument. He's not wrong that there should not be outbursts in court. I don't know how much of a thing there was because they cut the audio. I want to hear what he has to say. It has not been there was jury selection, but it has not been 2 weeks of evidence. But the victim's mother having to leave is the disturbance that he's talking about. I'll back up and let him have his dramatic moment. My apologies, Chad. I was annoyed.
In front of a jury that's trying to decide the case, they needed to get out of the courtroom. Now, what happened here today should not ever happen. There should be safeguards in place. There's no room for this after 2 weeks of murder trial for something like that to happen. One of the Torres members of the family audibly,
are so
during the 2-minute suitcase video, expressed some kind of emotional reaction.
Now they're going to have to put it on the
I
record.
look back, he or she were bent over in agony, physical pain. The physical pain followed the audible announcement.
What announcement?
You can't unring that bell. That's their responsibility to ensure that kind of thing doesn't happen, especially when they know they're going to show a video and the family of the victim is on the front row.
They have a right
I've
to be
never
there.
heard of such.
They have a right to be there.
I asked for a mistrial.
The prosecutors are so
I've never heard
calm.
of such a request. The victim's family has a right to be here. They were advised as to what will be used during closing arguments. I cannot make a decision for the victim's family and the homicide survivors as to whether or not they believe they can handle it. She clearly, or he, I don't know, couldn't, and I believe the appropriate thing was done. They left the courtroom. But again, to say this is intentional sabotage and all the accusations that continuously get made are unsubstantiated.
The hyperbole is exhausting.
It does not warrant a mistrial.
They're so calm.
People get warned, and sometimes they misjudge their own emotions. I don't understand what test we are expected to run on homicide survivors. So the motion should be denied.
Motion's denied.
I wish the court would clarify the record.
Jury's going to be back in about 13 minutes, counsel. So we'll reconvene at that point in time.
Could the state put the suitcase back in the water?
Yeah, can we clean the well from the state's materials, please? Thank you.
And the motion was denied. Look, family members, and I wonder if in Florida it is called a homicide survivors statute, also have rights to be in court. You can't force them to not be in court. You can allow them to choose. Whatever happened in court, it seems that this is speculation. I'm not in court. Maybe we'll hear from those in court later. Maybe we won't. But I would imagine you heard somebody cry or sniffle or what have you, and that's about it. Because if it was more than that, the judge would have put it on the record. He didn't. They went to sidebar. That family member removed themselves from the courtroom. I don't think a jury's going to be persuaded by a family member having a reaction to that video. I think they're going to say, yeah, that's a human reaction to a video. I don't think it persuades them. Again, Owens asked for a mistrial. It was denied. We have about 5 more minutes. I'm going to run to the restroom very quickly. Again, thank you, Chad. I know there are 30,000 of us in here. I don't know if we've got about 5 more minutes of court on break, and I'm going to use the restroom. So it will be very brief, and I will be right back on, and I will answer questions and try to do a summary of closing. I thought the state's closing was powerful. I like the way they use the jury instructions. We will see a combination of that with Owens, but we already see that Owens is already at a 10, right? There were times where the prosecutor was a little bit loud as well. But we definitely saw Owens at a 10 already in court, and I think we're going to continue to see Owens at a 10 in court. But I'm glad to hear that the prosecution gave the victim's family a heads up of what would be in their opening their closing argument and what they would expect, and allowed them to choose. And they deserve that choice. So I've also seen my friend Octo in the chat. Warren has advised in the chat that we are very close to a subscriber milestone. So, and it looks like we are very close to a subscriber milestone. Give me one moment and I will show you guys what I mean, because we are absolutely almost at a subscriber milestone. So with that, we are close. Chat, we are definitely not far from 800,000. So trial time can be like that. So thank you, Warren, for letting us know, and thank you, chat, for subscribing to the channel. I appreciate it. You guys are bae because chat is bae. So I'm going to run to the restroom. I'm not going to leave this up. But thank you guys for doing the subscribing things and making the numbers jump. I always appreciate it. It's sometimes very fun to watch. So we are really, really close to 800,000. And then I can maybe convince my 12 going on 13-year-old that we're a real YouTuber over here. Meeting the CEO of YouTube, no. Being in some of the SPM programs, no. Meeting other YouTubers that he likes, no. Being number one on live trending, also no. What he continues to remind me is that my subscriber number does not have an M after it. Because kids keep you grounded, everyone. So we'll check back on this in a little bit, but what we're going to do right now is head to lunch. Not lunch. Emily, no, don't terrify the chat. I'm going to take a very, very brief restroom break. I will be right back. Thank you, everybody, for the likey, subscribing things. Thank you for staying on topic in the chat, even when it is a busy day. And on topic means just what we're doing right here, not what's coming up later tonight, not what's going on in other cases. Just on topic here, because it is very hard for me to follow when we get off topic. So thank you very much, mods. Thank you very much, Team Baker. Thank you very, very much, chat. We'll go with you guys all really liked the music this afternoon, so we'll do that. It wasn't that one. It was that one. We're going to leave that one real quick. I will be right back. Hey, y'all. I know I need to take this down. And then we need to take our music off. We are going to be going back to court in just a minute. They are not back yet from break, so we're going to just, court's up there. I'm going to remind you that tonight we're going to be on Verdict Watch. For those of you just popping into the stream, we are going to be on Verdict Watch. It seems late because the court said they were going to let the jury work till like 10, and then Owens was like, and or 11, and I was like, girl, what? But it looks like the jury is going to be working through the night. Who knows how quickly or not they will come back? Who knows if they will want to talk? Remember, the jury does not get to talk about this case with each other at all. They might want a minute to talk. So as we are coming back in court, don't forget to get the Lawnard app. Once we know that they are coming back with a verdict, I will be back with you and we will go live. I'm going to set up a live so that we can have a members only chat on for a bit, and I will be monitoring that and keeping an eye as well. But as we are coming back to court, we're going to get into the defense closing statements. What do I expect to hear from the defense closing? It looks like they've got two
We are
easels
back
in
on
court.
record 2020 CF
They're going to talk about
2603, State of
Sarah
Florida
being a
versus
battered
Sarah Boone.
spouse.
State appearances for the record.
Dave Ketchner on behalf of the state.
So you're going to hear a lot of that. And then the state gets to go again after that.
Tony Henderson, Sarah Boone.
Ms. Boone is still seated at counsel's table wearing the same clothing from this morning.
And thank you.
Are we
Yes, we are
ready
close
to bring in our jury for the
800,000.
defense closing at this time? State.
Yes, Your Honor.
Defense.
Judge, I would like you to give the audience an instruction, and then if you would, instruct the state attorney to instruct whatever family members or friends of
Ew.
Jorge Torres may not be in here, and may not be able to hear the instruction, but may come in during the trial so that we can try to get some order.
Are there any other members of Mr. Torres's family that may be outside that may be joining us? Okay, all right, so she's left, she's no longer here? Okay, that's what I just asked. Is there anyone outside? Okay.
She's outside, but she's not coming back.
Okay, all right. So, members of our gallery, good afternoon.
Turn off your cell
I'm going
phones.
to please ask you to please contain yourself and not to have any emotional outbursts. We had a minor one, and the person, whoever it was, had a small outburst, then hid next to another family member,
Right.
and then excused herself
Probably
during
to
the
try
last
to
absence,
recover.
during the closing. It seemed to be minor in nature. However, I'm advising everyone that at this time, if you believe that you cannot control yourself or your emotional responses during the defense's closing argument or any rebuttal by the state, I'm going to politely ask you to excuse yourselves at this time.
You guys can have all the outbursts you want,
All right,
depending
thank you
on
very much.
where you are and
Mr.
who's
Owens,
around.
anything else, sir?
No, sir.
All right, state.
We're ready.
All right, let's bring back in our panel.
Emily, why don't you want to be live in court? Because I want to be here where I can have outbursts while we are doing trial. I would like to be here. I would like to be here where I can just talk.
Okay, thank you.
And
All
they
can be
can't
seated.
hear
They're
me.
making their dinner selections. We'll just give them a couple minutes to do that.
He said the
Thank you.
jury is making their dinner selections. It is 4:25 local time. And they have got to be, the victim's family has to be frustrated. The lead detective is sitting with the victim's family in court. I imagine that there is a tremendous amount of frustration at this point. And I understand, I absolutely understand and empathize with that frustration. And those are hard conversations to have too. And Nick W in the chat says, I keep telling myself that Owens is doing his job. Owens is doing his job. It's not always an easy job. Owens is doing his job. Frustrating. I don't always like the way he's doing it, but Owens is doing his job for his client. And when your client expects you to fight for them, sometimes that evidences itself differently depending on the counsel. Patty, thank you so much. Appreciate it. And yes, that would be awesome. Owens better not yell at me or I'll cry. I mean, there's times during the prosecution's closing, I felt like I was being yelled at. I'm like, okay, sir, but now you're reading the jury instructions. Can we just tone it down a bit? I feel like I'm being yelled at, but it's much different than like snark of a Carrie Morrissey. So we've seen Carrie Morrissey in court quite a bit, and it was more snarky. There were times I felt that it was almost a talking down to. It was kind of condescending. I don't feel that this was condescending. He seemed outraged, right? There was like a righteous anger of like, this was a murder. By the way, we didn't see any of that from like a Lally closing. We didn't see like more energy. None. With this prosecutor, we saw the energy. We saw this should never have happened. This defendant did this to this victim, and it is unexcusable. And here are the jury instructions that you can just ignore because her behavior is inexcusable. And so we saw some of that in this closing, and we'll see that in the defense closing as well, saying this woman suffered, and this is how she responded on this day, and they will argue for that self-defense and that it's justified. So let me see if we have any audio in court as we gain this back up. Nope, none at all. So we are in real time. I've got the court audio still on. So no, we've got nothing. Judges on the bench, jury is picking out their dinner selections. We're going to go to, super chats and questions. Sapple said, tried to get engaged in this trial. I couldn't get through the day. 0 motions and such. So let's skip to the end. Thank you for making this as digestible as possible. That is always my goal, to help us understand the law and ride with you. I think watching this trial without a moderated chat would be incredibly difficult because this is a difficult trial and it's a trial with some nuance. And yes, chat, if I know I say stay on topic, but while the jury's selecting their dinner, chat, if you would like to discuss your dinner, I'm not going to tell you not to. When we come back to closings, we'll rein it back in. But for the moment, I'm not going to tell you not to discuss what you're having for dinner, because as the jury selects their dinner, you should be able to select your dinner too. So Gwendolyn said the videos yesterday were very hard to watch. I sympathize with George. Deeply disturbed me. Those videos were hard to watch. That's all. They were hard to watch. So it's going to stick in the mind of the jury. When you think back, if you've watched every day of this trial or only some parts of it, when you think back to what stands out in your mind in this trial, I think it's hard to pass those videos from yesterday. Some of the early body cam footage, it's like the face that she's making in the thumbnails I use is the face she was making at the cops when she was like, can you get my phone with me? Her going in for a hug, her jumping up and down as he was getting arrested, and then the videos she took. It's really hard for me to go back to what other testimony there was. It's just like there's a wall after those videos, and things changed in the state's rebuttal case for me. Emma Lou, I think you are not alone in saying I really want to hear from her ex-husband now. We're not going to see any of that. And now at this point, it seems the ex is not co-parenting. And I imagine if she is convicted, will not be co-parenting because she will remain in prison. I feel very much for her kid because that is going to have a large impact. However, being in a house with what was going on with her and George doesn't seem like it would not have impact either, and would have had impact. So it's a lot. Those videos are a lot. Jay Michael said people here in Central Florida often use the anglicized pronunciation of their names. Kissimmee is little Puerto Rico. Well, I bet the food is amazing. Colleen said, are there a ton of hurdles to getting a new BC in the US? I unfortunately don't know what BC is. I am sorry. I have no idea, but I don't know in context. Also, we've been streaming for like 7 hours. No, Sassy J in the UK said all she had to do was poop on his pillow. Yeah, we didn't hear much conversation of poop in this trial. That is, birth certificate. Thank you, chat. Chat is like birth certificate. You have to go into court. You have to have some information. You have to pay for it. You have to go to the clerk's office. But jurisdiction by jurisdiction, I don't know. I don't know how hard that is to accomplish in Florida. But normally you do have to go into court. You have to pay for it and those sorts of things. So there's generally paperwork you have to fill out. So thank you, chat. Chat is bae. I appreciate all the extra brains when my brain has stopped. So it just depends on your jurisdiction. So some of you are saying you can get it online. It really depends on where you live, because how the different government offices operate is very different state to state. Sarah Ann said, hey, Emily, new subscriber. I'm enjoying your stream. Thank you. Though I think for George, not having a debit card might have been a hurdle because he was working with cashing paychecks, and that could have been a hurdle for him to buying something or getting something online, and might have needed his help for that. One happy white girl said, I just got the Law & Order app so I don't miss anything. Well, I'm glad you got the app. Thank you. KP Jeep said, I vote for 4-hour deliberations. I will do a poll before we end the stream on how long you think deliberations will take. I will also ask at the end of all of the closings, whose closing argument you thought was more persuasive, and regardless of side. Like, you might think one way or the other about Sarah Boone or about this case or the evidence, but you might say, hey, I don't necessarily believe the prosecution's theory, but I thought that they had a very good closing. So I'll ask that as well. So for all of you that gifted memberships, thank you for the gifted memberships. I very much appreciate it. Thank you, thank you, thank you. Jenny in the chat said, George's mom is only human. As a boy mom, my heart goes out to her. I mean, I think everyone's heart goes out to her. Mom, not mom. I mean, you know, I think all of us understand that. Seeing these videos again after everything else was really hard. I cried pretty hard without realizing I was going to. Yeah, it catches you off guard. And I think for me, I had seen the videos early on in trial. They hit different after seeing the testimony yesterday and after seeing the videos yesterday, that they really do hit a bit differently after all the evidence has come in, which is why you play them in closing. You want them to hit differently. You want it to be more difficult. I think that one of the other considerations for birth certificate is, I don't know what state George was born in, but it might be East Coast. So there might have also been more to do if you are not in the same state. I don't know, but not easy. And it can take a minute. And so tearing it up could definitely impact his ability to, you know, operate his bank account and things like that, because that's what we heard on the police body cam footage. PI paralegal 2019. There's the not able to parse things up. This is an amazing closing statement. I'm seriously impressed. I thought the prosecutor did a good job. I also have a preference for using the jury instructions. I do. There was definitely, there wasn't a ton of hyperbole. There was a lot of argument in the facts and a lot of bringing back to what the jury instructions were. Carrie said, it was a good day because I lived, hit me, and I wish he had said, well, George didn't. I think there was some more room to use Sarah Boone's words, but I think using the video was powerful. I also will remind you, the prosecution, we will hear from them again. So we will hear more from the prosecution. So that will happen. Livin said, why not say that before she called 911 for whatever, but that night in fear for her life, she didn't. She went to sleep. I don't know if they'll bring it up later or if the defense addresses it. I don't know if they will address it. And I think that if they do, it will be in obviously rebuttal to the defense. But I also think that the jury knows, and the jury might be remembering those things too. Forever X Jana said, I think deliberations will be as quick as Murdaugh. Those are pretty quick deliberations for sure. Did the camera show Sarah's side of the bleachers? We've seen some of who's in court, but not a ton. And there are people sitting behind Sarah. I don't know if it's just her legal team or not. So let us continue going through questions if you guys have questions, because, well, we're just chilling. We're just chilling. Al Alowit, Debbie Jo A said, having my birthday coffee with the Lawnards. I realized this was from this morning, but happy birthday. And I'm glad you are having your birthday coffee with the Lawnards. The Bolter said, been listening all week while I work and wanted to say thank you for your coverage and being you. Well, you are welcome. That is what I am here for. It's what I love to do. And trials are long, and a lot of parts of trial are confusing, I think, if you're just watching it. And since there are so many places to watch it without commentary, we've got to have some to watch it with commentary. Joseph Ortiz said this might be a bit off topic, but how does the jury selecting their dinner work? Because I'm a cook, so that's what's interesting to me. No, I think it's on topic because, well, that's what's happening right now in court. And though Owens is talking, the microphones are off in court because I have them turned on. There we go.
Okay.
I don't know if that's
But generally the court has a menu and a place that they work with, and they can put in what they want. So generally the courthouse has some approved options. If the courthouse does not have its own little eatery, some courthouses have restaurants, some don't. Sometimes it's getting sandwiches from the local sandwich place. It just depends. So the jury would say, I can eat this, I can't eat that. And then they would bring it in from wherever the court normally works with.
that is allowed by the court.
We didn't hear the beginning of what Owens said.
Okay.
I don't know if that is allowed by the court or.
Anything?
Been allowed since I started practicing in 1997.
If you want to split up your closing between the two of y'all, that's fine by me.
Well, I intended on doing the closing, but when I finish, Mr. Henderson wants to say something. I may ask you to.
I've never seen it done that way. I've understood the sandwich can be broken. I've never, ever seen a single closing argument split by another attorney.
With a footnote.
If it's a discretionary issue, I'll leave it up to you, sir, on what you want to do and how you want to present your closing.
So they're asking about splitting their closing. You don't get to just say extra shit, but sometimes you split it up into one person talking about the elements, one person talking about the affirmative defense. So Celeste said, can the jury take their notes to deliberate? It depends on the jurisdiction, but generally when notes are allowed, yes. They're allowed to take them in to deliberate, and they are reminded in the jury instructions to go off their memory, not off their notes. I don't remember if that was in the jury instructions here. I don't remember hearing it. But yes, they are allowed to take them in, and then they're destroyed after trial. Angie said it's still around lunchtime in Vegas, so lunch is spaghetti. Is it mom's spaghetti? And a side of a few pieces of cheddar cheese. So Greek Fairy says, if the jury stays wicked late, will they get a fourth meal? I don't know. Doc TJB said, I've been watching since 100,000. So proud of you. Well, thank you. I appreciate it.
Who would be objecting during rebuttal?
Mr. Owens.
Okay, there you go.
They keep going off and on the record. I wish they would just leave it on. Vernique, thank you for that. RK said at marching band state comp today, go regiment. Are we talking about the Phantom Regiment? Is that the regiment we're talking about, RK? It can only be said that way. Band nerds in the chat get me. If you're not a band nerd in the chat, it's band shit. Don't worry about it. Twisted Life asked a great question in the chat and said, why is the lawyer allowed to walk them through how to fill out the verdict form? He's not. He's walking them through the jury instructions. So he was visually showing them, hey, you don't have to worry about this one. So I'm going to cross it off so you remember. So that was him crossing off different jury instructions, but not the verdict form. So that was not him working the verdict forms, which I don't think I've ever seen. I don't know if there's a rule. I really don't remember if there's a rule. I've never seen an attorney like pull the verdict form up and be like, check guilty, like check this, vote for L. Like I've not seen that, but I have seen people go through the jury instructions, line things out, be like, this doesn't apply, just because it helps have a visual representation of you don't need to worry about that one. Yes, Emily is a DCI fan. Emily also has a kiddo that's in band. So Emily also did marching band. So we love marching band stuff up in here. We've talked about, I think there was a members only live that we watched marching band on. Oh, members, I need to circle back with you. We did get a copy claim on the members only live It's still up. It just can't be monetized. They're never monetized, so it's fine. We did get a copy claim, and members, you called it accurately. We were talking about different music, and I had gone to see Yachtly Crew, which is a yacht rock band that I absolutely love. So I had gone to see Yachtly Crew, and I was sharing some of the videos from the concert on our members only live stream. And the members accurately clocked which of the music that we played that was going to be a problem. And it was indeed Baker Street. Baker Street is the one that got us. We kind of knew that it would. Y'all said it was going to be. But it's a members only live stream. And since we don't monetize them, I don't mind getting the copy claims on them. Not a copy strike. We'll take the claim. It's not like the time we played the music video and the whole stream went down. We learned from that, y'all. We learned. I need them to go ahead and bring the audio back, please. Thank you. The jury is coming back in. I think we're going to get to the, we absolutely pushed it on that members only live stream. We maybe flew a little too close to the sun, but it was fine. It's fine. It's fine. The jury is coming back in. I suppose that they ordered their dinner. And we're going to get to the defense closing argument shortly. That was a longer wait than I thought. The jury can refer to their notes. They're just told if there's a discrepancy between their notes and their memory to go with their memory. That's all. So, Call Me Out was a great stream. I agree. Being able to talk about music matters, and a lot of music reacts channels.
Recognize our jury.
Yes, Your Honor.
Do it very
recognize
well.
our jury. Thank you. Y'all may be seated.
Sarah, they didn't ask.
I'm sure for one of the last times, if you could, please raise your hands to confirm that you complied with the court's instructions.
Sarah
All
was
hands
like,
have been raised.
I recognize
Members
our
of the
jury.
jury, at this time, the defense is going to proceed with their closing argument, similar to the state's closing argument. These are not evidence. These are just arguments, and I ask you to pay attention to them. Thank you. Mr. Owens, you may proceed, sir. Yes, sir. Thank you.
Ladies and gentlemen, good afternoon.
And defense closing.
Y'all know me, I'm James Owens.
Yeah, they know you,
Along
sir.
with Tony Henderson and the girls. We're all from Milton. I think y'all figured that out. That we.
And the girls. Sir, it is the year of our Lord 2024. Also, I prefer that the prosecution started their closing with, "This is my case, and the state thanks you." I want to know how many women are on this jury.
Ladies and gentlemen, good afternoon. Y'all know me, I'm James Owens.
You have a
Along
female
with Tony
client,
Henderson
dude.
And the girls. We're all from Milton. I think y'all figured that out, that we were from out of town. Santa Rosa County. It's northwest Florida, close to Pensacola. And my buddy Kevin Beck, he's a longtime friend. He's from New Mexico.
What?
The team, the defense team, is here. And,
Shout out to my buddy Kevin.
Miss Sarah Bennett. And we feel confident that we're going to be able to show you why she's not in. Okay? And I'm going to take my time. I've got some notes. I'm not the most organized person in the world. I've got some exhibits.
We've
that we'll
learned.
show you. And then we got a couple of videos at the end. Okay? And we're going to try our best to help you make the right decision. Okay? But yeah, Milton's a small town.
Objection. Providence.
Overruled.
See how small it is. 7 miles away is another small town called Pace. In between that is a Walmart. It's a very small town. We didn't know what to expect coming down here to Orlando.
Providence.
Judge, I'm allowed to.
I'll give you a little bit more for intro, but then we need to get into it.
I'm going to get into it, but I wanted to say. It's a small town, good people. We've been down here 3 weeks. We didn't know what to expect. We've been surprised.
Objection. Improper argument.
Mr. Owens, approach.
Well, and there we are. We've been surprised. Sir, what? At least we have 30 seconds of Zoom room.
I like this.
Nope. A little bit more than 30 seconds of zoom room. All right. There we go. He was called to approach. Owens is not talking about the case. He's not arguing the case. He's talking about
Objections overruled.
where he was.
All
But
I wanted to say.
the court's going to give him some leeway for that. Owens is going with the, I'm just a country lawyer.
It's just, since we've been here, we've been treated with respect and hospitality, and just like we've been at home. We appreciate that. Now, I'm going to do some reading, and then I'm going to do some talking. But ultimately, this is about justifiable use of force. That is a legal defense in Florida. We as citizens, the law is designed to protect us from defending ourselves, to protect us from potential attack. And you are the only ones, in this case, because Sarah Boone was arrested, that's going to be able to look at it critically and objectively. Objectively. Not like the state attorney.
Objection to improper argument.
Overruled.
Objectively. And the law in Florida gives y'all the power and authority to do that. The state attorney can't make the decision.
Well, the state attorney is going to be objecting a lot.
They can't make the decision.
Fear. Maybe
They can
too
try
much.
to influence you. And we're going to talk about some of the things they did here in this trial. And some of the things they said.
Objection. Objection. Remove motion.
Yes.
Owens looks so put out right now. Owens looks so put out. He's allowed to respond to what the DA said in argument, and it might be too heavy-handed. We'll see. I also don't know if Sarah and her attorney should be chitty-chitty chat-chatting while closing is ongoing. I don't know if they're doing that while he's on the record or just while they're at sidebar. So we'll see. But we have some zoom room. We're almost out of it. We will see.
May proceed. Objections overruled.
Does it look bad on the prosecution? I think it can. That's a lot of overruled objections in closing. I think it can look too heavy-handed.
Their position we've got outside. So we're going to talk about that. But, and we're going to talk about justifiable use of deadly force and non-deadly force. But either way, however you rule, it still justifies her behavior. And the result is not good. Now, I don't believe there's anybody...
Objection. Improper argument.
Overruled.
Objection to reproach.
Yes.
Owens' face. He's worried that Owens is going to get into vouching. He said, I don't believe. I think that one, out of all of them, I'm the least mad about that one. Some of the other ones, like if he's talking about his small town, let it go. Just let some of it go. But this prosecutor is just like, nope. I don't know. I think the state doesn't trust Owens. So I think he's worried that Owens is going to get into vouching because he started to say, I believe. You are not allowed to say what you believe about a case. The evidence shows, you can see that the evidence shows, but not I believe, and that's what triggered that. And Owens looked at the jury and went,
I think you will find from considering the evidence in this case that there is no doubt that Sarah Boone is a victim. That Sarah Boone has been traumatized. That Sarah Boone is still traumatized. And the reason for the trauma is Jorge Torres. The reason for the trauma is Jorge Torres. From the positive things about the man that we've seen, on video, to the positive things Sarah Boone is testifying about, to the violent monster he becomes. And I mean monster, because it was repeatedly. And what happens the next day? Man, I don't remember. I was drunk. I don't remember. That's the gaslighting that this young woman, vulnerable woman with nobody, just starving for love, starving for attention, and seeing the good in the man. And it was good. But every day was on the balance. She measured every day, depending on how it started and then how it ended. And that's the way she had to live her life. Day in and day out. Day in and day out. Dr. Harper and Dr. Brandon talked about trauma. Dr. Harper spoke of the veterans that she had treated for post-traumatic stress disorder. I don't know if you remember her testimony, but she spoke about some of the veterans that had been in the war in Iraq, you know, and people in war a lot of times get post-traumatic stress. It used to be called shell shock and other things. But people in wartime, or police officers
Are you
post-traumatic
going to
stress.
compare her
And a lot
to
of them come
war
in, the males
veteran?
come in with this bravado, oh, I'm all right. I'm all right. And so, that's why Dr. Harper was talking about the veterans, that's what they'll do. But you've got to spend time with them. It just can't be one session.
He's like,
And you've got to run post-traumatic stress testing.
He could just talk about people who've
Which
experienced trauma.
tells whether they really have post-traumatic stress.
All the experts agreed she showed signs of battered
We all
spouse. So I don't
probably
think
have
you need to
experienced
fight
some trauma.
this.
All of us have lost some loved ones. And it's awful. You're in shock. You can't believe it. It's disbelief. You don't sleep for days. And eventually, you have to go back to work. You take a week off. Life has to go on. Life has to go on. You go back to work. Kids are in school. You get a little time. Right? Time heals. Right?
Where are you going?
These veterans that come back from a deployment, they get back, they get some semblance of normalcy. They may or may not get some treatment, but time helps. Time heals. Everybody, it helps. Just time. Overcoming a divorce, overcoming a death, whatever trauma. Sarah Boone had no break. No break. Learned helplessness. Just giving up. Just giving up. I can't get out of this situation.
She's the one
They
that gave
broke up. She'd go about 2 days. She'd go about 2 days. Texting and calling. Just learned helplessness. And it's, in the manual. Battered spouse syndrome is not, but what did you hear Dr. Harper say? She suffers from post-traumatic stress. That is a mental disorder. You are actually undergoing the psychological effects of post-traumatic stress. You're not in your right mind.
Are you
And
saying
it's
that the
repeating
jury is
itself.
traumatized by your closing?
It's repeating itself again and again, day in and day out. And when you look at this law, that's what you have to apply. someone in Sarah Boone's shoes when you're deciding whether her conduct was reasonable.
I have a hard time following his flow too, Chad.
Got a bunch of notes.
I've got a bunch of notes. Good for you, sir. The prosecutor had them in order.
Not that. It was something I wanted to read. Where'd that put it? Sarah Boone's long-term exposure to abuse created a state of learned helplessness and diminished her capacity to assess risk, especially in moments of heightened stress.
Are you reading from something that's in evidence? Because you should identify the exhibit that you're reading from, and I'm surprised there's not an objection seeing how many there were. That's all.
The cyclical nature of this violence, the tension building, the battering, the contrition phases, caused Sarah to be trapped psychologically in that relationship. Due to this clear abuse, Sarah Boone had a reasonable belief of imminent harm under her state of mind.
A transcript.
Jorge Torres had a history of violence against Sarah, and as a result, Sarah Boone's actions were the result of fear conditioned by abuse she endured over time.
Is that transcript?
The cumulative effects of long-term abuse, as we saw her behavior on the 2-minute suitcase video, is a trauma response. Sarah Boone acted out of a sense of preservation. While tragic, it was not driven by malice, but a mind ravaged by abuse. And I'm going to ask you to try to understand. Try to understand. Sarah Boone being emotionally and psychologically broken, whose actions may have been misguided attempts at survival but not murder. Imminent danger, her response reacted to that belief. It's somebody suffering from the long-term psychological effects of domestic violence. Who spent a lot of time? Dr. Brandon, you remember him. He was the first expert on trauma. Took some notes. Kevin Beck, you remember, did the direct examination of Dr. Brandon. He was from down in Miami, I think. He talked about the trauma.
Why are we talking about your expert if you don't know where he's from?
You cannot escape from the abuse, so you develop coping skills to protect yourself, knowing that the bad things will happen to me. It changes your behavior, not only your behavior, but your thinking. Your subjective thinking about fear and what to do. And if you remember, Dr. Brandon said it's all about that person's perception. Okay? A lot of times they will self-medicate with alcohol or drugs. A lot of times they suffer from anxiety. Basically, he said the trauma ends up being terror because you do not know what to expect. You do not know what is going to happen that night. It may be a great night. You may drink, and both of you have a great time. He falls asleep, passes out, you fall asleep, passes out. But it may turn by, depending on his mood, I don't know if you can tell, she would try to placate him.
Where was that? What did
Dr. Brandon said,
videos?
You know, when you're trying to evaluate somebody, it takes time to get them to trust you. And the ultimate goal, he said, is to be a behavioral detective. If you're a forensic psychologist, is to be a behavioral detective. And the ultimate goal is to put yourself in the abused person's eyes so you can better understand their world. But ultimately, it's their perception of danger. Their perception of danger is what you have to look at.
Well,
what a reasonable person would do under their perception of danger. Now,
yes, that's an accurate statement.
I want to go on.
I was worried.
Trauma experts explain how
go a
victims'
different way there.
reactions in moments of stress are the product of the damaged psyche. Her actions, although tragic, and it was a tragedy, Jorge Torres lost his life in that suitcase. It's a reactionary response to sustained trauma. It's as if Sarah was acting out of a deeply ingrained fear and helplessness developed over the years. So it's a desperate need for survival, but battered women do things to keep the peace from time to time. And when they feel like they have a small portion of momentary power, they may enjoy that by vocalizing their position to the abuser. Sarah Boone's not perfect. Sarah Boone would argue with him, talk down to him. Some would say was somewhat abusive to him. Sarah's not charged with that. Sarah Boone is not charged with that. And I want to read you something on that subject.
Yes, she's not charged with it, but it is a big part of her defense, isn't it?
Essentially,
Counsel, give yourself a second.
okay, I don't know where it's at, but I'm going to have to come back to it.
Are you going to try to phone a friend?
But
Who's he
essentially
looking at?
what it said was, eventually
Eventually? Eventually?
It's been a 2-week trial. I got a bunch of notes. I'm trying to get this right. I know it's important. What I wanted to say was someone can be mean and angry and hateful and intoxicated and still be abused. They're not mutually exclusive. And mutual abuse exists where one is abusive towards another. And eventually the victim, Sarah Boone, trying to fight back against the abuse, became verbally abusive. While the victim has committed verbal abuse, it is important to remember that they, Sarah Boone, are the victim and have been pulled into an extremely vicious cycle where they are trying to survive.
Are you reading? What are you reading?
Sarah Boone intentionally left Jorge Torres in the suitcase, which was the act of a battered spouse syndrome woman. She went up to her room, she fell asleep, or passed out. These actions are disconnected. Ultimately, she didn't let him out because of her fear that she knew if he got out in that moment, what he would do. That's real fear, that's real trauma that she was experiencing at that time. Now, I talked to you about force being used, and I think I talked to you about blocking an attack using a physical restraint like the suitcase to block somebody's attack. And the example I give, I got a couple of examples that may or may not apply. Let's say
I don't know if we need a
you're
couple.
in a bar and you got your buddies and the other guy's got their buddies and they're drinking and it ends up being an argument between two of them.
We heard those.
and you realize that these two are fixing to get in it, well, one of your buddies comes around on the other side and grabs the guy before he's able to strike him, right? So you're committing an offense on this guy, but it's a restraint. It's a restraint where you grab him by the neck and try to get him out the bar. So yeah, you're committing an act, but it's designed to defend another, which is legal. Or let's say you have a situation where you have a police officer and he's on patrol. You know, he's in uniform, he's wearing a firearm, and of course he's got the bulletproof vest. And he's called, he goes to a call where there's a suspect that may be armed. A suspect that may be armed. And so he gets there, he gets out of the squad car, he's walking around. Of course, he's taking out his gun because he realizes he may be armed. And eventually he sees the suspect, and the suspect reaches for his waist. Now, in that moment in time, that officer has to make a decision.
How did the victim reach for his waist in this case? Can you explain it to me?
Am I going home with my family tonight? And I asked Dr. Werner about this basal instinct. It's called fear response or fight or flight. You know, those decisions are made, it's instinctive based on your set of circumstances. She instinctively reacted to her unique set of circumstances to save her life or save herself from another one of these. I'm 63. I can't imagine that. I can't imagine that. Her father's not around.
Are you going to argue there's no man around to protect her because her father's not around?
I need to talk about the case a little bit.
I really think that's what
And if you remember,
implying.
I'll get back to it. If you'll remember,
I think that's why he said he was 63. He's like, I'm kind of old school. I don't know if 63 is old enough to be that old school.
Let's start with the witnesses, and then I'll talk about Sarah. But the first witness out of the box.
May I suggest
for the state? You remember was Juan Torres.
Don't use out of the box.
Remember that? It was some time ago. I know it's been a while. Y'all taking notes. You may have to go back.
Counsel?
Their first witness was a good witness for us. Their first witness in their prosecution of Sarah Boone for murder was a good witness for us. Remember Tony Henderson did the cross-examine of Juan Torres. Asked him, what did you hear Sarah Boone say? Juan Torres, she was yelling, he's been choking me. He's been choking me. Mr. Henderson said, did that surprise you? Juan Torres said no. That family knew what was going on.
I don't think they think what you're thinking, though.
The police knew what was going on. The neighbors knew what was going on. Pearl Walker came in here, 80-something years old, in a wheelchair. Kevin Beck called her up.
Kevin, my buddy.
She saw it. Is there any doubt? Is there any doubt? I tell you why there's no doubt. In cross-examination, I got Dr. Warner to even admit. Did you hear it? Yes? Okay, Mr. Owens. She suffers from battered spouse syndrome.
Yes, and?
Wouldn't admit it on direct. Well, maybe. I don't really know. I hadn't had enough time to really see her.
That was about PTSD. That misstates the
You hadn't seen the
testimony.
pictures? You hadn't seen the 2-minute video? You've seen her one time earlier this month. One time.
That's a fair argument.
And she's going to start testifying about stuff she's never said before until she showed up in court? About, well, based on what she told me, I don't think she was an innocent.
Surprised you didn't object to
Come
that.
on. This is a courtroom. This is a courtroom. Good thing y'all are here. We thank you.
It's like, this ain't a scene, it's a goddamn arms race, jury.
But it gets even worse than that. It gets even worse than that here in this courtroom.
I'm surprised there aren't some
The state
objections to
attorney
this stuff.
referred to these pictures. And I was going to rise up and show these pictures to you.
Overruled. You may proceed.
Why didn't we object
And I was
earlier?
going to rise up and show these pictures to you.
Chad, stop singing Hamilton. I see it
Do
happening.
that.
I'm teasing. Don't ever stop
They
singing
put her on
Hamilton.
trial for murder. But what did they say? And I got to turn to this. Make sure I get this exactly like they said it. 'Cause I took a bunch of notes. Let me make sure I got this quote. Can't even find it. But it was something to the effect, maybe Jorge Torres is the battered spouse. Can you believe it?
They did say that. They did say that.
Can you believe that? Now you know why we're here. Now you know why we're here. Little boys learn early on that girls are different. You do not put your hands on a girl. You can't wrestle with them, you can't punch them, you can't kick them. You can't treat women that way. When you become adults, I don't care what she does to you. I don't care what she says to you. If she gets in your face, whatever she does, you do not have a right to hit a woman.
Wow.
No, sir. What has the state attorney tried to do?
Objection. Upper argument.
Sustained.
What has they done?
They're trying to convict your
What
client.
evidence have they tried to put on?
Overruled.
What evidence have they tried to paint Sarah as? What evidence? Controlled and manipulated were the words they used.
Oh, boy.
You know, this ain't the 1900s. This is 2024.
What? You know that? Sir, did he just say that unironically? Did he just unironically, after making those arguments, say, this is not the 1900s, this is 2024?
Well, What's all these text messages? Why is that relevant? What are they trying to claim? She provoked his violence?
Sir?
She provoked his violence.
I think they said that he wasn't violent. the
Isn't
night
that
of the
what
crime.
they've done here? In this trial?
Proper argument.
Sustained.
At some point, he's going to say the state's arguing that, like, she deserved it. I worry that's where he's going. I don't think he
Abraham
should.
Marino.
I'm worried.
I don't know if you remember him. Abraham Marino changed his statement. They took a statement from Abraham Marino in which Sarah stated, I don't know if you remember, but it was when the police were all there. I think they got the tape out, and some neighbors were coming around, and there were 2 or 3 neighbors sitting around. He said Sarah came out and stated it was an accident. Okay? Well, then, it was an accident. And this, Abraham Marino knew Jorge Torres from Philly.
From the apartment building.
Okay? They were friends. They would talk either at the complex, or if Marino went to Hall's Ace Hardware or Ace Hardware, what it was called.
I don't know if he changed his story.
The state attorney notifies.
You reading from your phone?
Judge, I'm going to object to reading from things that are not in evidence.
Approach.
Ding, ding. There's that objection. I was waiting for that earlier. Yeah, you can't read from shit that's not in evidence. He's been doing it. They haven't objected. It's about time that they did. This is bold strategy, Cotton. Let's see where it goes. I'm a little baffled, maybe more than a little, and words are failing me. So I'm gonna go to some of your questions. I don't know what's happening. Can we go back to singing "Rise Up" in the chat from Hamilton, please? That was better. That was better. That was better. Y'all, here, I will say this. There are a lot of times were you to watch cases where there is zealous advocacy. You might not agree the way that defense attorneys argue their cases. There are definitely arguments I have seen that have put my eyebrows all the way back on my head. The defense attorney does not give a shit what we think sitting here. He doesn't care if his arguments are distasteful. He does not care how his arguments come across. He cares that he is advocating for his client. And there will be times that those arguments will be and may be distasteful. That is his choice. It is a little wild to not read the jury well, but what he cares about is the jury. And I don't know if this jury is with him. I don't know if he thinks this jury is with him, but it is a difficult argument. However, this is not, well, I can't say this one is, this is a little bit wild, but you will see arguments that you're just like, I can't believe we're saying that. That is what that's what he's doing. But if he offends those on the jury, that is a problem. And that is where he has to be mindful, because that can very much come back to bite him in the ass. But he is not here to be tasteful. He is here to be a zealous advocate. And, well, I think we can see the direction that he is choosing to go with that. Okie dokie smoky pokey said, Note to self, never hand draw a flyer seeking defense attorney. For those of you listening, audio only, the attorneys are up at the bench. There was an objection to the defense reading things that were not in evidence. He's done that a couple times. I'm surprised this was the first objection. So they are up at the bench. This is an extended hearing at the bench. So this is an extended hearing at the bench regarding him reading things that are not in evidence. Even if one of the experts relied on a report, he can't read that in. He can talk about the expert's testimony. He can talk about what the evidence showed. He can take the evidence and make argument from the evidence. He can talk about the jury instructions, but he can't just read off other shit. I think at one point he was reading a book about battered spouse and they didn't clock that. So, I'm a bit befuddled. Let's get to 800,000 subscribers and then celebrate that, and then try to wash out our brains from what we're watching in court. Kel Mel says, Sarah, you in danger, girl. I wonder what she's thinking, right?
4.5 years.
Can you imagine?
Marino says, all I heard Sarah say that afternoon
and we're back.
It was an accident. Then he came in here today, or this week, and said, no, she said I was teaching him a lesson, things got out of hand, and then I fell asleep. 4.5 years later,
This is
his friends.
Who works at the apartment?
With the Torres. We heard it here. Now, I want to talk to you about the two boys that live right next door. You remember Vincent?
Sir.
Vincent Battaglia.
Warning.
And Brandon Motes. Remember those guys?
I know the jury loved
and you
them.
remember it came out in the testimony, this event happened on February 23rd of 2020. But it came out in the testimony that Sarah had said Jorge Torres, the night before, February 22nd of 2020, grabbed me by my hair and pulled me down the stairs in my apartment from top to bottom, which is consistent with what they were saying happened, remember? But they got their dates wrong. And remember Mr. Henderson called Deputy Copsel, or Detective Copsel up in our case, and she had to say, yeah, I didn't take their two statements until the 27th, February the 27th, remember? So they're remembering back, and they both had similar stories. Of course, they had time to talk by then, the 27th. I think the only recorded interviews they got the night of this event, February 23rd, was from Sarah Boone and her ex-husband, Brian Boone, right? So they came back following up on the 27th. That's when they got a statement from Brandon Motes and Vincent Battaglia. And at that time, they said, yeah, we heard that sound.
They said they
Sarah
heard it.
testifying? No. That was the night before. I complained about that, and I think one of them had testified. Yes, she had said something about being drugged down.
I don't remember that.
It may have been, can't remember now who it was. One of them. And, it looked like that there may be some implication that Sarah got him in the suitcase and pushed him down the stairs. But I think we didn't have anything more of that. Remember? And then this photograph, which we introduced, which shows the bottom of the stairs. As you can see, there's Lucas's bookshelf right here. This is where Sarah Boone stored Lucas's stuff. And you can see it's not disturbed at all.
At like 3 o'clock the next day?
Anyway, I want to get back to Sarah. I want to talk a little bit about that. But let me talk a little bit about the law on justifiable use of force.
I think you should read the jury instructions.
Legal and lawful if you reasonably believe, I think we all probably already understand it by now, you reasonably believe it was necessary to prevent imminent threat to harm. The law is crucial, ensuring that individuals can safeguard themselves in potentially dangerous situations. by acknowledging you have a right to defend yourself when you have a reasonable belief that force is necessary to prevent an attack. Okay? What did Mr. Henderson say in jury selection? You don't have to wait. You do not have to wait. If you're facing, in your mind, a reasonable, imminent threat, you don't have to wait. Let's talk about Sarah Boone.
Reasonable and imminent being key.
And this unconventional form of physical restraint to block the attack of Jorge Torres. What did she say? You saw the tape.
I feel like putting up a poll about closings might be mean at this point.
You got to think about that. You got to think about what was going on. You got to think about the trauma she was undergoing. You got to think about they've both been drinking, and you got to think about the fact that it was all fun and games for a while. And I think the biggest thing to know is that Jorge Torres chose to get into this. He's a grown man. That was his choice. She didn't force him in at gunpoint to get into that suitcase. He voluntarily got into that suitcase because they were drunk and being silly and stupid.
And then he wasn't allowed out. And then he wasn't allowed
Which I
out.
guess when you get so drunk, that seemed like a good thing. Zipped him up, they're laughing, carrying on. And as you know, Sarah likes to videotape a lot. And I know you've seen some of these videos and you're wondering why.
It's not videotaped.
But I think the evidence shows that when George is being videotaped, he's not going to do anything. If you think about that. When George is being videotaped, that's like her power. You know, Dr. Harper said that Sarah's words are her power. Sarah's words are her
Interesting
power.
argument.
Physically, she's no match for George. Physically, she's no match. But that's her
You should
power.
have led with that earlier
When she
on the
gets
missing
a
minutes.
chance, when she gets a chance to have some control, that's what she does. And she videotapes because she knows when she's videotaping, she can tell it like it is. I can tell him what I want to tell him. A couple of these videos you've seen where she's telling him like it is. But she's got that video camera on and George knows. He's being videoed. We've got one that we will show you in a little bit. Where he loses it. Just a little bit. Right at the end. And then of course we got the TV. But they're kidding around, playing around. Then, Sarah realizes, okay, this is my chance to say something to him. So she sits down, she turns on the phone.
I mean, she doesn't talk
and
it out. She
you've
calls
seen
him
the tape.
stupid and tells him to shut the fuck up. But okay.
You've seen the tape.
Yeah, we've definitely seen the tape. I think his argument about the video
For everything you've done to me
is lost.
are the first words out of Sarah's mouth
In all
when the
of this.
video begins. There's a lot packed into those words. Think about that. For everything you've done to me. This is how it feels when you choke me. Now that's in direct response and the result of the abuse that she has suffered at the hands of George Torres. She wants him, for that moment, to feel how she feels. She wants, for that
So
moment,
she's not defending
to
herself.
feel. For him to feel how she feels.
Like teaching him a lesson?
How uncomfortable, lack of control that she feels when George is violent with her. Just for a moment, she wanted to do it to him. And if you can imagine,
Approach.
Another objection. I'm surprised at the amount.
I think from the evidence, you can determine she was crazy. She was crazy about that. And I don't know if, of course, it's a syndrome, but she felt like she couldn't do without it. And let's say she videotapes him, and then it's turned off. And there's a 9-minute gap, 11-minute gap, whatever it is. I said 11, they're saying 9, but I think if you count 2 of the others, then it's 9. But there's 9 minutes that we don't have video. But what did Sarah say? Now, if you remember when you listen on that video, George is talking in a normal voice. He's not stressed. Of course, if you're talking, you can breathe. She had said she had some air. And of course, she doesn't realize the situation, that it's going to end the way it ends. So she has no appreciation of that. It's a canvas. All she knows is an old canvas suitcase that she's got some, the 2 zippers removed, or spread out a little bit so he can. So she thinks he's not being serious. But eventually he gets angry. She gets angry, he gets angry. He says words to her, and then his hand starts to come out of the suitcase.
He's the only one that said she got angry. Well, there it is.
She also said his tone changed. And I know everybody's got a cadence with their spouse or boyfriend, girlfriend, but you know what I'm talking about. We've got a way of talking to people. We've got a way, your wife, your husband, you know each other. You know when they come in from work, what kind of mood they're in. Just by a couple of things, the way you can just sense it, right? Well, especially somebody as hypervigilant as Sarah and as hypervigilant as a battered spouse woman would realize that he can flip the switch at any time. When I get out of here, I'm going to end you. And he realizes he's getting out. He got his hand out. At that moment in time, in Sarah's mind, that's an imminent threat. So she's got a justifiable right to use force. What did she do? She went over there and grabbed it. She lifted it up. She tried to get his hand back in, remember? She tried to get his hand to go back in. Wouldn't go back in, so her son's back was 3 feet away. Where the police found it the next morning. Same spot. No attempts to hide. No attempts to delete the phone. No attempts to tamper with evidence. Nothing. In the same spot as it was. She picks up the bat.
She said she forgot recording it, though.
She pokes him hard, trying to get him to stop trying to get out. And eventually he does. And you've seen the blunt force injuries, and you saw some of the circular injuries where you can tell there's a poking. I think it's right around here. And she poked him several times. You remember the pathologist said, I think, maybe 5, 6, or 7 times. She pokes him. And he's got some scratches. I don't know if they'll let you look at it, but on the back of that suitcase, it's got some bars, some metal bars that are inside the lining. There's some lining.
Does this,
and it's for support when
does
you
this help him?
walk it. She testified. You heard what she said, that she was justified. That's uncontroverted testimony. Now, let's talk about the jury instructions just for a minute.
Well, finally.
I want to talk about reasonable doubt for a minute.
I suspected you might.
Can't find the page, but I've got one. I've got one to use it.
He's like, oh wait, I've got it on the board.
If we find it. If y'all are all looking.
It's It's not the good kind of paper rumbling, Owens.
I think it's on page 15 of 22. And we're going to talk about reasonable doubt in a minute, but if you look at those bottom three short paragraphs, it is the evidence introduced in this trial and it alone that you're to look for the evidence or look for that proof. A reasonable doubt as to the guilt of the defendant may arise from the evidence itself, a conflict in the evidence, or lack of evidence. But here's the main thing. And, obviously, I represent her, and I'm trying my best to show you honestly and fairly the doubt in this case. And 5 reasonable doubts, 17 reasonable doubts, 25 reasonable doubts. You have to have one reasonable doubt. I'm trying to show you throughout the evidence that each one of you can have a different reasonable doubt. A difference, but one reasonable doubt about the state's case, and your verdict is not guilty, according to law. Proof beyond a reasonable doubt does not mean proof beyond all doubt. A reasonable doubt is not a mere possible doubt, speculative doubt, or imaginary or forced doubt. Such a doubt must not influence you to return a verdict of not guilty if you have an abiding conviction of guilt. And this is a deeply held belief. Reasonable doubt is the highest standard we recognize in litigation. Car wreck or something like that is preponderance of the evidence standard, 51%, you're entitled. Abiding conviction, that's a deeply held belief that you must have if you're thinking about something. That's a firm belief. That's a level of certainty that you would have. That's what you got to have as a juror. I've got to be certain of her guilt. If, on the other hand, if after carefully considering, comparing, and weighing all the evidence, which we want you to do, there is not an abiding conviction of guilt, so I'm not certain. I'm not certain of her guilt. Or if you have a conviction, I think there's some evidence of guilt, but it is one that is not stable, one which wavers and vacillates. One which wavers and vacillates. Then the charge is not proved beyond a reasonable doubt, and you should find the defendant not guilty because the doubt is reasonable. You understand that? You've got to be certain of guilt. That's the high standard we recognize. If I've got some evidence of guilt, so okay, there's some evidence for conviction, but it's not stable. It wavers and vacillates. Then under our system, you've got a reasonable doubt. And you've got the power and authority and the obligation under the law, if that's the way you feel, to vote that way. Later in the instruction it goes on, it's up to you to decide what evidence is reliable. You should use your common sense in deciding which is the best evidence and which evidence should not be relied upon in considering your verdict. You may find some of the evidence not reliable or less reliable than other evidence. You may rely on your own conclusion about the credibility of a witness. That is totally the province of the jurors to decide that. A juror may believe or disbelieve any or all the part of the evidence or the testimony of any witness.
Mm-hmm.
I want to show you this before I forget it. But Dr. Warner said, this is their expert again. He testified that Sarah Boone suffers from battered spouse syndrome.
She did.
Battered women's experiences affect her perception of imminent danger. Those past experiences with Jorge Torres, and there's a bunch, affect their perception. Remember Dr. Michael Brandon talked about perception of imminent danger. Victims of repeat violence may fear death in situations others would not. The reason Sarah experiences all this, the reason she was feeling the way she was feeling, that imminent threat of danger from Jorge was because of Jorge Torres.
Notice he didn't say
Jorge
what
Torres
Jorge Torres
is
was
responsible for
doing.
her mental state because of the way he has violently treated her. She reacted to his attempts to get out because of the way he treated her and the way she knows what is he going to do if he gets out of the suitcase. She knows. The second video is played. She's flipped it back upside right. You hear him, it's 22 seconds. He says, Sarah, she's not going to open that suitcase. She's not going to open that suitcase. He's already threatened her.
He sounds so menacing in that second video.
She used the bat to get him to stop trying to get out of it. Why would she do that?
This is what his whole argument should have been. This part.
Why would she do that?
This part.
I know what he's going to do. I know what he's going to do to me. I know him like I know more. I know him more than he knows himself. I know what he's going to do to me. You don't have to wait. That was justifiable. Now, you got to understand this. She intentionally used the bat to defend herself. She intentionally didn't unzip it to defend herself. Both of those are lawful under our law. She went upstairs. The dogs were upstairs. At some point, she called her husband, or ex-husband, Brian Boone. We know that many times she testified, or somebody in court said, she would often flee to her ex-husband's house sometimes. I believe that testimony came out from either Sarah or somebody. That sometimes she would flee,
the prosecution would object.
Flee to upstairs. One of those two. But the dogs were up there. She made a phone call. At some point, she fell asleep. Passed out, fell asleep. We don't know. They had 2 big bottles of wine.
They used them synonymously.
Right? That was unintentional. That was unintentional. His death was unintentional. You remember when she was in the interrogation room? You remember that? Now, I don't know if we did a good job of this, but it came out that she got arrested. You remember the one time when she got the black eye? She got arrested for strangulation. And you remember that? It was, they ended up over there by the dryer, and he was banging her back of her head on the floor that had very little carpet on it. And she ended up getting her arms out, and then she grabbed his neck. And she eventually got him off of her, and that's when he got up and stomped her in the eye. Remember? Well, the police came for that event, and they took statement, and Sarah was honest with the officers about what all, and they arrested her.
Are you saying he stomped her in the eye while she was choking him?
They arrested her.
That's what you said.
And she said, why? I was fighting back. You remember that? Why? I was fighting back. So from that point on, she didn't trust law enforcement. The video that they showed a while ago about...
We saw a lot of videos of her interacting with law enforcement, though. Just saying.
George, that was about dropping the case. Where she was...
That was the worst timing ever. Apologies, as the video yeeted itself. Sorry, chat. That was 100% me. Apologies. No jump scare. That was just the video yeeting itself. We will continue on to closing. I tried to make a comment. That's what you get for snarking during closing, Emily.
Defending herself and fighting back. want to talk about this investigation by law enforcement.
I've seen a lot of people that don't trust law enforcement. It's not what
She didn't
we saw when she was drunk.
know the law. She's not a lawyer. She gets up the next morning. Brian's calling. Sarah's got to pick up Lucas at 3. Brian's calling. Eventually she walks down. She's looking for George. Where's George? It's quiet down there. Then she looks in the bathroom. She looks out. He's smoking a cigarette. Is he on the computer? She sees the suitcase. And you can imagine.
Objection, golden rule.
Sustained.
That's improper argument.
She sees him in the suitcase.
That's improper argument. You can imagine going the wrong way.
She panics. What does she do? What does she do? She tries to get her fiance out of the suitcase. They're engaged to be married. She's not trying to kill him. They're engaged to be married. She gets him out. She tries to do, he's purple. She tries her best to do CPR. She doesn't, and you heard her, I didn't know what to do. I didn't know, call Brian. That's her safety valve. That's all she's got. Brian eventually says she's come over. She calls again in 2 minutes. I'm on the way. He gets there. You got to call 911. They have told her before. Call 911. She calls 911.
Brian is like, can I please
She
be
tries to do
excluded?
CPR again. Is she busy trying to hide evidence? She busy trying to hide evidence? She busy trying to hide the back? No. She's trying to save his life. If she can.
I don't think she knew there was evidence on her phone.
So the police get there. She knows
Police always took her side in
if
the
she
past.
told them she fought back, she's going to be arrested. That's what happened before. What happened before, like George has said on the video, she'd never been arrested before. Before that time, she was charged with that with George. She lies. She lies. She's scared. She's scared. She doesn't know what to do. So she lies. She makes a decision to lie. Don't trust law enforcement. She doesn't know the law. She doesn't call a lawyer. She talked to Officer Rodriguez, was the first short black female that came up here
That's
first,
so loud.
the first one that arrived with body cam.
That's so loud.
Talks to her. There's a recorded statement there where she doesn't tell the whole story. She lies. And then the detectives eventually get there and get her in the squad car. You hear the audio. I think it was played. She lies again. Then the next day, she goes down to the sheriff's department. Now, if they would have told her, hey, ma'am, we're going to arrest you. And she gets a lawyer to go down there to make a statement. And the lawyer would advise her.
Objection, facts not in evidence.
Sustained.
Move to strike.
Stricken. The jury will pay no mention or give any weight to that statement.
The jury's lost already.
She's not a lawyer. She didn't have a lawyer present when she made this statement.
No, she didn't.
She didn't know the law. She didn't know
She thought
she was justified in defending herself the way she did in this dysfunctional, toxic, abusive relationship.
She was also told like twice, if you can't afford a lawyer, one will be provided. So there's, you know,
I
that's
don't know
what
if you remember, it was a 2-hour video, but there was some things
Miranda's for.
she said, you know, it was not intentional. And eventually, she wanted the detective, it was Detective Lowen, the male detective. And she said, I swear to you on my son's life, it was not intentional. What
She
she was
wanted
talking
him to
about
believe her.
was that George passed. Was that George died. That was not intentional.
It's a second degree?
She thought he was fine in there. Would he sober up?
That's not in evidence.
We've learned from their history, when Sarah gets drunk, she calls for help. When George gets drunk, he beats Sarah. That's their pattern. How many times do we see Sarah call the law? That's their pattern. Sarah told him, I didn't know, I think she said, I didn't know something like this could happen. I've never done it before.
Important.
And Detective Lowen said, well, what did you expect that was going to happen?
This part actually matters. She has to perceive that it's dangerous for the second degree.
She was about 18 or 19, and she got a grandmother's hand-me-down pickup truck. It was an older truck.
That's not in evidence.
She didn't have it long, and she was gassing it up, but she didn't put any oil in it. And eventually, it burnt the motor.
Well, this is a story.
And you don't know what you don't know. I hadn't done a good job of explaining, hey, you got to put oil in it too. Sarah Boone didn't know that he could die in there.
This is
an old beat-up canvas suitcase
an important
that she left a gap in. And as naive as that sounds, she didn't appreciate the danger. I mean, is that the way you want to kill somebody? Is that the way you're going to do it? She had Lucas to take care of. Am I going to go to prison doing it like this? No attempt to hide the crime. I think the evidence is clear. That's how this happened.
That's very close to vouching.
I don't want to belabor the point. I do want to show you.
Now he says, I don't want to blame the poor guy. You called him a monster earlier.
Sarah Boone got stabbed.
Can we not? We know. Can we not?
Think about that. Stabbed with a steak knife in the leg. And she stayed with him. She stayed with him.
Apologies,
Poked
YouTube.
between the eyes with a curtain rod. Stalked in the eye. I mean, who does that?
Owens, where are you going, sir?
The law empowers an individual to defend their life and safety when faced with a threat and to prevent an attack. That's what Sarah Boone did. That's what Sarah Boone did.
Are we going to end on that, or? He needs to make the self-defense instruction clear, I think, and he needs to make the second-degree murder instruction clear. I don't know if he's done that well. She has to perceive the danger. Yeah, the state's going to argue he was telling her he couldn't breathe, but he has room to argue on that. But I don't think he's made it clear here, and I think using
I think it's important to understand
guide would help.
Sarah had to be the parent a lot of times. It was her place. She had that $1,000 a month from divorce settlement coming in.
It's a relationship?
She had the car. She had the phone. She had the keys.
The
she had to
control?
be the parent in a lot of ways.
So she had the control?
I want to talk a little bit about Dr. Harper. If you remember, Dr. Harper is from Okaloosa County, which is up in the Panhandle, close to where we're from. And she's the doctor that treated Sarah from early on. Remember, this happened in 2020, I think.
Treated?
She first treated, or first saw Sarah Boone shortly thereafter. And over the 4.5 years, saw her 9 times and did all the testing for post-traumatic stress. Of course, she has the experience from the veterans, and she's testified that she's now just traveling around the state, testifying as a forensic psychologist. But she talked about how important it was to develop trust with the patient over a course of time. It's just going to take time when you have somebody suffering that kind of trauma and that kind of damaged psyche. It's going to take some time to get them where they can trust you and really tell you and talk to you and tell you what's going on with them. She talked about that Sarah uses her words for power. I think her testimony, I don't think, but I think the evidence supports that her testimony was credible. The evidence supports that her testimony is credible.
Objection is sustained.
I can't.
You can't vouch. You can't vouch. I think she's credible is exactly what the fuck you can't do. You have been dancing on vouching for shit the entire closing. And while I think there were times the prosecution was overzealous in their objections during closing, this is absolutely what you can't do, sir.
I don't think, but I think the evidence supports that her testimony was credible.
Objection.
The evidence supports that her testimony is credible.
Objection is sustained.
I can't give my personal opinion.
Yeah, you can't.
Correct. The evidence supports that her testimony was credible because of the time that she spent, because of the number of tests that she did, and she diagnosed her with post-traumatic stress disorder, alcohol use disorder, I think anxiety disorder, and battered spouse syndrome. Dr. Warner confirmed that, and Dr. Michael Brannon, the first witness, he was brought in as a subject matter expert, so he hadn't treated. So he was just
Nobody treated her.
testifying
They're forensic.
about the condition. He's been doing it a long time. He's an expert at it, and that's to advise you
Forensic.
to try to understand what's going on.
I'm gonna call.
And as crazy as it sounds, in this syndrome, they try to protect the abuser. They're in love with them. They try to protect them. I don't know if you remember that there was a time where Sarah Boone had a conversation with one of the neighbors, and they were talking about something. She said, "Did you hear anything yet last night?" Remember, she said, "Shh, it's okay." Both George and Sarah lied to the police. They lied to medical people. I don't know if it's shame, but it just comes with the syndrome. That you stay trapped in it. I think another big, if you'll think about this. When Sarah gets beaten by George, she calls the police. When Sarah gets beaten by George, she calls the police. And a lot of times she just wants him out. Just get him out. Get him to leave. She doesn't want him to get in trouble. She just wants him out. There never was a report of George calling the police on Sarah. She wasn't physically abusing him. The state is trying to present evidence. Did she emotionally abuse it?
Sustained. Stricken. Members of the jury will pay no attention to that comment. give it no weight whatsoever.
I believe the evidence that's been presented by the state is an attempt to show that Sarah mentally or emotionally abused George Torres.
It's up to the jury to decide that.
Again, she's not charged with that. She's not perfect. Some of that was her trauma. In Sarah's situation, you do become numb and hardened, I think, over time. That's a coping mechanism. It's a day-to-day thing, some good days, some, But the homicide detectives, I know if you saw that 2-hour video, at some point during the 2-hour video, they started talking about some of the violence. And they go, we know. They had already checked with neighbors or whoever. They knew. The neighbors knew. Police officers knew who responded. Torres' family knew. They all knew about the abuse.
Somebody asked how long he's been talking. It's officially been 85 years.
Dr. Harper testified that abused women act differently
I
when
think
they
she said
perceive a threat.
people.
I think Sarah Boone was loyal to a fault to
That's
George,
too much I think.
even through all the abuse.
It's 84 years, 87 years, 85 years.
Judge, I want to make a comment about a couple of things that were said by the prosecutor in opening statement.
What?
Actually,
Why are you looking at the judge saying, I want to make a comment about what the prosecutor said? Sir, it's closing argument, closed, but you can't vouch for, I think this is credible, I think that's not credible, I think Sarah was doing this. The evidence shows, and then argument.
The prosecutor in opening statement, when he was talking about George Torres passing away, he started talking about Sarah Boone. And his quote was, because I wrote it down, George, in Sarah Boone's mind, George Torres deserved it. George Torres deserved it. That's the position they're taking.
No, it's not.
He deserved to die. She loved the man. She wasn't trying to kill him. He also commented about...
yes.
That misstates what they said in opening. That misstates what they said in opening. Though, I hate to say it, I did say at some point the defense was going to get to those particular words and that I was concerned that they would come in. The defense said, the prosecution said Sarah believed that George Torres deserved it. I don't think that's what they said in opening. I think we will see there at sidebar on that. I had paused to yell about vouching, and so now we are back on real time. This is a difficult closing to follow. I think there were some points he needed to make. I think there were some points that were difficultly made. For those of you that are just tuning in, yes, it is 6:06 local time. The judge is allowing the jury to deliberate till 10 or whatever p.m. So there is going to be deliberation after this. The jury has dinner coming. We still have the rebuttal of the state. It is now 8 hours and 34 minutes into stream. So when we go to verdict watch, we will switch to a different stream just because this is going to get real clunky the longer we go. Not by me. Well, maybe also by me. But as the streams get too long, they can get a little difficult. So we will switch to another feed for verdict watch for tonight and leave the chat open for members. And then as we know, or if there is a verdict tonight, we will let you know in the Law Nerd app at lawnerd.app.com. We will send you a push notification so that you know. I will also update you on all of the other places. But when we go live, you should also see a notification if you've clicked on that for the live stream. So we will notify you all the ways, but also if you want to just keep the chat open, we will notify you in the chat. So we will have a stream up and ready tonight, and you can, free app. We built it exactly for this purpose. And each trial, it keeps getting better. So thank you. For those of you that were asking about where we are subscriber-wise, we are just a few hundred away from 799,000. So thank you for those of you keeping on top of that. I think they are trying to figure out how to fix what counsel said. I imagine that's why there's such a long sidebar, because counsel said, the prosecution said Sarah believed XYZ. I think they're probably trying to figure out how to fix that, because I don't know what they're going to do with it. So, yeah, this is a rough closing. Again, I would have expected and hoped he would have gone through the instructions. In the second degree instruction, her not perceiving the danger of the situation, I think he could have argued. I know many of you will disagree and said he told her he could not breathe. I agree with you. I think it's room for the defense attorney to argue that she had no perception of danger and try to argue for that the lesser included by arguing that. And there was a lot of room to explain battered spouse better.
Prosecutor said in opening.
He's trying to fix it. He should have to apologize. I apologize to the prosecution team. And he could have and should explain how battered spouse works with the self-defense instruction. I don't think he's done that well here yet. Will he?
Violence. The violent episodes. It's a bunch of violent nonsense, was his statement to you, an opening statement. All this here, the photographs, is a bunch of violent nonsense. You'll have to make your mind up whether that's that. There were a couple of exhibits that I introduced late, and there were no contact provisions, where there had been a court order from a judge, not only a verbal order, but it was reduced to writing. So there was a court order for Jorge Torres not to have any contact with Sarah Boone. Okay? Court system got involved. We would have no contact with Jorge Torres. Now, I need to talk a little bit about that.
Okay.
And they talked about coercion, coercive control, power and control.
I'm interested to see how he argues
We
this.
know about his abuse. We know he destroyed the home, the TV. We know about his jealousy. We know some of the things he said to her. We know about how he treated her dogs. Nicely when he was sober, but at times abused the dogs or threatened to do so. If you think about power and control, when you're controlling a person, and I think she testified that he kind of smothered her, was always around her. Part of his fear was her realizing that she'd had enough and to leave him for good.
That's not in evidence.
That she would get the strength over time if she had enough time away from him.
Not in evidence.
Where she wasn't in control of it and he wasn't in control of it.
And I would have.
Enough time away, she would come to her senses and realize she could do better. The judge has been giving court orders all week. I didn't stop Jorge Torres. Jorge Torres knew he was going to lose control if she had a bunch of time away from him. She might move on. He was willing to violate a court order to maintain control. That's Jorge Torres.
I don't know if I read that situation the same way you did, counsel.
I want to show a couple of videos. And I want to say something to you. Shelby Andrews is going to help me. If we could dim the lights.
Yes.
His point about when she was and wasn't filming might have been his strongest point, but it got lost in everything else. But we saw the text messages today. And I think that's what was so helpful about the text messages. And remember, after this, the state goes again, folks. I hope all of you are making, well, all of you in the States are making dinner at this point. I guess West Coast isn't, but.
Do you understand?
In evidence?
As of this moment, and until I can get you out.
Oh, this is the second, this is a edited down video. This is the second part of a video we saw yesterday.
Get the fuck out of here. You're a room. I dare you.
Did you see him?
Look at him.
Did you see him trying to grab the phone? I did.
Get away from me. Get away from me. I'm gonna scream bloody murder. I'm gonna scream bloody murder.
Did you see him flip the switch? In that instance? Where he lost it? Even though the video was going. Show the next one.
They stopped it before you can see him horribly out of breath. That's interesting.
Thank you. Thank you, Judge. Can you turn it off? Can you turn it off? Ladies and gentlemen, I'm going to finish up right here.
Really?
And Sarah Boone, I've gotten to know.
Objection. Improper argument.
Sustained.
Sarah Boone is like any other citizen. Equal justice under the law. She's to be treated like any other citizen. Fairly and impartially.
Okay.
Based on the circumstances she was facing at the time of this tragedy. Based on the battered spouse instruction, which is a special instruction that's given
go over it.
when women have a heightened sense of fear and trauma, that you're to utilize in applying her subjective standard to the reasonable standard of what a reasonable person would do under her circumstances in using the force that she used to defend herself.
At least he didn't miss
I hope I hadn't missed anything. I've tried my best.
Oh, the sad fishing. Ladies and gentlemen of the jury, save me if I didn't do a good job. I hope I did my best.
Sarah Boone fought back and survived.
I hate that.
We ask that you do justice in this case and find her not guilty because the doubt is reasonable. I've tried to show you where the doubt was. I trust your judgment. We spent a long time picking the jury, 4 days. We trust you. We appreciate your service and your obligation to do your duty. You have the power and authority to right this wrong. That's what we're asking you to do. And give Sarah Boone some hope for a better life and freedom. Thank you.
And
Thank you,
that's
sir.
the end of the defense
Any rebuttal?
closing.
You may
And
proceed.
now we get to rebuttal. The defense, yeah, take your shit out of the well, Mr. Owens.
Let me get this.
He's like taking Owen's shit out. He's just gonna throw it over there. Take your stuff. And we're going to begin the state's rebuttal argument.
Ladies and gentlemen, Jorge Torres is dead because the defendant believed he deserved to be zipped shut in a suitcase so that she could make him feel how she felt when he cheated on her, when he choked her, and to hold him there as a captive audience, according to her testimony. Now he has to listen to me. Well, right out of the gate, there are credibility issues. Cheating to me means viewing pornography. Well, we saw cheating really means women. And the heated conversation on June 14th about these women in Facebook. And that is what leads to the arrest on June 15th. He's out whoring, Candy Crush, all the bizarre things that you see in her phone. He uses the legal system as a weapon at times. There's no denying that they are engaging in violent behavior, and it is over nonsense. It is smashing TVs. They call the police, and then they're standing there looking bewildered about what to do and who to say, and laughing and joking. Ladies and gentlemen, the courtroom is the place for justice, not a suitcase. The reason we have a jury system originally started with the idea that the king, the crown in England, shouldn't be able to go and incarcerate citizens on his whim.
We got back to England.
So it developed into a system where citizens would have to say, yes, you can take our fellow citizen.
Us lawyers in our history.
But the opposite is also true. A citizen cannot take another citizen's life because he or she feels like it. That likewise requires a jury to decide that it was objectively reasonable for a person of ordinary prudence and caution. Like Mr. Cacciatore argued earlier, battered spouse syndrome is not a license to kill. Past grievances, even being stabbed in the leg, so on and so forth, do not give her the license to kill. There are still laws in place about when and how this can be done in a justifiable manner. I want to talk about the most important jury instruction in this case that has not been discussed very well or thoroughly. Excuse me.
Is that a dig at the defense? Cassandra Fisher in the chat asked, does the jury decide how much time she gets sentenced to? No. They decide if she is guilty or not guilty and of what charge. Then
However,
the judge decides.
Use of deadly force is not justified if you find that Sarah Boone used force to initially provoke the threatened use of force against herself.
Provoke
We'll stop at that comment. The facts of the case that came from her own mouth, if she is to be believed, and we will explore thoroughly why you should disregard every bit of her testimony, from court to the detectives, to the 911 operator, to the doctors. Her testimony, if it is to be believed, the most favorable light that she has presented of herself, is that at the end of a Sunday fun day, where we are drinking, we're outside by the dartboard, we're doing puzzles, we're doing arts and crafts, and there finally comes a point in time where we're going to play hide and seek. And he says, tag, you're it. Even though she's it, she goes upstairs, hides in the shower, eventually gets tired of being there,
Back
it's
to the
cold,
confusing rules
so
of
on
hide
and
and go
so
seek.
forth, and she comes back downstairs.
House rules.
And as she comes back downstairs, she can see Mr. Torres fiddling to place himself inside the suitcase to try and hide for this game. And the lid is not closed, and it's flapping. And out of jest, out of levity, undisputed according to her testimony, she comes over there and zips it shut. Whether it's 100% or enough for 2 fingers to get out, that is something that you decide as the jury. But there came a point in time where the fun and games was over. And Mr. Torres told her that. Babe, I can't breathe. Sarah, babe, let me out. This is all on video. We don't have to imagine this. This is all on video. 1062. At that point in time, she is using force against him that is not justified. She is the initial provocateur. She is the aggressor under the law. And what level of force is it? I can't breathe. Not let go of my hand, not get your hands off me. I can't breathe. This is no different than 2 people, maybe they're buddies at the bar, similar to an example that was given by Mr. Owens, who are wrestling, and one has another one in a headlock. And there comes a point in time where the person on the receiving end of the headlock says, that's enough, I'm tapping. Jorge Torres was tapping. And she ignored it. And she was kind enough to tell you why. Out of anger. Which translates to hatred, ill will, spite. Just like that in jury instruction for second-degree murder.
That was the feed,
She
not
told you
you.
exactly why. She got angry. Him saying, I can't breathe, babe, was what triggered her. Not a fear of imminent harm. Those are her own words. That is the law. These are the 2 paragraphs that solve this equation without getting up on a big whiteboard in college that's 30 feet long, 15 feet high, and a ladder, and somebody's scribbling Latin words and Greek letters for months and months to solve this huge, complicated equation. The equation is solved in 2 paragraphs. She is the initial aggressor. He is saying, I can't breathe. It is no different than a naked chokehold that she does not let go of. And she told you it's because I want him to listen to me. This is my bully pulpit. This is how he made me feel in the past. She doesn't describe it as teaching him a lesson, but that's exactly what she says. I want him to feel like I felt in the past. I want to tell him things. Ladies and gentlemen, we can play semantical games, but that is teaching him a lesson. Therefore, we have to look at the other 2 paragraphs. Because right now, plain as day, the use of deadly force is not justified if you find that Sarah Boone used force to initially provoke the threatened use of force against herself. And what force are we talking about? Well, the threat of force that she tells you she was facing was him fighting for survival. Him sticking his fingers out of the suitcase. Him sticking his hand out. That is the threat of force, coupled with, I'm going to end you. Well, ladies and gentlemen, she is the initial provocateur. She is the one using deadly force against him. If I have somebody in a rear naked chokehold, they are entitled to use deadly force against me to break that chokehold, at least until we're separated. He had every right to say what he said. He had every right to exist and stick his hand out and try and survive to breathe another day. However, the use of force is not justified if you find that Sarah Boone used the force to initially provoke the threatened use of force against herself, unless she does one of 2 things. And she did neither. Not even close. The threat of force asserted towards the defendant was so great that she reasonably believed that she was in imminent danger of death or great bodily harm. All right, let's give her absolutely every benefit of the doubt, which you should. This is a criminal prosecution. The state of Florida has alleged she committed murder. You need to do everything you can to look for reasonable doubt. But a reasonable doubt is not an imaginary doubt, a forced doubt, speculative doubt. So accepting that all of their past history, accepting the doctor's testimony, and the limitations on what they reviewed compared to what we reviewed, We did a much more thorough review of the relationship than any of the doctors did in this case. So let's give her that first clause. Because of their past relationship, with George now fighting for his right to exist and saying that he will end her if he gets out, we'll give her that.
I don't know why that keeps happening. I'm sorry, State. I will let you continue with your closing if the feed didn't get yeeted. That is my apologies, or please accept my apologies. That's happened twice today.
But just like Mr. Cacciatore mentioned earlier, lawyers' words mean things to us, and they mean things to everybody, but really to us. Or an and. There's an and. Had exhausted every reasonable means to escape the danger other than using deadly force on George Torres.
These are important jury instructions the defense didn't spend much time with.
She did not use every reasonable means to escape the danger that now, after provoking him, that he was presenting to her, according to her. She didn't pick up her cell phone and start walking, call 911. She didn't do anything other than, if you believe that is why she called Brian Boone, made a phone call to Brian Boone, and unfortunately because of past history, he just ignored her drunken phone call. She did not exhaust every reasonable means to escape this danger that she created. She started it. She created this. Other than using the deadly force on George Torres. Now, this is a weird situation. This is not a rear naked chokehold.
Like MMA.
This is a suitcase, or as Mr. Cacciatore said, a box, or actually more aptly described it
as a coffin.
As a coffin. And when you secure somebody into a box or a coffin, you can still exert that deadly force on them from a distance. I'll give you a quick example from a couple of movies that I love. In 1977 in May, a movie came out. It's called Star Wars. They eventually called it Episode 4.
Who said there was going to be a Star Wars reference? Because I swear to you, the chat was talking about Star Wars references about 2 hours ago, and somebody said we were going to end up with Star Wars references, and it is happening. We had vampires in opening, and we have gotten to use the Force Luke in closing. So for all of you that mentioned it, and a number of you mentioned it in the chat hours ago, and we are in real time on this closing, we have now gotten to use the Force Luke. And just bingo.
In the first scene,
my Lord,
there is this large, imposing figure that wears black armor. He is a government agent, and he is looking for some stolen classified documents. He picks a man up who he believes is responsible for this treachery.
You're actually using a force choke analogy? You're actually using a force choke analogy. You're actually using a Darth Vader force choke an analogy in your closing argument. That's happening.
Breaks his neck and chokes him to death when he doesn't tell him where the plans are. We all understand that. That is direct force we all understand. But what we need to understand is the force she's exerting from the couch. And then when she goes up to bed, she is still exerting that force on him. She set these implementations into motion and did not stop. So later in this movie that came out in 1977, another co-employee of this dark, imposing figure, Vader, insults his religion. He does not go to HR. He takes matters into his own hands and chokes this person from a distance. Ironically, while we're talking about force, it's the force.
The judge's
And then in the
face.
subsequent movie, he's like doing it from his office. He's killing his incompetent employees on different ships. Force, deadly force, can be exerted from a distance in this situation. So whether she's on the couch or whether she turns in for bed, she is still using that deadly force on him. She has not exhausted every reasonable means to escape this danger. Do something. You started this. You put him in the position where he cannot breathe. She's required by the law to do something about it. Not something, everything. There was no efforts in this case. None. Or, in good faith, Sarah Boone
I'm still
withdrew
stuck
from
on
physical
incompetent
contact with
employees on other
Jorge
ships,
George
honestly.
Torres and clearly indicated to George Torres that she wanted to withdraw and stop the use of deadly force. But George, it just reads as Jorge. George Torres continued or resumed the threatened use of force. That did not happen. She never withdrew from physical contact. She is still, like Vader, choking him from the couch, choking him from bed. She never withdrew that force. Physical contact includes any restraint on George Torres' movement. She never indicated that she wanted to withdraw. Sarah, babe, I can't breathe. All right, if I let you out, are you going to come out peacefully? Since I started this, I'm the one that made you not be able to breathe. That didn't happen. So, ladies and gentlemen, this entire analysis about deadly force starts and ends there. She was the provocateur. These are her obligations when she starts it. She put him in fear of death. He is literally telling her, I cannot breathe.
I'm still stuck on incompetent employees on
Couple
other
other
ships.
thing about
I'm done.
the
My
law.
brain is done.
Second-degree
It's been 9
murder does
hours.
not require a proof of intent to kill.
And I am done.
Argument was made repeatedly that she didn't intend to kill him. That has never been the state's suggestion. Because why would we suggest we prove something that we don't have to? It's not her subjective belief. Well, Sarah Boone doesn't believe that this suitcase can kill him, even though he's repeatedly said, I can't breathe. It's a person of ordinary judgment who would know, is reasonably certain to kill or do serious bodily injury to another. A person of ordinary judgment who hears, I can't breathe, babe, Sarah, and his voice gets weaker 9 minutes later, you're on notice. This is statutory notice. Done from ill will, hatred, spite, or evil intent. Her words speak for herself. This was not out of fear. This was out of hatred and anger. Born out of all those horrible things that has been done to her and done to him. Understand, we're not going to belabor the past. Is of such nature that the act itself indicates an indifference to human life. I don't care that you're saying you can't breathe. Fuck you. That's my name. Don't wear it out. Fuck you.
That's what she said.
It's second-degree murder. We do not have to prove the intent to kill. We have to. She intended the act. She intended the act of zipping him shut.
Right, and leaving.
She continued to intend that act when he said, I can't breathe. That act resulted in his death. That's a manslaughter, but then when you add in the hatred, ill will, spite, and the depraved mind, that's what makes it second-degree murder. And that 2-minute video is the textbook definition of depraved mind as we define it here in Florida. Voluntary intoxication is not a defense. You cannot feel sorry for her because they had 2 1.5-liter bottles of wine and then some from the leftovers from the day before. And quite frankly, she's blackout drunk. She's blackout drunk. She doesn't remember making the videos.
Right.
She turns her phone over right to the deputy the next day because she doesn't know what's on it. She doesn't remember doing it.
You see that in the interview. Also, for those of you new to my channel, I do have a Star Wars tattoo on this arm.
Another thing that
The
we just
law nerds
haven't
are
talked about much.
Nerds of wide variety.
is her story. She can't be up in the shower hiding and taking a picture at 11:03 p.m. 9 minutes before the video. That portion of her story just doesn't add up. And what it shows is it's more like 20 minutes instead of 11 or 12 minutes that we know he's trapped in what turns out to be his coffin. Let's talk about her testimony at trial. And we'll talk about all the problems. A lot of her issues predated her relationship with Mr. Torres. So it's not attributable to the trauma from Mr. Torres with all the luggage she brought into the relationship.
He said
And
luggage
listen to the way she
intentionally.
talks. It's not splitting the bills. It's helping without argument. It's not cleaning up and doing Sunday chores. It's cleaning up so we can relax. It's a reward. She talks about him like he's a child. I need to lead him to the next activity from one to the other. And then you saw the videos, and I'm not going to belabor it, that we showed in Rebuttal, but the relationship and the power dynamics speak for itself. He was treated like the third dog. And it might very well have been a dog that bit and was violent, but he was treated like a dog. Why are you leaning against my door? Get out of here. Go downstairs. You're worthless. You're garbage. They showed the part of the video where he slaps the phone, but that's after 5 or 6 minutes of being berated and dehumanized in a way that nobody should be treated. He just wanted to get in bed and lay down next to his fiancée.
Up against the wall.
Instead, get away from the side of my door, you useless dog. I thought it might be a good point in time to listen to the music. You know, when does Mr. Torres get to decide what to do? I mean, she paints this picture that he goes off and does all these things on his own, goes and buys wine when he's not supposed to, does all these things when he's not supposed to, but when does he get to do what he wants? Suitcase downstairs for a week so they can donate it.
His suitcase.
What was in their lives that was preventing them from getting that suitcase to the Goodwill or whatever? Neither one of them worked. What's going on? Lucas is over there on Mondays and Tuesdays. The story about the suitcase having already been down there is quite suspect, and we will get into that more. But again, it's not we went on a trip together, we had a great time. It's, I quote unquote, I recently took him on a trip.
That's what she said.
Then it comes down to the moment of truth, which we've already gone over. And it's just quite frankly inconsistent because she doesn't, there's no explanation for the picture. Her explanation at trial when I brought it up to her was, I just don't remember. I don't remember this period in time from the picture at 11:03 to when I was supposed to be coming down the stairs. There's a major glitch in her matrix. She shakes the suitcase. Please stop doing this to me. And then his hand gets out. Now she's the point in time when she gets angry and doesn't do what the law requires after basically choking him with his coffin. Beats him into submission with the bat and turns it back over. For the first time ever at trial, she says, I'm going to fucking end you, is what he said. She never told that to even her doctors. We've heard the arguments why she didn't tell the truth to the police and all that. And there's a lot of truth into the argument that was made. There's a lot of truth. When the argument is made that she didn't understand self-defense, what that means, what it comes across as, she makes this story change as she learns about it.
It's a good use of the defense's argument.
When we apply the jury instructions to her statement, all 6 of them apply against her.
Her story changes as she learns about it.
Won't belabor this since it was discussed earlier, but did the witness have an opportunity to see and know the things about which the witness testified? Even at trial, she admitted that she was intoxicated for the first time. She went back and forth with the police about whether or not she was intoxicated and her standard of drunkenness and whatnot, but she was so intoxicated that she still felt the effects of it at 1 in the afternoon the following day. The medical examiner told you that alcohol dissipates in the average person. Everybody's different. Tolerance, all sorts of things come into play. But on average, 0.015 grams per deciliter will dissipate every hour. So you can do the math. 0.015 times 14 puts her at 2.5 times the legal limit. For those reasons alone, you should not believe anything she told you. You should not believe anything she told the police. You should not believe anything she told the doctors. She was at 2.5 times the legal limit. She has a gap in her memory that's unexplained when I brought up the photograph at 11:03. You can't have it both ways. I don't remember 11:03 to 11:12, but I was upstairs in the shower hiding.
And then he said
Does the witness seem to have an accurate memory? Well, this ties into what we're talking about. But again, There's a glitch in the matrix, 1103 to 1112. Her memory is not accurate. By her own admission, I don't remember. She tells the police when they show her the video, I don't remember that happening. Was the witness honest and straightforward in answering the attorney's questions? I submit when we got off script, and by we I mean both, with both attorneys, she wasn't as honest and straightforward as when it was a very directed and smooth examination. I came out of the gate with something that was off script. Tell me about Pamela Erickson. Tell me about Christine. Tell me about Crystal. Because she's the one that said cheating to her meant pornography. Well, ladies and gentlemen, you know, she knew exactly who those people were, and that she believed that he was cheating on them with her. And apparently she is too, with some guy named Ben. That when I describe this as a violent, nonsensical relationship, that's exactly what it is. It's not to downplay the violence. She got stabbed. She had minor surgery. It got infected. Those injuries are real. But they just don't apply in this case. They just don't apply when you use that self-defense instruction when she's the aggressor, if it's to be believed.
Judge, I object.
Approach. Okay. Well, we have an objection from the defense, and they are approaching. We have 4 seconds of Zoom Room because I paused at the Star Wars reference. If you have not seen the Eddie Izzard comedy sketch of Death Star Cantina, you should watch it after this stream. But he talks about the head of catering on the Death Star, you know, Jeff Vader. So if you've not watched Death Star Cantina, it is, in my opinion, hilarious. So, you know, Jeff Vader, head of catering. So we're in the middle of the rebuttal. I am not quite sure what they are objecting to at this point. But it's been 9 hours of court today, so...
Okay, proceed. Objection's overruled.
And it's overruled. Mr. Stevenson. Sorry, Jeff Vader is the boss. Mr. Stevenson's head of catering. I totally messed it up. That's right. Mr. Stevenson, head of catering, who did not get force choked for being a poor employee. Thank you, Chad. It's been a long time. Death Star Cantina.
Does not have any effect on this case. It has no relationship to this case because she is the aggressor. She zipped him shut in the suitcase. After he said, I couldn't breathe, she wouldn't let him out. Therefore, all of the instructions above that paragraph of however do not apply. They do not apply. Now, turning back to what I was saying.
I think that's why the defense objected. I think the defense probably objected because they're saying it doesn't apply. And the defense, I wonder if, argued, but there is a battered spouse defense, so the background does matter as it goes to the battered spouse defense. And they're like, no, we're allowed to cover this.
Did the witness have some interest in how the case would be decided? Well, of course. 3 out of 4 panels that y'all came from indicated to the judge fear of punishment was more important than the fear of public speaking. It speaks for itself. She has an interest in the outcome of the case. Now let's talk about, does her testimony agree with the other evidence in the case? You do not have to accept this story. Let's pretend, as you should, because all 6 of these things, we haven't even gotten to the inconsistent statements. Let's pretend her testimony doesn't exist, and you just have to look at the circumstances. The testimony from the defendant is Jorge Torres' head is here.
Oh, dear.
You can stand if you need. You've been sitting a long time, too.
They just told the jury you can stand if you need to. He's like, take a stretch break.
His butt is kind of down here. His feet are here. And his hands and his knees are up here. He's in the fetal position, if we remember right. The hematoma on his head is on the left side.
Sarah showed the
bruises,
jury.
the deep bruises on his back are on his left side.
Yikes.
That's, you hear that? That's solid. You don't have to accept that she put those marks on him when he was in there. The evidence doesn't support it. You can conclude she used his bat when he was outside the suitcase.
I withdraw my idea.
You don't have to believe her when she said they were playing hide and seek. You don't have to believe her because she doesn't know the rules. She came downstairs, saw what she had done, and had all the opportunity in the world to clean up whatever mess may have been at the bottom of the stairs. But ladies and gentlemen, physics doesn't lie.
That was a good demonstration.
Can't expect you to believe her testimony about the loud boom being the day before compared to her two neighbors who weren't drinking, who have no interest in the outcome of the case, who suffer from none of the infirmities of her testimony. She suffers from all 6 infirmities. When her neighbors say there was a loud boom that night, there was a loud boom that night. Did it shake the wall they shared in common? It shook the wall that they shared in common. Did she have any injuries consistent with being dragged up and down the stairs the night before? No. You saw the pictures the CSI took. You don't have to accept her story about hide and seek. Something made that loud boom. It takes energy to make a loud boom. Energy that could very well be in the form of somebody going down some of the stairs, all the stairs, in the suitcase, out of the suitcase. But that's what the evidence supports, is there was a loud boom that shook the walls and interrupted a FaceTime conversation that was so loud that the girlfriend on the other end heard it. Something loud happened. And then there was silence, according to the witnesses. And they can argue that Juan Torres' testimony was great for them. It's great for the state. She was screaming at him already at 7:30 p.m. She was already on her bully pulpit. And we know she doesn't need to put him into the coffin to get on her bully pulpit. There's video after video of her on her bully pulpit telling him how it's going to be, how you're going to live your life. Go take a walk. Do this. Do that. You don't have to accept anything she said. It's inconsistent that he received the hematoma to his head, his bloody mouth. How is his mouth getting bloodied inside the suitcase? That's protected from her and her bat. But that suitcase, a 100-pound drunk woman is not beating through the wood of that suitcase or whatever it is that's making that noise when it's thumped. Ladies and gentlemen, those injuries happen outside of the suitcase. Ladies and gentlemen, somebody or something went down those stairs. She has no injuries consistent with going down the stairs. He does. He has blunt force trauma all over him. You don't have to buy her story, and you shouldn't. The inconsistencies, I'm not going to belabor it. Your dinner is waiting in back. Let's just briefly talk about the experts.
Okay,
and we'll move
Mr.
on
J.
to the end. Dr. Brandon was absolutely fantastic.
I'm not going to belabor it. Your
He
dinner's waiting
explained
in the
everything
back.
that you all needed to know about battered spouse syndrome. And this isn't about whether one of them or both of them had battered spouse, because at the end of the day, she's the initial aggressor, and she had the duty to do the things that the law requires. But it does call into question the credibility of the past power dynamics of their relationship. Those videos speak for themselves. The officer in the last video asks him, dude, you're a guy. Why don't you do something about this woman, your wifey, who you don't want to rat on for beating you? It's like, man, I'm not a beefcake. I'm not going to rat her out.
This is his conversation with police that he's
There's
referencing.
countless examples, if you apply Dr. Brandon's testimony to Juan Torres, that really shows you the power dynamics of the relationship. He was her violent pet. Dr. Harper, I don't find much quarrel with what she says about battered spouse syndrome, and nobody should. I mean, she's the expert. But she's not Ms. Boone's treating physician. She's not her treating psychologist. The way it was described in argument, and I believe from Dr. Brandon's testimony, was she's supposed to be a forensic detective. Get to the bottom of this. She's going to come in here at trial and tell you her opinion you should rely upon. With 9 visits, she never asked the defendant what it is the victim said that put you in imminent fear of death or great bodily harm.
That's a good rebuttal.
That's the crux of the matter, Doc.
Good rebuttal. That's a good rebuttal.
You're never going to ask her what it is he said or did for this grand jury instruction about threat of force or use of force? It's remarkable. And, you know, she didn't review everything that was presented to you. At the end of the day, it's your opinion that matters about this relationship. And again, we agree with Dr. Werner. It doesn't matter. She had the duty to retreat. She had the duty to take the chokehold off. And if it was too dangerous for her to directly take the chokehold off, she had the duty to do something else, everything in her power, to stop him from dying because she started it. She set it in motion. She used the force grip on him from a distance, the couch and from bed. It was her obligation to stop. She didn't. But Dr. Werner, she was called by the state of Florida after having evaluated and listened to the defendant give a similar story and concluded battered spouse doesn't apply. So she was never asked to delve any deeper into it. Given the information that she did have, the limited information, she agrees. Yes, Ms. Boone has battered spouse syndrome, but it doesn't apply to the case because she was the aggressor and she did not fulfill her obligations. And really just your gut common sense. Go back to jury selection. In jury selection, there was examples about bullies day after day doing something to somebody. And somebody raised their hand and said, don't they have to do something that day? Don't they have to do something that day? And he didn't. After he was put in fear of death and told her he can't breathe, the imminent threat of great bodily harm and death she is describing to you is him fighting for his life to escape. She did not fulfill her obligations. There's details that matter. And again, it's not to belabor it. I mean, the evidence in the body-worn camera and the 911 calls, it's not offered to prove the truth of the matter as who stated what. Who knows what happened between these two? You see them with the police. Can't believe anything they're saying. It's not offered to prove that she's a bad person. It's not offered to prove that Mr. Torres is a bad person. It's simply offered to call in question the reliability and credibility of what she said about the past. That's all that it's there for. But there are some nuggets and some Easter eggs.
Back to the movie references.
There was an argument made during closings that Mr. Torres knows not to do anything when being videotaped. Bizarrely, shortly thereafter, they showed a very edited clip of him attacking her and slapping the phone out of her hands. He knows he was being videotaped, and there was another video like it too. So to make the argument that he doesn't do anything, he's a good boy when he's being videotaped, it's belied by their own argument. They showed one of the videos. Learned helplessness. She seemed to control everything. I mean, his birth certificate, it gets torn up when he doesn't comply with her wishes. You'll see the rest of the text messages if you choose to delve into them. But I would suggest you don't have to, given the jury instruction about aggressor. Ladies and gentlemen, this has been a long 2 weeks, and you are making a very, very important decision for Ms. Boone, and a very, very important decision for Mr. Torres and the state of Florida and his family. He's dead. She killed him. She's admitting she killed him to have this affirmative defense if I was justified. It was not justified under our law. She does not get to decide that she has a license to kill because of her past grievances. The law requires her to stop using the force that she started applying to him. And she didn't. She didn't withdraw. She didn't tell him he was withdrawing. She didn't use every means available to try and stop this from happening. She didn't. And you know what was in her heart. She tells you. It's
She's
hatred.
mad.
ill will, spite, and venom. This is not a self-defense case under the law. Go back and follow the law. You cannot feel sorry for her. You cannot feel sorry for him. You cannot feel angry at her. You cannot feel angry at him. It's maddening to see their relationship. It is maddening. Nobody would want this life for yourselves or your children. It is violent nonsense, but it does not affect what she did and what her duties were under the law that night. She wanted to punish him. She did, and then she left him there. And she had an obligation, if you even believe her story about the imminent threat for him fighting for his life, she had an obligation to do something about it and not just go upstairs and let him suffocate. Thank you.
And the rebuttal is done at 6:58
Thank you both.
local time.
Members of the jury, I have some additional instructions to read to you.
Now the final
You
instructions
would
for
be so
charging.
kind to turn to page 21 of 22. Instruction 3.12, verdict. You may find the defendant guilty as charged or guilty of such lesser included crime as the evidence may justify.
Now that the judge is on
or
mic, I'm going to
not
turn
guilty.
that down a little.
If you return a verdict of guilty, it should
That's
be
better.
for the highest offense on the verdict form that has been proven, beyond a reasonable doubt. If you find that no offense has been proven beyond a reasonable doubt, then, of course, your verdict must be not guilty. The verdict must be unanimous. That is, all of you must agree to the same verdict. Only one verdict may be returned as to the crime charged. The verdict must be in writing, and for your convenience, the necessary verdict form has been prepared for you. It is as follows. If you're looking for it, you don't have it. I do. That's why we only have one. The verdict form reads, in the Circuit Court of the 9th Judicial Circuit in and for Orange County, Florida, case number 48-2020-CF-00260-3-0, State of Florida Plaintiff versus Sarah Boone Defendant. Verdict. We, the jury, find the defendant guilty of murder in the second degree as charged in the information. We, the jury, find the defendant guilty of the lesser included offense of manslaughter. We, the jury, find the defendant guilty of the lesser included offense of culpable negligence. We, the jury, find the defendant not guilty. So say we all, dated at Orlando, Orange County, Florida, on this blank day of blank, 2024,
On this
signed,
blank day of blank.
foreperson.
You have time to deliberate today.
Final
You might be back
instruction, members of
Monday.
the jury, page 22. Instruction 3.13, submitting case to jury. In just a few moments, you will be taken to the jury room by the court
For
deputy.
dinner. For your
First
dinner.
thing you should do is choose a foreperson who will preside over your deliberations. The foreperson should see to it that your discussions are carried on in an organized way and that everyone has a fair chance to be heard. It is also the foreperson's job to sign and date the verdict form when all of you have agreed on a verdict and to bring the verdict form back to the courtroom when you return. During deliberations, jurors must communicate about the case only with one another and only when all jurors are present in the jury room. If a juror goes to the restroom, the deliberations should stop until the juror returns. You are not to communicate with any person outside the jury about this case. Until you have reached a verdict, you must not talk about this case in person or through the telephone, writing, or electronic communication, such as an email or any other means. Do not contact anyone to assist you during deliberations. These communications rules apply until I discharge you at the end of the case. If you become aware of any violation of these instructions or any other instruction I have given in this case, you must tell me by giving a note to the court deputy. Many of you may have cell phones,
You have questions?
tablets,
Ask me.
laptops, or other electronic devices here in the courtroom. The rules do not allow you to bring your phones or any of those types of electronic devices into the jury room. Kindly leave those devices on your seats where they will be guarded by the court deputy while you deliberate. If you need to communicate with me, send a note through the court deputy. If you have voted, do not disclose the actual vote in the note. If you have a question, I will talk with the attorneys before I answer, so it may take some time. You may continue your deliberations while you wait for my answer. I will answer any questions, if I can, in writing or orally here in open court.
I like the way that instruction is
During the
written.
trial, items were received into evidence as exhibits.
It's really clear.
You may examine whatever exhibits you think will help you in your deliberations. All exhibits, with the exception of Exhibit 10, which purports to be a wooden baseball bat, will be sent into the jury room with you when you begin to deliberate. If you wish to see Exhibit 10, which purports to be a wooden baseball bat, please request that in writing. In closing, let me remind you that it is important that you follow the law spelled out in these instructions in deciding your verdict. There are no other laws that apply in this case. Even if you do not like the laws that must be applied, you must use them. For more than 2 centuries, we have lived by the Constitution and the law. No juror has the right to violate the rules we all share. The parties approach.
All right, that is the final charge to the jury. They have not been excused yet, but they will be excused shortly. Don't forget to go and do the YouTube-y things. Don't forget we will be starting a new stream for Verdict Watch. If there is a jury limit, if there is a...
Members of our jury, I want to take a moment and thank you for your time, your service, and your participation in this very important process. As I said to you last week, be it Monday or Tuesday, and maybe even on Wednesday, without your sacrifice and your service, the wheels of justice would simply come to a screeching halt. And on behalf of myself, the state, the defense, and Ms. Boone, we thank you for that sacrifice. With that, jurors wearing badge 295-9569,
he's telling them who deliberates.
130, 249, and 448,
They just
110.
picked deliberating 6.
You successfully served as our alternate jurors in this trial. I wish I could give you more than my thanks and a hot meal that's waiting for you, but I do thank you for your service and your sacrifice. Courtroom deputy is going to take you out at this time so you can collect your meal, and I'll meet you back there momentarily to give you your jury certificates. Thank you for your service.
Alternates are being excused, and deliberating 6 will go
The rest
back.
of y'all, if I didn't call your badge, you need to hang out.
So now they know who's deliberating, who's not. There were 8 alternates, 6 deliberating jurors per the rules in Florida. So they are being sent out to deliberate at 7:05 local time. The court has said they could work till after 10 p.m. if they need to.
That will be deliberating in this case. I thank you again for your time and your service. The exhibits will be brought back to you momentarily, and a meal is waiting for you. We will work till approximately 10 o'clock tonight if you do not render a verdict before then.
Then we'll come in on
And I
Monday.
thank you again for your time and your service. I'm going to ask the courtroom deputy to go ahead and take you back now to the deliberation room.
Generally, the alternates do not know they're alternates until that moment, which I imagine is a little heartbreaking. Because then you're like, no. I think the reason they're excusing the alternates is because everybody thinks this.
You can bring your phone with you. There's a basket that the deputy will take. And
Everyone
collect for
thinks
you.
they'll
Thank
have
you.
a verdict tonight, and the lawyers agreed. That's why they're letting and it's late on a Friday. That's why they're letting the alternates go. They think these 6 will be solid, and the jury's had no issues. They've been there. They've been on time. They've been, by all accounts, really attentive. They haven't had even a hiccup, and they gave them a 3-week estimate, and it looks like they're going to be done in 2, including jury selection.
You all can be seated.
You
Thank you
count
very
the 4
much.
days of jury selection. They've been.
May I raise something real quickly? Did you intend for the jurors to take the notes into the deliberation rooms?
Yes.
Okay, I would object to that on the grounds that it allows one juror to potentially assert that their notes are better than others as opposed to just relying on their memory.
Now you're objecting to them taking their notes back to the jury room? This is coming up now? Counsel? Seriously?
Any response, State?
That's not the law.
There's a verdict form there's an instruction that I read specifically on that, sir, that no one juror's notes should trump another juror's notes or
That's
their
not the
memory.
law.
So your objection is overruled.
Sir, do you even
Mr.
go
J
here?
and
Aren't you the lawyer from New Mexico? Sit down.
Mr. Cacciatore, do you have the clean laptop for the review by the defense? While we're putting that together, can both the state and the defense review all exhibits that were entered into evidence and confirm they are what they purport to be, so that all exhibits that were entered, with the exception of Exhibit 10, the bat, would be sent back to our jury?
Everything but the bat will go back to the jury?
Yes, please.
Y'all remember, we will start up a new stream. It's not going to have a time on it. Mingolina, if you want to go populate that so we can direct the chat over there. We will have members only chat on so you guys can monitor the stream for verdict watch. But you guys, he's going to excuse the alternates and be back. Law nerds, I think it's time to officially say. We're on verdict watch. So I will be monitoring the feeds for a verdict. We will be doing that in a separate stream. This stream will probably tap out at about 10 hours, I'm told. YouTube allows 12, but apparently our streaming software allows 10. So we're now working against the clock. But we will be, we'll see what happens. But the court went to excuse the alternates, and then we will see if they come back on the record for anything. While the judge is out of the courtroom, I'm going to leave, we'll make this a little bit bigger. I'll leave the courtroom up, and we will see if we can do a quick summary here of court. So we'll just leave that. We'll just leave that down there. I have no idea. There's like one. There we go. We'll just leave that down there for now, and we'll do a quick summary of closing arguments as best we can while we wait for the court to come back. And we are at the end of the state versus Sarah Boone, the end of a very long day 6. The jury got excused at about 7 o'clock local time in Florida to begin their, dinner and deliberations. After closing arguments, I think, the poll in the chat has said that the prosecution was more persuasive, over 97%, with, at this time, over 7,000 votes in the live stream chat. The prosecution gave a closing argument to narrow down the jury focus, telling them which jury instructions they could discount entirely, which jury instructions to focus on, and reminding the jury that what happened on this day is what they need to focus on. Was Sarah the one provoking Jorge Torres? Was Sarah the one that was going after him that day? Sarah zipped him into the suitcase and left him there. In the very beginning of opening statement, the prosecution brought out the suitcase, put it on the floor, and said, this is a box, and then went through that this is the box where Jorge Torres was murdered, and went through the videos, went through some of the more difficult videos, and at one point, Torres's family member had to leave the courtroom because of that video. Later, the defense objected and said there should be a mistrial based on that family member having to be excused. The court denied that as quickly as I've seen him deny anything in this case. Then we got to the defense's closing argument, where it seemed that Owens was going with, I'm just a simple country lawyer, and said repeatedly to the jury, I might not get this right, but I hope that I did, almost leaning on them to pick his side and to fill in the gaps of his argument. I think he could have used the jury instructions more to his advantage, but he did say that the reason you don't see videos of Jorge Torres being aggressive towards Sarah is because he didn't do things while she was filming. But then in rebuttal, the prosecution said, yes, but then they're playing clips saying he's supposedly violent in these clips that they're showing that are edited down. I think the rebuttal was helpful. I think the prosecution's closing was much more linear. The defense had moments, but will those moments resonate with the jury because of how lost they got in the defense getting lost in their own closing? It was not as smooth and linear, even though he said things like, Sarah Boone was acting out of a brain that was changed by trauma and was trying to explain battered spouse. But then he also went a pretty far way to say that Jorge Torres was a monster. So will that be persuasive to the jury, and will they be back tonight? I guess we will see. We're going to go to questions. Dr. B is standing there staring at me while I'm trying to do my wrap up. Hi, Dr. B. Let me go to questions. We're on jury watch. Okay.
Okay.
Have a good night.
Yep.
I will see you in a little bit. Have fun.
Good.
Bye.
Been fed?
Okay.
He's good.
We're on verdict watch, so I will be hopefully out in a minute, and I'll see you in a bit. Okay. All right. Bye, hun. Have fun. Dr. B is going to a concert. So with all of that, they did send all of the evidence back except for the bat. Why? Well, because the bat is technically a weapon. So that is why. So Dr. B came to let me know he was taken off and everybody's handled. So y'all, I've seen some of you ask, what kind of doctor is Dr. B? Dr. B is a maxillofacial prosthodontist. It is a dental specialist. And that. So, okay, Miguelina, thank you. That works. Perfect. Thank you. Miguelina said, our stream won't cut off. Just the recording part will cut off. That's perfect. So the law students, it seems, are walking around within view of the camera. We're going to see if anybody comes back out. Look, I have had a jury where they didn't even get the exhibits back and had a verdict. They went back in, they took an initial vote, and they were like, 4-person verdict, 5 minutes, done. So Catherine said, will the benchies stay for the verdict? I would. I mean, you've already been there all night. I would grab a sandwich or a Snickers and hang out. Look, sometimes justice just runs on caffeine and sugar in a dream. I don't think it's healthy. I'm sure other lawyers have found out how to do it better. You guys asked if they will eat then vote. I imagine the jury will want a minute to talk to each other. And we're going to go back on the record.
2020 CF 2603, State of Florida versus the record. Defense.
James Owens from Miss Boone.
I have the parties had the opportunity to review and inspect all the evidence to be sent back with the jury.
The defense has as best as I could.
Okay.
Yeah, I didn't keep a tally, so I trust the clerk's numbering system.
Madam Clerk is the best, so I have no doubts that everything is included. State, had the opportunity to review it?
Mr. Cacciatore was the person who did that, so I think so.
Okay, all right. And with regard to the laptop, has it been inspected?
Yes. Yes.
All right. Okay, so we'll send the exhibits back with the exception of Exhibit 10, the bat, and the clean laptop to our jury. Ms. Boone, I've got a couple of questions to go over with you again, ma'am, if I could. Ma'am, you were sworn previously this morning. You've been present throughout the entire trial, starting last week through today. You've been seated next to your lawyers at counsel's table. You've had the opportunity to observe the opening statements, the direct examination and cross-examination of all the state's witnesses, the direct examination and cross-examination of all the defense witnesses, and the opening or the closing statements as well that were presented by both sides. You've also had the opportunity to observe all of the exhibits that were presented as evidence in this case. Are you satisfied with your lawyers up and until this point?
Absolutely.
And are you in agreement with the strategy utilized in your defense?
Yes.
The last issue that I need to address is the
closing?
state's request for in-camera hearing regarding financial arrangements between defendant and defense team.
Oh, we're back to that. We
State,
talked about that a couple days
what
ago.
is your concern?
State, what's the problem?
It's a very expensive defense, and she's indigent, and
Abundance of
there
caution?
are bar rules that limit the ways that things can be done. I don't know
How they're doing? How are they doing that,
none
Your
of my
Honor?
business unless it's raised in a 3850. So if there's an in-camera proceeding, I would ask to be sealed, and won't be any need to get into it unless there's a 3850 claim that there's a conflict of interest.
Is there anything other than concern or speculation that you have?
No.
Just things in passing that have been said and observed. It's a very expensive defense. That's my concern. I don't want her to be able to raise any arguments that, well, I would have pled if I had a conflict-free lawyer who did not want it to go to trial for his or her own reasons.
Okay. Mr. Owens, is there anything of concern that I need to be aware of in camera?
No, sir.
Mr. Henderson, same question to you, sir. Is there anything of concern that I need to be aware of in camera or otherwise?
No, sir.
Mr. Beck, same question for you. Is there anything of concern that I need to be aware of, be it here or in camera?
No, Your Honor.
Okay. All right.
Judge, and if you need to inquire from my client about whether or not she wanted to enter a plea or whether she wanted to go to trial, but, you know, we made it clear that it was her decision, not my decision to go to trial because I'm trying to gain some publicity or money or book deal or whatever. But that was her decision. There was some strong conversations we had about what was on the table.
I bet there were.
And Ms. Boone, as she has a right to, wanted a trial.
I bet she did. I believe,
Henderson and
I
Mr.
believe all of
Beck,
that.
would you agree with Mr. Owens' recitation as to none of the financial issues being book deals or anything on the table at this point in time?
Judge, yes, because I definitely don't know about it.
Okay.
Because
Mr. Beck,
He's
anything
like,
to add,
wait,
sir?
there's book deals? I want a book deal.
Your Honor, I believe this is attorney-client privilege information, but there are no concerns about comment.
I colloquied Mr. Owens, your client, before we picked a jury as to the offer in this case and whether or not she was ready and wanted to proceed to trial. And
She said
she
she did.
affirmed at that point in time that that's what she wanted to do. So I see no reason to inquire of that further. State, is there anything else we need to address? Defense, anything else?
That's
All right, please
All
give
right,
your
that's
cell
it.
phone numbers to Madam Clerk. We will be on verdict watch. And I thank you all for your hard work in this case. We're off the record.
Well, Your Honor, we couldn't love you anymore over here. And yes, we are on verdict watch. Are they going to, what are we talking? Hey, can we have the volume back on in court? I want to know what they're talking about. They're still talking. I just want to know what they're talking about. Come on. Oh, you guys, we're going to get to some questions. We will have a separate stream. We will have a separate stream up, but we're going to answer some questions now. I'm going to leave court up. Well, even if it's just the seal, I'll leave court up in a corner when we get there. But Miguelina, we're going to need to clip the judge saying we're on verdict watch. I don't know, what was that, 9:46 into the stream? 9:46-ish into the stream. We're gonna need to clip it with now we're on verdict watch. It makes me want to play our verdict watch bumper again. I gotta be honest. I kind of want to send it again. But before we do that, we are going to take a quick peek at where we're at on the stream, and then we're going to answer questions. So let me share my screen real quick. A number of you have asked where we're at. We're going to share where we're at because we can, and why not? This is where we're at on subscriber watch. Before we start verdict watch, we had to peek back in with subscriber watch. So we're getting close to 799 on the road to 800,000. So if you haven't already hit the subscribe button, go ahead. It is A, free, and B, really thrills my my kiddo, and the Law Nerd team Baker would very much appreciate it. I would too, as long as you've already downloaded the app. If you've downloaded the app, that's free. And you subscribing to the channel, also free. And when you subscribe to the channel, then you can chat because we're in subscribers mode, and that helps us out too. And then you get to watch the numbers go like that. You get to watch them just like that. And I appreciate it. We've been sitting here for like 9 hours today. So thank you for honoring me with your subscribe. We're going to get to some questions. Amelia said I'd subscribe again if I could. I think you have to 3 times. I don't think twice would work. I think twice will just unsubscribe you, and that's not helpful. There needs to be a bumper sound. Oh yeah, we're going to absolutely clip this judge. He's going on to the soundboard. Once they're onto the soundboard, it's a judge that we have very much liked because they are on the soundboard, and that is very much appreciated. So verdict watch, we will notify you in the app. We are going to set up a stream that is open-ended. Will it go live tonight? Only if there's a verdict after we end here. And if there is a verdict, then we will go live if we need to. So that is what the plan is for the evening. We're just going to keep an eye on court and see what they are going to do. So y'all, thank you for subscribing. And look, court's just doing that. We're just over here doing this. And thank you for all of you that are love watching the numbers go up. I appreciate it. We are definitely getting close. Look, we can just take a minute, take a stretch, and just we're almost there. Thank you, members. So, Scattered Sunshine, we'll talk about this in just a second. So, thanks, Law Nerds. Hey, look at us. It is fun. It is enjoyable to watch it go bang. So, thanks, Law Nerds. We're almost there. Thank you. Oh, It's been a long day, everybody. So thank you. We'll roll the we banged animation. Don't worry. Thank you, Lawnards. I appreciate it. All right, we'll check back on this in a minute. We will. I promise we will check back in on that in a little bit. But for now, we'll leave court up here in the bottom so we can see it. I need to share that a different way so we have audio if we need it. I would rather be prepared. We'll switch back to that in a minute, but I would rather be prepared for audio if the court comes back on the record unexpectedly. That I would like to be prepared for. You know, we're trying to prepare. Scattered Sunshine, how am I liking the Remarkable? I have been using the Remarkable Pro for this trial. I've used the Remarkable 2 in other trials. I'm not sure yet. I will give you guys a breakdown and keep you posted in wherever, in another stream in the member space. The Remarkable Pro is heavier. I don't know how much I use the fact that it has a color screen and it is a little bit bigger. So on my desk, that makes it a little more awkward. So for me, I'm not sure which one I'll prefer for trial just because it is a little bit heavier and a little bit bigger. But if you are always using it on the desk, I think that's maybe a different use case. I don't know how much having it have a colorful screen matters to me yet, but we'll see. I'm going to keep trying both and let you know. The other one is lighter weight. Miguelina, let me see. Let's see. I put the stream for it not to be. Yes, we'll just go live. Yes. So that works. That's perfect. Thank you, Miguelina. So the team is getting ready for our other stream. So this one can redirect when I end. So it'll redirect over there and we'll see. I mean, Judge K's just like bopping around on the bench. So we're going to watch. Let me put this up at the top of the screen so that we can pull up super chats and see if the judge is bopping around. Because again, why not? EDB, we need a poll for jury verdict to find out how long we think it will take for them to come back. I will put a poll up in this chat, and then I'll go put a poll up in the new chat. Chat, what do you think the options should be? You guys let me know in the chat real quick what you think the options should be. I'm going to stop this poll on closing arguments. With over 10,000 votes, 97% of you think that the prosecution's closing were more persuasive. So there is that. I will put up a poll. I think the jury, keep in mind, the jury has not gotten to talk to each other about this case at all, and they have dinner. So they might really want to have dinner and get to chat with each other about the case a little bit before rushing through it. So let's put up some poll options. I'm going to go with under an hour, I think. How long till we have a verdict? Let's see. We got to go with under an hour, right? Under an hour. 2 to 3 hours tonight. Before 10 p.m. tonight. And we'll go with Monday, which seems like the outside option to me. All right. How long do we have a verdict? Under an hour, 2 to 3 hours before 10 o'clock tonight and Monday. So let's go with that. And let's see. Oh, I should have said how's long till we have a verdict. No, actually, this case is, well, all things considered, this case is run fairly smoothly. We've had moments of hiccup and they still got to the verdict tonight. But part of that is because of the dedication of this jury. They have worked such long days. Have you felt like they're long days? I felt like they're long days. They have had very long days. The court reporter must be absolutely exhausted. Days, just long days. Get Knit Faced said my kids' high school marching band made semis again. Last time was 2013 when my kids marched. Go Doherty Spartans. Congratulations on making semifinals. It is indeed Bandtober. Holly gifted 5 EDB memberships. Thank you so much. Taylor said, tempted to take hubby's phone to give EDB another sub. I appreciate it. You don't have to sub on multiple devices, but if you choose to, then we'll do it. Emily, 3 hours is 10 p.m. Oh, well, that's right. All right. I should have said 2 hours. That's a fail. Look, we tried. In that 2 to 3 hour range, and then like right at this squeaker, like right at 10 p.m. We'll go with it that way. Silky Mom said, I've enjoyed my Remarkable. I'm conflicted for the pro. I would think about use case and I would think about whether or not the bigger version or heavier version will work. And then I would watch some of the tech YouTubers that will be comparing both, and I will keep you up to date. But when I say it is a larger tablet, this is not sponsored by Remarkable. Someday it probably should be, but at the moment it is not. The size difference is a noticeable size difference, and it is heavier. So those are considerations that you need to take into account how you use it. And if the difference in having a color screen matters, the screen's also a little more slippery. But I do like the Remarkable, for me, better than writing on an iPad. I find the iPad too slick, even with one of the like paper-like covers on it. I still find it too slick to write on. So I find the Remarkable screen comfy to write on. I'm sure other e-ink writers have a similar screen. I haven't used any of them. The Law Nerd Chat heavily recommended this one, and that is what I got. So I wish I had one when I was in court. They're pretty great. So fantastic to see you gain so many subscribers. Apparent Plastic, thank you so much. I appreciate it. I am very excited, but I am also excited for the amount of new law nerds in the chat, because you guys are amazing and we have a very generous community. So for those of you that have wanted to be members, so you don't have slow mode, and you can see the members only videos, but so you don't have slow mode, and so you get the free members only chats. That's fantastic, because these are members chats. Kudos to Judge Kay and staff for a well-run trial. I think the courtroom really, really did a fantastic job running this trial. I imagine the jury's heads are swimming, right? I mean, I think they would. Don't you think? Let's see. His respectfully counselor dad voice needs to get clipped. It kind of scared me when he yelled out, like when he yelled at the person whose phone went off and he was like, "Get out." I was like, holy shit. Don't piss off the judge. Don't piss off the judge. Don't piss off the judge. Because holy shit, it is getting warm in my office. It's just because I've been sitting here for 9 hours. Let's see. I'm gonna fan, please. I don't have the Force. I can't. I am not a Jedi. Thank you. All right. I just have a remote control. Mo in Deep End and Broken Baker were talking about the book deal chances last night, I think. Interesting. I don't know if anybody would want these attorneys to have a book deal. Do you? I mean, I don't know. I don't know if it's that type of a case. I don't know if it's that type of a case that anybody would just be like, let's see. Music to My Soul said, does the claim that Sarah Boone doesn't remember undermine the prosecution? No. Do we know about her zipping the suitcase and going upstairs to sleep only from her? There was no one else in the apartment, and on video he's in the suitcase, and everyone has kind of corroborated that there was no one else in the apartment, and she didn't let him out. So if she didn't go upstairs and she slept on the couch, I don't know if that makes a ton of difference, but no, I don't think at this point it undermines the prosecution, because there was nobody else there and there's no evidence that there's anybody else there. And I don't think there's been evidence that there was anybody else there. So that part I think is consistent. Christine, thank you, EDB and mods. I know the mod squad has hopefully been taking adequate breaks, mods, and has been making sure that they are taking care of themselves, because it is a long day. Lauren, thank you for the 5 gifted memberships. Much appreciated. And you guys, thank you for all the member chats. I know I'm not going to get through all of them tonight. I know that I won't, but we'll see. KD said, my palms are sweaty, knees weak, arms spaghetti vomit on my sweater already. So all the things. DW said palate cleanser for the law nerds. My mom has a black kick. I can't even say that word at this moment. Munchkin cat named Dwarf Vader. And yes, he uses the Force. Kinkalau, I think. I don't know. This is my knowledge of cat breeds. Right now we have orange ones. We go cat by color. Previously there was a gray one. So that is my knowledge. It's not Taylor Swift level cat breed knowledge for sure. Natasha said, how bold is it to introduce this new theory of George's death? I'm feeling like it's very daring. I think you're talking about the prosecution arguing that she could have hit him with the bat when he was outside the suitcase. I don't know if that's a new theory. But it is an explanation for his injuries. And when he was tapping on the side of the suitcase is hard-sided. I mean, really, actually hard. When he was banging on it, you could hear it, but you also got a sense for that when he was dropping it on the ground in the well, you could hear it. Happy at Heart asked the question that many have asked throughout the stream, and we will break it down one more time. Happily. The second-degree murder carries a term with a floor of 22 and a half years to a maximum of life. The judge picks that range. The manslaughter carries 15 years. My brain just buffered. And then the negligent third cause of action is a misdemeanor. So maximum 1 year in custody and maximum fine. Normally those are a couple $1,000s. So that is where we're at. So 2 felonies and a misdemeanor. What I did appreciate is in the prosecution's closing, the way that they talked about the murder being like the top charge, you really got a indication of how the prosecution was like, this is the charge that we're looking for. I don't even want you to worry about him. It's a second-degree murder. And then really saying, okay, fine, you've got the second-degree murder and then these other charges, they are less than the second-degree murder. So if you think that she did this and walked away, that is a second-degree murder. Because the defense, I don't think, did a great job arguing that she didn't appreciate the danger. I don't think the defense really hammered that home. But again, the video is George saying, Sarah, I can't breathe. And so it is hard to do. The Caliente said this is a great rebuttal. He had a great rebuttal. I'm sat, y'all. I mean, I was locked in too. It was a great rebuttal. It was linear. It had energy, but it was not overdone. I really thought the prosecution brought the arguments. I've been critical of them at times during the case, but it's easy to sit here and commentate. I'm not the one who's not sleeping because I'm in trial. So I think the prosecution really brought their best foot forward on closing. I thought their opening was strong, but I think they really brought their best foot forward on closing. Elizabeth said that thumping noise hit me so hard. It was chilling. It definitely was impactful. So it was. Darlene Danielle said, how many lawyers will now cite Star Wars in closing? I'm sure it happens already. Movie references work well depending on your jury. Like pop culture references help make the point, and it's something that a lot of us have in common. Richard Huffman said, so we had a Chewbacca defense and now we just witnessed the Darth Vader prosecution. I think that's what happened. Kate said Mr. J, but in Harley Quinn's voice. Lisa said, necktie forgiven. This lawyer is compelling. It was a good argument. Absolutely a good argument. How much are the jury retaining at this point? I have no idea. They are probably exhausted. I know I am. I'm sure you are. No time limits for closing arguments. Not enough at this point. Rebecca Fitzgerald. This is... She could have pled the Sith. The case always needs a little humor. And I appreciate that one. The defendant should have pled the Sith in this case, because what do we see in a lot of the prosecutions that we watch on this channel? The best witness is often the defendant themselves. So Murdaugh absolutely got himself convicted with his testimony. The video of Hannah Gutierrez is a substantial part of what got her convicted. I mean, Murdaugh's voice on the Bubba video as well. And the police interview in these videos by Sarah Boone is absolutely what's going to do it. So yes, it's all that self-snitching, chat. It's 100% that self-snitching. That self-snitching is not going to get you anywhere good. The use of one's words against themselves can be incredibly, incredibly compelling. So chat, we're gonna give you a counter, because I know otherwise Octo is gonna come into the chat and be like, Emily, you have not given them an update on where we are. This is the update. Thank you, chat. Thank you. We are over 799,000. I very much appreciate you. We got 99 problems. Ugh. Can we quote Jay-Z anymore? He's really close with Diddy. I don't know if we can. I don't know if we can. Ironically, Sarah's child is named Luke. Well, Lucas, yes. Lucas is Chad was like, I can 100% imagine Vader saying, Sarah, I am your father, or Sarah saying, Luke, I am your mother. I am your mother. All right. The Sith would like to be excluded from this. The Sith are like, stop it. Oh, the Star Wars jokes. I missed all of these earlier. Crazy Cat Queen. Did the Empire really have an HR department? I mean, not abiding by the laws of this universe, but they might have if we're to learn from Phineas and Ferb. Didn't they talk about the HR for the stormtroopers? I mean, they obviously don't put them through like weapons testing and testing and weapons training because they can't hit anything when they shoot. But, you know, maybe. He's not wrong though, said Richard. Oh, chat. I was not expecting a Sarah is Darth Vader argument. Yeah, the force choke argument, I mean, you could it's a lot of use of force and talking about using force. So it is quite a lot. Chris in Chicago said Sarah is never at a loss for words. Yet George was smashing the TV with a bat. Sarah was speechless. I don't buy it. She staged videos to her advantage. It felt the video, first of all, the TV smashing video, he was completely out of breath and the defense kept ending it before showing him out of breath. But it looked more like somebody who was at one of those smash rooms where they're like, oh, we get to smash like broken, appliances and cars and whatever with things. It looked more like that to me. It was a very odd video. So yeah, I don't know how impactful it will be to the jury. So we'll see. Thank you again for the gifted memberships. And Kitchen Clock said I was on a jury last month and we found him guilty. We would have had to determine punishment. I'm glad they had no evidence. Fun fact, also a 6-person jury in Texas. So it depends really on where you are and on how they do it. Here, the judge will determine sentencing. I don't think that will happen tonight. If a verdict comes in tonight, I do not think that we will see a sentencing this evening. Law Nerds, I have been streaming for over 10 hours. So I'm going to take a break. I will be in the chat on the other stream, and then I will send you a Law Nerd app notification, lawnerdapp.com. I will send you a Law Nerd app notification. Not that. When we have a verdict tonight. I think it's probably when we have a verdict tonight. I really think we will have a verdict tonight. So I will send you a notification. I will be in the chat. Keep an eye on the chat. It will be members only for a while. So members, we can chat and then we can give our mods a break and then rally everybody when we hear that they have a verdict. It's going to happen, I think, tonight. When it will happen, we will see. They've only been out, 35 minutes. So they're eating dinner, picking a 4-person and talking. And I think there's things in this case to talk about because there is an affirmative defense. So I imagine they will be chatting for a little bit. Okay, Donnie said this is the book deal. Donnie B in the chat. We're going out on this one. Donnie B said, How to Talk About Women in 2024 by Owens. There's the book deal, y'all. That's what it is. That's what it is. Oh, all right. No, there was one very practical question. We're going to answer this one too. Steph said, are there any specific rules for the party's lawyers, defendant during verdict watch? Defendant will go back into lockup and hopefully should get dinner. The attorneys will have to give their cell phone, and generally the court will tell them how close to stay, within 5 minutes, within 10 minutes, things like that. So that we will see that. So generally the court will communicate that to them. I will end the poll before we go, and then we'll start a new poll over on the other stream as well. Danielle, as I'm saying, last super chat, Danielle's like, no, one more. Thank you, Danielle. EDB, my favorite YouTuber. Thanks for all you do. Also, this judge should be elected to the Florida Supreme Court, in my opinion. But then we would miss him in trial courts. See, there is so much impact of a good judge in trial courts. It can really help. It really helps humanize the judicial system and judges. I think this was a a great judge to watch. Becky, we'll redirect to the other stream. It'll be up on the channel, so don't worry. It will redirect the chat over there. Please show the counter. All right. One more time. All right, one more time. One more time with the counter. And don't worry, we'll check back in with it in a bit. I promise. One more peek to the counter. And again, I appreciate you. Team Baker appreciates you. Mods, thank you so much. I know this has been a heavy and long trial. We're gonna do some food court after this. We're gonna need to cover some Bravo drama. We're gonna need to do some of that. So we'll need to do some of that. So thank you, law nerds. We'll see. Will we get it tonight? I don't know. What will happen first? 800K or the verdict? Honestly, I think the verdict. I don't mean to be self-deprecating, but I think the verdict's going to come in pretty quickly on this one. So we'll see. But maybe they'll both just happen tonight. Emily, it's time to take a break from being on screen, turn off the light for a minute, and get ready for the rest of Verdict Watch. Law nerd, don't forget, we're on... We're on Verdict Watch. I will let you know in the app. Don't forget to download it so you're kept in the loop. And if you just need to keep an eye on the chat, that's why we're opening up that other stream so you can just monitor the chat. We will pin a comment as soon as there's a verdict, and we will go live as soon as we need to. So have a good night around the internet. I will see you, I'll see you when there's a verdict. Law nerds, you're the best community on the internet. Thank you. It is an absolute pleasure and a delight to be here with you for live trials. And I appreciate you guys supporting me so I can do this. Your support is why Team Baker is here doing this, and we love it, and I appreciate you. You guys, I'll probably see you later tonight.
You can stay up to date with everything I'm covering and fast notifications on our free iOS and Android app at lawnerdapp.com, or search the App Store for Law Nerd. You can also follow me around social media, and don't forget to check out my podcast, The Emily Show, with quick bits dropping every Monday, summarizing everything I do here on the live streams on Tuesday and Thursday for when you just have time for the quick bits. Thanks for being a law nerd.